Hey, J-Bo Nation! Shaming of Jay. He's not a dopey dumb bitch. He gets laid. The court jester. The court DJ. It's time to dive into the case. To the case. Good morning. Good morning. Wow, she didn't make it. She didn't make it. She was trying to make it out before we went live.
So close.
You saw those super quick moves, though, man. She's like a ninja yes. Girl. So I saw you were enjoying some Olympics this weekend, my friend.
I was. I don't follow any of the sports. I don't. Shannon's a huge Olympics fan. Her mom used to tape it. Her mom is into all of it. So Shannon watches it all. Big into gymnastics. Big into tennis. Yeah. But so I just I don't. Peacock apparently has the NFL Red Zone version of it. I don't have that. Right. I just have I switch between NBC and USA and just kind of check out what's going on.
Yeah, it was Allie, of course, is a big gymnastics fan, so we were definitely checking out some gymnastics and that badminton.
Badminton's amazing. I love it. And ping pong. I was the US dude made it to this is the first time he won a match. Now he's going to round 32. I have to wait till fucking Wednesday, but ping pong and badminton are awesome. I love
it. That badminton, man, the speed was insane. It was the reaction shit is incredible to me, man. Like you would put something up there and then I wasn't even kidding. I'm the badminton was breathtaking. I'd never seen it played. So it was it blew my mind that just the response, the reaction time with these players is crazy, dude.
Yeah.
It's crazy. And yeah, your little clip of Gump with the ping pong is pretty spot on. Man.
How do you not think of that? If you haven't seen it, you don't think of that. It's always got to be Forrest.
Oh yeah. So Scout left for a little vacation. Her first friendcation.
Ooh.
Obviously with their family, but yeah, she was a little nervous.
Where'd you go?
Down to Florida, nice. I think around Bradenton area. I think is where they went. So yeah. So she left early this morning, and she's gone. I already miss her. It was very sweet yesterday. She was I'm gonna miss. She was kind of crying, and not kind of. She was actually crying. She was I was yeah, I guess this is the first time that because I've had to travel. Allie's had to travel, but I don't think she's ever traveled without us or her sister going to family. You know what I mean? This is kind of where there's no family. So yeah, it's a big deal. So she's hopefully she's gonna have a wonderful time. So, but I already miss her. I miss my little love bug.
Sure.
So what else good, man? Anything good?
Well, funny thing this morning, I walk in. You guys like the story. I go to the food store because I go fucking when it opens. I'm not going there when there's a lot of people. Go there. We need some cold cuts, as we call it here. I don't know. Other people call it. They call it deli meat.
Delis.
I walk up to the counter and I'm like, oh look, SB Genoa salami. It's on sale for $6.99, which is a good price. And I'm like,
that is good.
Which is SB stands for I find out after, but store brand. However, I walk up there full breath and confidence and say, I'd like a pound of your Starbucks Genoa salami. And the guy's like, Starbucks? I'm like, oh, wow. Shit. I'm like, oh, the Stop and Shop. So yeah, that was
my lord,
Starbucks Genoa salami.
Listen, that's the power of marketing. I mean, Starbucks is clearly living in your mind rent free.
What else could SB be?
Apparently store bought.
Yeah, store brand apparently. So,
hey, in your defense, dude, I probably would have thought it was Starbucks too. I'm like, oh look, these motherfuckers are making coffee now, or these guys are making salami now. Yeah,
caffeine-infused salami.
That's outrageous. Yeah. Well, how is it though? How was the store-bought stuff?
Well, I haven't tried it yet. I'll have it for lunch probably. It's usually it's not as good as Boar's Head, but if it's on Boar's Head could be $11 to $12 a pound.
Oh,
and if I can
crazy.
if I can get this, if it's a little less, not as good, but I'll still take it. So
Yeah, no, Boar's
uh,
Head is like outrageous. Like the Jewels, they switched over about, I want to say 2 years ago. Like Boar's Head like invaded and basically knocked out everything else. I mean, they have like Land O'Lakes cheeses and stuff like that, but for the most part, it's all Boar's Head. And I'm like, I was like, because we've been shopping at the same Jewel forever. I'm like, what are y'all doing, man? You're for like, what is this like a meat monopoly here? Like, this is like twice as much as I was paying for like Genoa salami. I like a nice shaved Crocus ham. I'm like, what is going on here, dude? So they were like, yeah, so they signed a contract with them. It's really good. It's really good deli meat,
it
but
is.
it's also all right. I see movement.
Yeah, and I'll tell you this about this trial. As you guys know, I post clips. That's what other than following the Olympics, I was posting clips of the trial. It's just interesting. Some of the, I thought us here in the chat, most of the people in the chat, although we've had differing opinions, which we love and people are respectful. But I posted a clip of the state and how I just said I thought it was outrageous the way that they came at Ashely on the stand, and people were like, I was shocked. TikTok, I posted everywhere. TikTok especially and Twitter, people coming at me. It's crocodile tears,
Oh
and I'm
yeah.
like, tons of people. I'm like, wow, was I like? First, I'm like, am I being like, did she like fool me? Like, I thought she was legit, but then, there's two states of thought that I've noticed in my comments. It's one, she wasn't abused, which I don't even have time for. Like, if you don't think that shit that we saw wasn't abuse, I don't know what to tell you. But
Right.
then there's this thought, which is she was abused, but that doesn't give her free reign to murder someone. Like, that doesn't give her the ability to just murder someone, which is more of an argument as far as you can't just if like walk up to your abuser in the street a week later and shoot him in the head. Like, you can't do that, right?
Right.
Obviously.
Right.
So, but my thought is about this trial, and I thought this just about Karen Reed too, about reasonable doubt. Like, has the state, for the people who think that there was abuse, but this was murder, because has the state proved to you beyond a reasonable doubt, first of all, how it happened? Like, you don't think there's a chance after all the stuff that they brought up about the abuse? You don't think there's any chance beyond a reasonable doubt that maybe he did do something in that time? Because the state hasn't proved to me. Like, I'm still questioning, like, in my head, trying to figure out how the shooting happened. But you're telling me beyond a reasonable doubt, you don't think there's any way that he did anything that made her fear her life? To me, that seems like a stretch, but I know some people think that they have done that, but I don't know, man.
Yeah, no, I agree completely. I think that anybody who's paying attention, strict attention to this case, anybody who has a true understanding of domestic violence and what it entails, it's not just beatings, and it's I was getting the same thing. I had the same essentially we had the same tweet. I didn't make a video of it. But I just put up a tweet and, it got a lot of traction and, I was getting the same thing. And I'm like, look, I'm sorry, but if anybody in our chat or anybody out there on Replay Crew, if you could tell me of a situation where you're with somebody that you're either in love with or in a relationship with, and they've fired a weapon into the ceiling of the house of the room that you're standing in, and you don't think that that's terrifying, and you don't think that alone, like, not even taking into account the fact that he punches her dog in the face so hard that he knocks the dog out, or throws a weapon, I don't care if it's at her or her direction, so hard that it busts through the drywall, driving like a lunatic where he's in control of the car, veering off the road, nearly missing tree, like, all that stuff is true. Like, that isn't stuff. If you don't think that this woman is sitting there thinking, at what point is this dude actually gonna fucking snap? Like, I can't help you. Then you're in denial. This is not Johnny Depp versus Amber Heard. I'm so sick
Oh,
of
I'm
people
so sick of those comments
comparing this
too,
to that
man.
case. It's there. Like, every single domestic violence case is different. Like every case is different. Like, I cannot stand when people are saying, well, what about, like, comparisons to Karen Reed? Well, like, what about the I'm like, what are you? I'm like, Karen Reed doesn't have anything to do with this. Like, why are you even bringing up the comparison? It's like one has nothing to do with the other, you know? So, yeah, no, I'm with you, man, completely. Like, and people are absolutely allowed to have their own opinions, and I'm
Yeah, absolutely. As long as they're
all
respectful, I
about it.
don't. That's just my personal opinion. Is the state has like I thought I could have sworn, you guys correct me if I'm wrong, on redirect on the medical examiner, the defense got him to say the shot was from the front. I could have sworn, but they didn't have like a. To me, this is a case where you should have like some sort of forensic, like a Dr. Kinsey, where you're like, this is where he was at, and this is how it came. Like I didn't get that from the medical examiner, and
No,
maybe like I need a visual. I need to see like, and I didn't get that. I
no,
just
no, yeah, we didn't get that. Like they really gave no kind of like, or had their ME give any kind of even a educated guess as to how he was shot. Now, more came out, that bladed stance that they kept talking about, is like, just think of blast or a grass blade. That's the concept, that you're making yourself thinner,
mm,
right? That's why they call it like a bladed position, which would
mhm,
explain the shot in the side, going
right.
through the side and the side. If he's in a bladed position, and I mean, which I don't know, man. Like, so we have a pretty huge ruling coming up this morning.
Yeah, that was
Uh,
interesting, by the way, Bob. Did you like? It wasn't even like he said, "I reserve my decision." It was just kind of like, it seemed like he waited. By the way, I don't know if you just saw it, but Taylor has that circle that the gentleman went over, the expert went over. I forget what it was called. He has it there, so clearly he thinks at least there's a chance he's. I think that's so weird that like this guy's out of town, he's in a hotel, so then the defense has to like pay and just hope that he's going to allow this, Bob. Like, is that like I thought that was.
yeah, I
I
mean,
mean, I understand that you need time, but I figured he would have said something.
yeah, me too. But I mean, he's kind of in that position where he doesn't have to say shit. He's the judge. But
Right.
yeah, that's why I was asking. I didn't know if, like, the doctor clearly lives in Florida, or I don't even know if he's a doctor. I know he's a former cop. I think he's got to have some kind of degree in it, because he was super insightful. Like that dude should be giving, like, just kind of domestic violence courses to everybody on the planet, because he just has a very clear understanding of how that really goes, the cycle of it, just the other ways that aren't physical, that you can abuse people. And I mean, he just had a very clear understanding of it, and is able to explain it in very, very simple terms, so that you can kind of think about it in relation to your own life or your own experiences, and just have an understanding, like, look, oh shit, it's like, man, did I ever do that? You sort of like, well, Jesus, you know
Yeah, dude,
especially.
I was saying in the chat, I was like, I probably I want to see if I could he put this, make a video like if we ever cover another domestic violence case before we go forward, put some of his points in, so just so people
100%.
have an understanding, because I bet you people might have. I don't know. It's surprising to me that there are a lot of antiquated thoughts about domestic violence, but there clearly are. So I thought his presentation was pretty great. So
Yeah, me too. And yeah, that Duluth wheel, I think there's some other wording in there, but like, it's the Duluth wheel, which is kind of like breaking down, because it'll have violent. There's a few wheels. Like, I was looking up the wheels. The Duluth violent, the one that we saw, was for non-violent. So other ways of abusing somebody that aren't violent, that don't constitute putting your hands on them. So yeah, I just thought it was really, and I've seen it, because I've argued it for years in divorce court. These other types of abuse, and it's just very, very difficult to get, like I'm talking judges, where you're trying to make this argument that what I'm telling you is real. Forget about the fact that there's no marks, that this is a pattern and a cycle of abuse that, like, ebbs and flows. And it's just like he said, it's like they'll pop off, they'll lose control, whether it be firing a gun in the ceiling, whether it be punching their loved one in the face, whatever the case may be. And then there's the massive realization that I've lost control, and I've hurt you, and what I did was wrong, and I'm sorry, and I'll never do it again. And, and that person who loves that other person wants, especially early on in the abuse cycle, you want to give that person the benefit of the doubt. You know, you're not trying, you know, it's like, oh, but then, and then it happens again. And then it happens again, you know, and you've got women that are out there that are strong enough to be like, dude, no, you hit me one time. That's all it took, you know, done, and stick to it. And then you've got women that aren't, you know, able, whether for various reasons, you know. So, but when they're stuck in there, man, it's devastating stuff. You're not hearing any
Gina,
sound, are you?
I don't. I could try. Let me see. No, I don't. Gina
Okay.
asks, so what do you say to all the DV victims that don't believe her? I say they have every right to their opinion, and I respect their opinion. You know, that's up to. But I see DV victims from both sides on my comments saying I absolutely been here. I've been through it. I know what she's like. Then I see, you know, other people say I'm a DV victim and this doesn't ring true to me. I've been through it. This is, you know, to me, I respect your opinions. I'm just giving my opinion on it. But as long as you're respectful in our chat, we welcome different
Totally.
opinions, and we're not trying to minimize at all. You know, that's just I'm just giving my opinion on that.
Yeah, me too. And my answer to that is that the things that we know that Doug admitted to in his deposition, that there's no question that these things happen, to me rise to a level. Because remember, this isn't about like I had people like confusing the issue, you know, and they're like, this isn't about if he attacked her and he was like choking her out, and then that this isn't like when you're like guys just being the knuckleheads that we are always like in a bar fight like type situation. You're like, oh, you got to hit me first. That way it's self-defense. For me, this is not like, this is an objectively reasonable standard in terms of, in her mind, whether she thought that her life was in serious peril. And I just don't know, if you're being intellectually honest, when you have a guy that over the course of these few years has fired, like I just, if that happened, if I had a client who had fired his handgun into the ceiling, the county that I practice in, that guy would have gone to jail, maybe even prison, without a finger being touched. That is insane to me. Like anybody who doesn't think that that's a big deal, like we just live in very different worlds. Just very like that is a terrifying prospect. And if you don't think that this woman at some point would be like, when is this dude gonna like kill me? Like when is he going to kill me? And if it's not at the time that she's finally made it clear to him that you're not moving in with me when we get down there, and like he's making the realization that he has finally lost her, like truly, that she's gonna pop off, or he's gonna pop off, and like I just, to me, in terms of what I know from the background. And again, you know, we got a more thorough explanation because we had the ability to watch the doctor speak on domestic violence and the other forms of it that this jury may not necessarily know exists. You know, I mean, people, unless you're taught it, you don't necessarily understand that there's so many different ways. Like I just thought that thing where he's like, yeah, you know, he's like, I'd much rather take a punch to the face than somebody calling me bald and ugly every day. You know, he's like that because that hurts me in a much different way that lasts. It lasts for a period of time much longer than if somebody physically strikes me. It's like that psychological abuse, just, you know, and it's all used to control. It's just coercively controlling the victim. So that's just how I feel about it. And in the light where, you know, I know.
All right. Good morning, everybody. We're back on the record in state. This is Ashely Benefield, 2020 CF 3014. Thank you for your patience as we've gotten started this morning.
All that action.
First thing, we had early this morning, a juror call in that
We
there
saw
was
you
some
like a
car
ninja.
trouble. Juror was running late. My understanding is all the jurors are here and they've been brought up. And then obviously I've had computer problems this morning. So we'll just get going.
But he's not
Anything you need to
ruling?
bring up before we resume with the defendant's case in chief?
Judge, the clerk notified me on Friday that we had not actually entered states 103 and 104. So I would like to go ahead and enter those. I don't know if the defense has an objection. We can do it in
Yeah,
our case
too late.
in
So
rebuttal
sad.
if we need to, but we did talk about them during testimony. I just didn't say the magic words.
I just don't know what 103 and 104 is.
I don't either.
Modeling picture and the mugshot.
Yeah.
Oh,
No
actually,
objection.
yes,
I do
we
object.
do have something to say about that.
All right, so you're just gonna save that until your rebuttal? Okay,
Yes, and then just to put on the course,
There's a discovery issue with respect to those two photographs. We were never provided them.
well, the mugshot.
All right. So I'm making a note that
Late objection
um,
to a late admission.
you have to have a Richardson hearing on that issue then.
Oh boy.
And also just to, for scheduling purposes, at some point, hopefully before, right at lunch, I would like to have a discussion about whether the court would allow the state to introduce evidence from Dr. Broder that we had previously talked about before. I just wanted to get a ruling from the court so I know whether to get him here or not.
Okay. I don't know what evidence it is, so I'll just wait for you to bring it up.
Okay.
Defense, any issues before we resume?
Yeah, can I have a ruling?
All right.
What is
State, you
happening?
ready?
Yes.
Did we miss
All right.
something?
You said ready.
Yes,
All
sir.
right, I just want to make sure. Are you feeling all right?
Yeah, picked up a little cold, but
I
I'm
was going
good.
to say he sounds a
here.
little more gravelly
So,
than
I
he
understand.
usually does.
Okay.
Oh boy.
Probably
Hope
got
it's not the
vid.
vid.
He's in there super spreading. Brooklyn Janet, $5 holla. Husband was evil, inhuman that would punch a dog unconscious. It's horrendous. She was abused. She had to defend herself by voting not guilty. I agree, obviously, Brooklyn.
Hey, pause it a sec,
$5
babe.
holla.
So I'm still like half asleep in my mind,
Aw,
but
she's sleeping. She makes the sleeps.
but I just want to say, no
sleepy.
matter, yeah, sleepy, no matter what you think, like even just assuming for the purposes of this comment that I'm going to make that Ashely is guilty. The cross-examination of her was based on a line of questioning that with failed premises, like things that actually literally don't make sense and have no relation to what she's trying to establish. By trying to establish she's not a victim because she's smiling in this picture or because, all those questions. So it's the same thing like we made an issue with in the chat when somebody, I can't remember what the comment was, but you were like, all right, you're getting out. And that's like, all right, fine. You can disagree. You can think that Ashely might be lying, but you can't do it on a premise that's based on victim blaming. You have to do it on a valid premise. And the fact that the prosecutor like did all that and that the judge, it's like everyone who is a victim's watching is like, oh shit, that's what I'm going to go through. And legally speaking, because of what everything this expert is, they're trying to get in through this expert, the questioning of the prosecution did not go to anything they were actually trying to establish, because those two things don't mean, 1 + 1 is 4 when doing it that way, if I'm making any sense, because I am still.
You are. You made
You are.
complete sense. So what do you? So did you get to watch on replay, Clue, the proffer of this expert?
No, I didn't. I watched, I think, a
Well,
little
the
bit
only
of
reason
it
I'm asking
first
is
for that legal argument you were telling me,
to see
right?
if Jay and I missed, like he gave some kind of
I
ruling.
don't think I went back.
Like, let us know in the chat if we missed that ruling on Friday. I was under the impression this was getting kicked to the morning and he'd give a ruling. Like what it seems to me is that he's going to call them and that they're going to take it as it comes.
I think you're right. He's got his little wheel there to Taylor. I think he's
all right. You guys ready to rock and roll? And good morning, beautiful humans. Thank you for being with us.
Yes.
We really, really appreciate it. We got 303 in the chat right now. Best chat in the land. Up and at it. Happy
Don't forget
Monday.
to minimize and click thumbs up. I don't know how many likes you
Yes,
have, but
indeed. Yes, indeed. And thank you, LS, $2. If you punch a dog, you're a bad dude. Say less. No doubt. I could not agree more. I mean, that just goes to like a mental state. Like,
Are there texts where he admitted it? Did I
Yes.
miss that?
Yes, he absolutely admits it.
So I don't
and his
understand.
deposition.
They let that in?
Yep. Mhm.
What the hell? When did this happen?
When you were
During
sleeping.
her direct examination.
Oh God, I should have rewatched that. I was so worked up
Jeez.
by the cross. I never even went back and
Allie. All right, let's go.
I wait, but the reason I was asking that is because the prosecution's been like almost denying
you all
it
can have a
since
seat.
day
Welcome
one.
back,
It's so
everybody. Good-
freaking weird.
Good
Oh,
Are
it's
people
in-
going to sit there and say
I
that
don't
she
know
like
who
dyed
had
her
car
hair
trouble,
gray
but I hope
so that
everything
you
worked
can
out.
make yourself
You've had
look more
time to
sympathetic?
kind of
She
calm
dyed
down
her
from
hair
that.
to make herself look more
Wait,
So we're gonna
do
get
you
started,
think that
and
people
we
out
left
there
on
wouldn't say
Friday.
that
Ashley
shit?
was presenting it. Sorry,
Why?
Chris was
She
presenting
dyed
it.
her
look at her
hair.
gray
I
hair
do need to ask you though. before
Where's
we get
her hair
started,
gray?
we just had a couple of days off.
on her
Did
crown of her
anybody
head.
discuss the case
Oh
amongst
man,
yourself in any way?
damn, watching
Did anybody
looking for
discuss
gray
the
hairs?
case with anyone outside of
Well,
this
they just
jury?
showed her.
Did anyone do any
I see it.
research or watch any coverage at all about the people, places, things, or legal topics we've heard anything about?
No, sir.
All right, everybody says no.
Boston
Mr. Taylor,
JD.
call your
Love
next
it.
witness.
You're the
Thank
best.
you, Your Honor. Defense calls Bruce Ferris.
Here we go.
Aw, you had a little DD baby, Shannon. Thanks for being an OG, girl. We love you. Let's go. Let's go. Sorry, babe.
I
I know
really
Jay. I know Jay loved it.
did get up was to hear be on here for some legal stuff about this argument this morning.
I know. No, surprising.
And I could have listened to this from bed.
Wow.
Jury is gonna love this dude.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Greeny, we all are confused. There wasn't a ruling.
It could have been while his computer wasn't working before they turned the cameras on.
Morning, sir.
Or
My name is Judge Whyte.
potentially he
Presiding
gave them a
over this
written
case.
ruling.
Just have
I
a
don't know.
seat, make yourself comfortable in that chair. Get yourself about 12 to 15 inches from that microphone. It's pointed straight up, but it does adjust down, left, right, up, down, whatever you need. And you just speak directly, a loud, clear voice into the microphone. It should pick up everything.
I will.
Yeah, thanks, Donna. Appreciate you. Extra coffee for Allie having to wake up to bubbly Bob, no doubt. What a nightmare.
Good morning.
Bubbly Bob, is that what they
Will you tell
said?
us your
That is
full
the
name?
worst.
Spell your last name, please.
Bruce Eric
I'm still
Ferris,
tired.
last name
Thank
Ferris.
you, Donna.
Thank you.
Mr. Ferris, what type of work do you do?
I'm a licensed mental health counselor.
And how long have you held that position?
I've been doing that for 14 years. I've counseled individuals I just recently counted 1,000 clients, not including group work I've done. I also am a consultant in domestic violence and testify as an expert court witness in domestic violence.
Let's talk about your education for a minute.
Okay.
Please enlighten us.
I have a Bachelor of Science degree in civil engineering. I graduated from the Police Academy in Gainesville, Florida, and I have a master's degree in mental health counseling.
And do you have any specialized education or training in a specific field?
Yes. Been to a lot of training seminars and certifications and various conferences. In my curriculum vitae, I'll call it a CV, my resume. There's about 100 items listed of trainings that I've been to over the years.
For what specific field?
That's what she rolls out of bed
In
looking
domestic
like every
violence
day.
and mental health and trauma to children and trauma in general. And I could go on, but that's the general focus of all my work.
Let's talk about your work experience for a moment.
Oh, okay.
Tell us about it, please.
So as a counselor now, my day is spent seeing individual
I would
clients.
agree.
Um,
This is awesome.
I specialize, like I mentioned, in domestic violence victimization, both men and women. I also see generalized mental health issues and typical things that a counselor would do, but I have a focus on domestic violence and family problems. I also counsel adolescent boys, most of which are going through
Morning,
the
Caitlin.
foster care system or adoption or divorce of their parents, et cetera.
All right, and what position did you hold prior to that?
I was a police officer in Gainesville, Florida, for 20 years. I graduated the police academy in 1993, got sworn in 94, and I retired in 2013. The last 10 years of that career,
You know what?
I was a
I think I'm gonna go listen
detective,
to Ashley's
uniquely
testimony while you
running. I
guys
was the
do
lead
this.
detective of what's called the Domestic Violence Unit of the Investigations Bureau
Thank you
at the
for that,
Gainesville
Emily.
Police Department. Over the course of that time, when I retired, I looked back and did a little search, and I
hear me,
had
babe?
arrested or filed charges or got warrants
What'd you say,
on
babe?
500
Pause it a sec.
different abusers over those years.
I think what I'm going to do is listen on the 1.5, 1.7 to the direct of Ashley while this is going on, and then I'll come back. But text me when he's like you're on another witness.
That sounds like a perpetual state of behindedness.
I know, but I feel like
All right.
or but
Hey,
you
you
did
do
say
you.
he actually interviewed her, right? So he is going to
Yeah,
get
he said between 15 and 20 hours. In the state, when they were asking him how he reached his conclusion, was talking about basically the documents he was presented with, which I think he listed off 13 different things that
including
he
the
used.
deposition, by the way, because I
Right,
was
which was the first thing that he said, because I was like, wait, did he, like, I was asking in the chat, I'm like, did he say the DEP? And Allie's like, yeah, that was the first thing he said. So thank you
Right.
for that. I
I
appreciate that.
but
Um,
I fell asleep shortly after.
all right, I
Shortly after
vote
that
you
part.
stay with us, but
All right. Well, I just thought it could take 45 minutes of explaining domestic violence in general before we got to Ashley.
yeah, that's true. I mean, I think that's going to be a bulk of the testimony.
Is not about Ashley,
Why
but
to let
just
him go. Yeah. Oh, but what I was saying is that the state was, giving this guy shit because he basically said he didn't base his opinion, in terms of what he came up, that she was abused, based on the interview with her as much as everything else that he was reading about that happened to her. And the state was like, oh, you didn't even form your opinion based on what she was saying to you. So it was like, I don't know.
they
All
can't
right.
have their cake and eat it too. Like,
Yeah, I think that was
didn't you
actually
want him
said.
to rely on other information so she couldn't be malingering?
I
But
think somebody actually said something to the effect of you can't have your cake and eat it too. I don't know. All right, let's go. You do you though. We'll miss you. Just
well,
hurry back.
text me once he starts talking about her specifically.
Okay.
Mr. Ferris, give us an idea of your professional credentials. Lightly.
Sure. I have, I'm licensed with the state of Florida, like I mentioned, as an LMHC or licensed mental health counselor. I have to keep up with education, et cetera, keep my license active. I'm certified as a batter's
Shan.
intervention program facilitator. In case anyone doesn't know it, batter's intervention, which I'll refer to as BIP, is a 6-month class given to abusers who are found guilty or on probation or could be part of their injunction order. And it's a curriculum based upon the Duluth Power and Control Wheel. And it's a psychosexual type, not sexual. It's a type of therapy that involves some counseling and some ownership and learning. And also was a certified police officer, I mentioned. I also have certification as a domestic violence danger assessment and level of danger scoring system developed by Jackie Campbell out of Johns Hopkins University. And I also have a certification as adoption competency training, mental health for mental health professionals out of Rutgers University. I'll
All right,
stop there.
Mr. Ferris. And briefly, have you been the recipient of various awards and recognition?
Yeah, I have.
Just a brief idea.
Okay. The
You guys
Alachua
seem
County Board
nervous,
of Commissioners had nominated
Just
me to
go.
Governor DeSantis
Yeah.
to be part of the Children's Trust Fund of Alachua County. I received the 31st Annual Martha Barnes Award for outstanding achievement in the prevention of domestic violence against women. I had recognition for valuable contributions in what's called crisis intervention team. I train officers how to de-escalate confrontations with citizens. I did receive the 2010 Distinguished Victim Service Award for recognition of outstanding contributions to crime victims for National Crime Victims Week by State Attorney General Pam Bondi awarded that to me, and Governor Scott at the time was there for the presentation.
Mr. Ferris,
I'll stop there. There's a few more.
have you been recognized as an expert on domestic violence in various courts of the state of Florida before?
I have.
Approximately how many?
So I've been involved in 60 some cases as either consultant or expert witness. 50 of those I've been recognized by the judiciary as an expert in domestic violence, mental health, batter's intervention, effects of DV on children.
All right, and when you say you've appeared before approximately 60 times as an expert witness, was it for any particular side in a dispute? That is to say, for example, in a criminal case, was it always for the prosecution, always for the defense?
But both. I worked for the state attorney's office and worked for defense, and a majority of my cases have been in civil court, though I have worked in criminal court also.
Would you, Mr. Ferris, tell the ladies and gentlemen of the jury what another definition of domestic violence is?
Well, so there's the criminal statutes of domestic violence, which are typically, we all know it's battery, ag battery, assault, ag assault, false imprisonment, sexual abuse, et cetera, person crimes involving a family or household member against each other. And that has another definition, that's spouses or family members living together, or it could be a couple that had a child together that have never lived together. Doesn't include, let's say, cousins who've never lived together and aren't intimate in any way. But through my experience, I've realized that there's a greater, that's umbrella, and that has to do with power and control. The abuser needs to control their victim. Now they'll use the criminal things, hitting, et cetera, all those things. But in a greater sense, there's also this, I referenced it earlier, the Duluth Power and Control Wheel that DCF's accepted for the BIP class. I'd like to explain the Power and Control Wheel, if that's okay.
In fact, with the court's permission, we can perhaps have the screen come down and the lights dim. Mr. Ferris, you have a laser pointer in front of you. The little star in red will provide you with
Okay.
the dot.
Judge, may I stand here and pay attention to the mic as I talk?
Any objection?
Okay.
Yeah, Shannon L.
So as I mentioned, there's the criminal definition,
Was
and
there a question? Objection. Was there a question?
Go ahead with the question.
Yes. What is it that's on the
Right.
screen?
so what
Mr. Ferris?
okay, so
Mr. Ferris,
yes,
would you please tell us what is on the screen?
I will. So this is what's referred to as the Duluth Power and Control Wheel. And so there's physical violence and sexual violence. Those are the criminal things I talked about. And then there's these power and control aspects. And the nature of the power and control is repetitive. It's a way to get control. So up at, we'll call it 1 o'clock, using intimidation, making her afraid by using looks, actions, gestures, smashing things, destroying her property, abusing pets, and displaying weapons would be an aspect of intimidating. your partner again to gain control. Using emotional abuse, putting her down, making her feel bad about herself, calling her names, making her think she's crazy, playing mind games, humiliating her, making her feel guilty. Then isolation, controlling what she does, who she sees and talks to, what she reads, where she goes, limiting her outside involvement, using jealousy to justify actions. Then a big one that I see often is minimizing, denying, and blaming, making light of the abuse, not taking her concern seriously, saying abuse didn't happen, shifting responsibility for the behavior,
Back to the
saying
wheel.
she caused it.
Wheel up.
Another one is using children, making her feel guilty about the children, using the children to relay messages, using visitation to harass her, threatening to take the children away, male privilege, testing, treating her like a servant, making all the big decisions, acting like the master of the castle, being the one to define men's and women's roles, using economic abuse, preventing her from getting or keeping a job, making her ask for money, giving her an allowance, making her ask for money, not letting her know or have access to family income. And the last one is coercion and threats, making her carrying out threats to do something to hurt her, threatening to leave her, saying that he'll commit suicide, reporting her to the government, making her drop charges, making her do illegal things.
Now, I have a couple of questions I'd like to ask you about that wheel that you demonstrated for us. Is this something that you created?
No, this was created by, up in Duluth, Minnesota, there was a domestic violence advocacy group and also researchers, and they looked through police reports, they interviewed victims of domestic violence who come through the shelter, and through a period of time, they developed these 8 items and created the power and control wheel. This wheel is used around the country and actually internationally. Like I said, it's the base curriculum for the Banter and Prevention Program class I talked about, and it's taught quite readily all across America and by use by domestic violence shelters, et cetera.
How long has this wheel, if you will, been in existence?
Yeah, probably, I'm guessing 30 years or so, could be a little more.
Are there any agencies within the state of Florida that predicate their decisions upon the Duluth Power Wheel?
Yeah, the DCF accepted the power and control wheel for the curriculum for the BIP class.
That's the Florida Department of Children's and Families.
They were the ones who were controlling the BIP class when it started up. Also, a lot of federal money, domestic, against women act, things like that have always promoted the power and control wheel bill, and also, giving out grants and education money.
Are the majority of abusers male or female?
Majority are male, but there's certainly a percentage that are female. I'd say it's at least 2/3 male at the least. And in my practice, I have male victims.
And what about on the other end, the victims of domestic violence? What's the percentage of males and female?
So again, there's some different statistics. Somewhere between 2/3 and 3/4 are men, and
are men as victims of domestic violence?
2/3 to 3/4 abusers. So that on the other side of that, they're 1/3 to 25% male victims. And I just got a male victim this past week.
Okay, so look,
Okay, I'm done.
I want to make sure we're clear on this.
Sure.
You've told us that the percentage of abusers that are male is approximately 2/3, is that
At least
correct?
2/3. There's some statistics to make it actually higher.
Would you tell us, please, what percentage of domestic violence victims are female?
Somewhere between 2/3 to 3/4.
All right. Now, I want to ask you if you would educate us, Mr. Ferris, about whether or not there are common characteristics that abusers share.
And I certainly can do that, Mr. Cheller. Can I make one closing statement about the Duluth wheel? And
Sure.
Power and control. So I think it needs to be said, maybe I didn't say it, that the whole idea of the use of the wheel is to get compliance by the abuser with their victim. So they're looking to control them, and either they use those criminal, the battery, or they use emotional abuse or intimidation or these different techniques to try to control them. So the victim of domestic violence is placed with wanting the least harm to them. So they get into a compliance, I call it equilibrium type of status mode, where they seek to get along, to go along. They don't want to poke the bear. They don't want, they believe that this is certainly a danger to be involved with this person, their mate, their spouse, etc. So they comply. They get this compliance mode, and they can certainly appear to society as nothing's going on, but there actually is, and they're afraid to display that because of the retribution that might happen.
All right, so this wheel then is the product, if you will, of the science of domestic violence over the past 30
Right.
years.
And throughout my entire practice, the thousands of people that I've counseled and even the 500s I've arrested, I see this repetitively to be true.
All right. Now, would you please tell us,
Oh, I do. Thank you.
I need you to make sure you keep your voice up so that
Yes,
we
sir.
can hear you. Would you now tell us, Mr. Ferris, whether or not there are common characteristics that abusers share?
They can be anyone from all socio-economic stratas, and that's been my experience also. And I said, like I said earlier, predominance men, but also females.
What's the motivation for their behavior, abusers?
They want to control their partners. I find often an ownership type attitude. They want to control them.
How do they treat generally pets in the household?
Pets. So statistics have shown that abusers abuse pets well above average, more than average citizens would. And so I have two theories about that. One is that they're missing some empathy, or they tend to see things as objects. And so,
Object to
Sustained.
non-responsive.
okay. Can I explain why they abuse pets?
Yes.
So if a pet is belonged to the female or their partner, the victim.
Judge, I'm going to object.
Can you approach, please?
Man, he's doing all right, but I feel like he did so much better. Bob, you're muted. You're muted.
Yeah, I agree. I think
He's so nervous. Like he's not doing as good a job.
he crushed it Friday, and he's stumbling over his words a bit today. It's different being in front of the jury. That's the only explanation I can come up with. I mean, as long as he gets the information out,
Right. Yeah.
I mean, it's certainly not. But he was super confident Friday.
Yeah.
Like real educational. Like blew us all away. At least those of us that were willing to listen to what he was saying. So I thought, I saw a comment in the chat. I thought that Ashely filed a counter petition for dissolution after Doug had filed trying to get parenting time. So Dizzy, can you confirm that? I'm pretty sure that's what I heard them testify to, that when her lawyer was on, that she testified that they had filed the petition for dissolution in response to his pleading, seeking parenting time. I thought. So maybe I'm wrong, though.
And thanks for being here, folks. If you haven't hit that like, please hit it. Do you think, Bob, by the way, do you think they're going to rest today? Or
I think
I
so.
guess it depends on how many, if they have further witnesses, how many.
I mean, I think they will. I don't know how many else they can, like, who else they can put up there. Like, in terms
good
of,
question.
It's like you don't have anybody that was really, there. So you're not going to have any fact witnesses in terms of what happened. I don't know. Yeah, I was thinking, I think that they will rest today. I think that's in the cards, Jay. And then depending on how late it goes, closings in the morning, and then to jury or rebuttal.
Yeah, rebuttal. Yeah.
Yeah. I mean, I think the way it's going to line up for certain is that closing arguments will be tomorrow, like depending on whether or not the state has rebuttal. Yes, I am going to Delphi.
Mr. Ferris, would you describe for us what the term coercive control means in a domestic violence
Sure.
relationship?
So coercive control, acts of aggression, assault, threats and harm, punish, frighten the victims. And that fits in with creating fear, and it fits in with this whole continuum of power and control, a pattern that is developed to control the victim.
Do offenders always behave violently, or does the abusive behavior happen in cycles?
They don't always act violently in what common term of a battery or an assault. It can be accomplished just by threats and fear. And in terms of a cycle, there can be a violent or emotionally abusive state, and then a honeymoon side of state, and then it cycles back. In the field, we talk of a model of kind of like rain and sunshine. And,
all right, and let me ask you, Mr. Ferris, does the victim always appear to be afraid or act like they are afraid of the offender?
Definitely not. Oftentimes, the motivation is to hide the abuse from friends, family, law. There's lots of repercussions if it's disclosed. One could be fear that the oppressor, the abuser, the husband, the boyfriend, the wife, whoever is the abuser, will harm them. So they're very scared. The other is they might not even understand that they're victims of domestic violence. Quite often when I get clients, people don't know those definitions.
How common is it, Mr. Ferris, for a victim of domestic violence to smile and act happy in the company of the abuser?
Very much so, and also in terms of even in public or with family.
Why?
Because they're afraid. They found this least resistance. They're trying to not poke the bear, as we'll say, or we've all heard the term walking on eggshells. They're trying to avoid aggression by their partner because they've grown to believe that there's a threat here.
So could we characterize that as an appeasement?
Totally appeasement. It's something I see quite often. And
what
if I'm
is the victim trying to accomplish by engaging in the appeasement behavior?
not encourage him to be abusive to herself, or if there's children involved, she's putting up a front to again create a type of stasis or minimum amount of aggression. So they don't want to again poke the bear. They're afraid of the repercussions.
All right, now give us some insight into this, if you will. Does the introduction of a child change these dynamics at all?
Yes.
Tell us how and why, please.
Okay, so it definitely ups the ante, we'll speak.
Objection. I have the same objection as at the bench.
I'll overrule on this one.
So yes, definitely, if someone is single and they're being abused, certainly they want to incur least amount of abuse. But when a child's involved, now they're concerned, and if they have a strong maternal instinct, now they're concerned about their own safety and their child's safety. And abusers will use a child as a manipulation tool to try to get at the victim. So the victim, that's even a further degree of way to pacify. Oftentimes women will stay in marriages because they want to protect the child, even though it's detrimental to themselves.
A couple of questions about abusers, if I may. How do they generally rate on the scale of ability to charm and deceive others?
Quite highly. Those 8 years I taught domestic violence crimes, I got to know quite a few, and some were individual therapy clients also. Many of them, I used to say, have the gift of gab. They were very personable, friendly. Not all of them, but a large percent definitely were very much the charmer. They'll hide the abuse, and they use it as a strategy to influence or control their victims.
Is there a pattern? Excuse me. Is there a pattern, Mr. Ferris, of denying, rationalizing, minimizing, or blaming the victim in these relationships?
And I can say a very high percentage, well, I don't know, over 90%, I'd estimate, of all my cases involve minimizing, denying, blaming. In fact, on the power and control wheel, I guess it's gone. It's one of the 8 categories is minimizing, denying, and blaming. And it's all a technique that she made me hit her. I didn't really do it. It wasn't that bad. They're always trying to minimize and talk their way out of their being abusive.
Would you explain to the ladies and gentlemen of the jury, Mr. Ferris, is there a particular time in these relationships when violence is most likely against the victim?
Yes, very much. The most dangerous time statistically is when a woman or a victim of domestic violence is leaving their abuser, and if the abuser is there, there's a high fatality rate, high incident of danger to them. I've been trained in this and in my evaluation with John Hopkins' work. This is a really dangerous time. As advocates for domestic violence, we oftentimes have safety plans. Those plans, part of those plans, you never leave.
All right. I'd like to ask you, Mr. Ferris, if I may, a couple of hypothetical questions.
Certainly.
Involving the hypothetical abuser and a hypothetical victim. First, I'd like you to tell me, would the following acts be consistent with an abuser? And allow me to finish, and then you give your opinion.
I'm going to object to that.
All right. Do you want to approach?
Yes.
Did he just shush her?
It sounded like a shush in there. That really
It
sounded
sounded
like
like
a
a
shush her? It
Let's go
really
back.
sounded like a shush to me.
It really did. It really did. I want to see.
If you're speaking. First, I'd like you to tell me, would the following acts be consistent with an abuser? And allow me to finish, and then you give your opinion.
I'm going to object to that.
All right. Do you want to approach?
Yes.
I think he definitely shushed her.
It's definitely sounded
I feel like that was a shush. All right, let's bloop 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 bloop. bloop
Although if
bloop.
he really did shush, I feel like she would have said something.
Right. Why is this man shushing me?
Yeah, Your Honor.
Talk about coercive control.
Your Honor Gaffigan. This is outrageous.
Hot pocket.
A series of So, Mr. Ferris, I'm going to give you a series of hypotheticals, and I'd like you to tell us if it's consistent with abuse.
Yes, sir.
Shooting a gun in the kitchen of a home in an effort to intimidate the victim to stop speaking. Throwing the loaded gun at the victim. Cruelty to pets. Punching a dog in the face hard enough to knock the dog unconscious. Throwing a cat down the steps, placing a tracker on the victim's car, an illegal tracker, throwing things, breaking things, yelling, screaming, belittling, cursing, humiliating, declaring such statements as rid the earth, being in a murderous mood, kill all the bad people, take them out, being caught at night, peering into windows of the victim's home, violating a no contact order by sending a package, driving from South Carolina to Florida to be able to follow the victim, suicidal threats, if the victim leaves more than 30 years age difference, and finally, prior marital history whereby the prior wife explains how she was beat up on the honeymoon. Would that be consistent with abuse?
Absolutely. And not only absolutely, but those are checklist points right off the Duluth Power and Control wheel and right off my experience, they're stereotypical abuse techniques.
All right, and now my last question for you, Mr. Ferris, is I'm going to give you a hypothetical. And tell me if this would be consistent with someone who suffers from abuse. Sending texts that are conciliatory with friendly emojis, accompanying the abuser during child time sharing ventures, acting deferential and subservient in joint therapy sessions, but decisively different in individual sessions, fearful of the abuser finding out the victim described him as controlling, manipulative, and abusive, and being exposed to threats, intimidation, pushing, holding down, humiliating, cursing. Would that be consistent with a victim of domestic violence?
Without a doubt. These are, again, techniques of compliance, not wanting to poke the bear, walking on eggshells, trying to minimize harm to themselves and their children. They'll put up a front. They don't want anyone to know, and they don't want their abuser to be angry by them disclosing. So, yes.
Lastly, one other factor I neglected to mention, would a video of the abuser and the abused at a restaurant with the child and another adult, whereby they are all acting happy, be consistent as well?
Well, certainly, if you're asking, they're acting happy, is she still a victim of domestic violence? Definitely. And it also fits with this whole idea of appeasement. We have to remember that the domestic violence comes in layers through the years of events. So one incident.
Judge, I'm going to object to non-responsive.
Ooh.
So that behavior isn't just a spot image right then. What's going on inside her? Why is she acting that way? That's what I would ask clients. That's what we're looking for. And if it's truly a victim of domestic violence, she'll be in this appeasement mode to try to please him and not disclose the abuse to get along sort of description.
My final question, as it relates in general to domestic violence. Assume, hypothetically, there were several violent or semi-violent acts of domestic violence, and then there was a break in the chain of events for, let's say, as much as a year or two, and then it started up again. Does the victim remember, and is the victim affected by the earlier acts of abuse?
Without a doubt. I've got clients who tell me about
Sustained.
Yeah, just
so yes, definitely they don't forget the abuse that's occurred to them, trauma lasting. Adults remember childhood trauma, let alone something from several years ago. Like I say, layers of impacts of behavior.
Thank you very much. No further questions from Mr. Ferris.
Wait, that's it?
Cross.
Thank you, Judge.
So wait, hold on. Pause it a sec. He's never talking about like Ashely specifically.
No, but he gave hypotheticals that were exactly. Bob, you're muted. He gave hypotheticals that were exactly the same as what was went over with Ashely.
Right.
Okay,
It was literally everything that happened to Ashely, but it was in the form of a hypothetical.
Okay, but did he give an overall opinion? Like, you examined Ashely, and did you make a determination? Like nothing like that.
No. Mm-mm.
Maybe that's where they limited what he's allowed to testify to.
Yeah. I mean, well, I think that was the thing. Like, I think kind of by agreement, it was going to be done through hypotheticals, not relating to her, because he's not a like what you missed was
Psychologist.
the argument that it wasn't even that. It said he's not a battered spouse syndrome expert. He's a like overall domestic violence
I don't get
expert.
these.
So the distinction is lost on me as well, but it apparently exists in the mind of Judge Whyte, and maybe even the case law over. And because that's what I was telling you. We were
Oh, I
talking
started to
about
look it
Shreen.
up. When I started looking up that night, and I found even old cases in Florida where they were talking about domestic violence and experts in domestic violence in relation to battered spouse syndrome, but I didn't see the distinction in the law, but I didn't keep, it was like I didn't keep digging. But all right, let's go.
All right, let's go.
Good morning, Mr. Ferris.
Good morning.
Mr.
Okay.
I want to ask you give you some examples and ask you if this is consistent with a victim mentality.
Sure.
Oh Lord, she's about to set
Minimizing
herself
the
up.
abuse.
Yes.
Now you're asking me if the victim would minimize?
Yes. Like what I mean by that, and maybe I said it wrong, is like covering or taking blame for the abuse, covering for the abuser, taking blame,
Yes,
making excuses for him
definitely.
or her, I guess, but not reporting the abuse,
Right.
dropping charges if they were filed,
Yep.
not standing up for themselves,
Yes.
and not leaving.
Yes.
Okay. I'm going to put that wheel back up, and I want to talk to you about the pie sections each.
Sure.
Okay. Sorry, Judge. While she's fixing it, and I know you're familiar, and do you have a copy in front of you?
I
do
want-
too.
I want
do
right
too.
in front of me.
Okay. And so I want to talk first about the use of intimidation. Would you agree that if somebody, this says making her afraid by using looks, actions, gestures, smashing things, destroying things, her property. We talked about a break. If those things weren't occurring for years, would you, but had allegedly occurred prior to that, would you still consider that part of this dynamic
Yes.
if it's been a distance in time?
Yeah, I think the distance can be totally irrelevant.
And there's a section on here about the economic abuse.
Mhm.
Would you find that if a hypothetical victim was living on her own for several years, had no monetary dependence on the alleged abuser, and lived in her own home in another state for part of that, and there was no monetary connection, that would not apply to a relationship?
Could you restate the
Yes.
question?
So if in this wheel,
Right.
hypothetically, when I'm talking just about using economic abuse,
Right.
would you agree, would you say it still applies if the victim was living on her own for several years with family and independently sufficient economically?
Mhm.
No financial dependence on
Mhm.
the other person. Would you agree with me that economic abuse would not apply to that relationship?
From the scenario you give me, it doesn't sound like it would apply.
And for isolation, would you agree that if it's the same facts, living on her own for several years with family, so I know it says isolated from family, I think. living on her own with family and having some periods of no contact for over a year, and then being back in contact, but living separately and having her own cell phone, having her own car, having her own home. Would you agree with me that that's not a situation where there was isolation?
Well, you have to remember, under the isolation also comes jealousy and justifying actions. So in terms of isolating, not letting their partner or the victim go to work or see family, in that sense, what you're saying is true. But a component of isolation could also be extreme jealousy, possession, your mind, those sort of things.
And I didn't add those facts. You're adding those facts, right?
Well, under the power and control world, the last item, I don't know if you actually mentioned it, using jealousy to justify actions.
And if that was not a factor, that's not a factor. for my scenario.
Then isolation component may not be part of that, component for the scenario we're looking at, the couple we're looking at.
And why do you say may not? What part of that would apply?
Well, would not be.
Okay, thank you. Using the children.
Mhm.
If the hypothetical victim had custody of the child and attempted to terminate parental rights, and the hypothetical abuser had to seek court intervention to get the child,
Right.
would that be a factor in your consideration of whether children were being used? If she had sole control of the child.
So you're asking me if I could just reframe that the alleged abuser is not he's not using child against their alleged victim, then they're not necessarily guilty of using the children.
I'm not asking if it's guilty. I'm just asking if that would apply. We've talked about how these
Right.
things apply.
It may not apply. It would not apply. But I think if I could mention, you're missing the point of the power control wheel. This is about pattern of behavior.
I'm not missing
Okay.
it. I'm just asking hypothetical
Okay.
questions. How about the using a male privilege? If that hypothetical abuser was not having any control over her big decisions or did not live with her, so was not being the master of the castle, was not treating her like a servant because they lived separately, and was not defining their roles, in fact, was offering to purchase things, get her anything she needed, those kind of things. Would you agree with me if those were the facts of a relationship, male privilege would not apply?
No, I wouldn't agree with you.
Okay, can you elaborate?
Yeah, the men's roles, and when you say purchasing things, I would want to look into what is that a concept of what the role is. I'm the man, I purchase things, I control things for you, I decide what to get, etc. So that could be a male privilege issue.
Okay, and I understand that, and that was a poor fact scenario in mine. I think it kind of goes with the economic abuse, and what I should have asked is, if she's asking for, can you stop and get me boxes, or can you stop and get me tape, or can you stop and get me something else? And he is, yes, of course, and he does it. That's what I'm talking about, not
Pause it a second.
him telling her what she may have.
I have to say, I think the judge made a wrong decision with these hypotheticals, because now she's allowed to use a hypothetical that sounds a lot like the real situation, but he doesn't get to counter her with the actual real situation.
Well, it was the same hypothetical. The defense was doing the same thing. I mean, the hypotheticals they were using were exactly the fact pattern of this
Right,
case.
but what I'm saying is she's trying to really, by saying it's a hypothetical, and because they are actually treating it like a hypothetical, she's getting him to stay in this narrow scenario and not able to use the real facts to explain how they, apply, into her actual scenario, because he's supposed to be talking about a hypothetical. And in her
Right.
hypothetical, she's limiting it in a way that it's not.
Well, it's
limited.
certainly new territory. I'm sure that Taylor can get up and, now that she's delved into some different areas, he can give hypotheticals. Okay, well, that situation where he's buying boxes and picking up things that help her with moving, and it was at her request. What happens if these things preceded it? I mean, I'm sure he could do that. And he
Right.
probably will.
And by the way, I mean, how, like, if I'm the jury, I'm like, how dumb do you think we are? Yes, hypothetically. Thanks for saying hypothetically.
Mhm.
We all know what you're fucking talking about.
Right. I mean, at this point, the dog
I mean,
punching,
come
gun
on.
shooting, yeah, that shit's all been out there.
So in terms of him buying things for her that she's asking for, I wouldn't consider that to be domestic violence.
Okay, you would not.
No.
Okay. And so that's, other than that caveat, then male privilege wouldn't necessarily apply to the cycle that we're in, under my facts.
The facts are not complete enough for me to come to the conclusion.
Okay. How about minimizing, denying, and blaming? What, you said that was present in 90% of the cases.
Quite a bit, yes.
Right.
Mhm.
I think you said 90.
I did.
What if the hypothetical abuser says, I was wrong. I lost control. I shouldn't have done those things, and never says it was your fault you did those things. Would you then feel like that's not minimizing, denying, and blaming?
No, I wouldn't agree with that,
Okay.
because it could be that part of the strategy of minimizing could be that, I'm sorry, I didn't do it. That could just be minimizing.
I'm sorry no, not I didn't do it. I'm sorry I did it.
Right.
That's part of
That's still-
minimizing?
Yes.
Well, certainly not denying or blaming, right?
I would need more definitive
I guess
facts.
I need an explanation on if somebody takes responsibility for accusations against them, how
Right.
that is minimizing. Just to say, yes, you are correct, and I am sorry.
It could be a way to dialogue or to minimize what occurred by accepting blame for it, and that could be part of their scenario.
Could it also be the opposite?
Yes,
That person
it could
is
be.
taking credit, is taking responsibility for their actions.
Right, certainly it doesn't deny that it happened, that's for sure.
Right,
Okay.
and no blame being set forward if they say it's my fault.
Well, just because someone apologizes doesn't mean they weren't abusive.
I'm just talking about the factors on this wheel.
Right.
And whether or not, if somebody, under my hypothetical, admits to responsibility for the accused abuse and apologizes for that, whether or not you would consider that denying and blaming.
I would
That's a
need
different
more
scenario.
information on the relationship in the scenario to decide that.
Right. It's part of the
Is there a
cycle.
scenario? Okay.
This is what he needs, how he
Would
needs to be answering
you-
all of it.
How about using emotional abuse? If there's no accusations of any name calling or telling her what to wear, this hypothetical victim, in fact, she's comfortable enough to wear a sports bra and shorts around him. There's no
Around him,
displaying
that's not the
weapons.
issue.
I'm sorry. I'm looking at the wrong one. No evidence in their relationship of playing mind games or humiliating her or making her feel bad about herself. Would you agree with me that that might not be a factor?
What?
You gave me a discrete list, but emotional abuse also includes name calling,
Okay.
putting someone down, affecting them emotionally.
I guess, is there a scenario, Mr. Ferris, where you will agree with me that a relationship might not include emotional abuse? Because I don't know how to give you enough factors for you to say, no,
Yeah,
it may not.
I can't help you with that. I'm not asking the questions.
Oh, I was asking you one. If there was
I
a
know, I'm
scenario.
not, you are.
Would you take into account, based on, with these factors such as emotional abuse, economic abuse, male privilege, using children, all of these, if the alleged victim, or let me give you a scenario, she does not live with him. She's actually in another relationship, potentially engaged to a new man.
Okay,
She
He
tells
needs to
him
object.
that she does not want to be with him,
okay.
and she plans to move away without him.
That isn't,
Would those be factors that you would have to take into account when deciding if that relationship fit this power and control?
Well, that would be factors of the relationship, but I haven't heard you say anything about what their history is, what trauma she's experienced, what's going on with children in their lives, all sorts of other dimensions of their relationship.
I guess, so is there no scenario where there can be abuse in a relationship and then there no longer is abuse, where they are no longer in this wheel? Because the way you're answering your questions, that's the impression I'm getting.
So there, I have come across situations where there's an emotional abuse or a physical abuse, but it's not a pattern of behavior. It doesn't go on over a period of time in an attempt to control someone. So, if I may, if someone pushes down their girlfriend on a night out and he gets arrested for domestic violence because they live together, it's a battery, that's domestic violence. But that's it. He doesn't, she's not appeasing, she's not put an emotion, the whole power control dynamic isn't happening. That is domestic violence under criminal law, but it isn't domestic violence in the sense of a pattern or behavior to try to get the appeasement or this sort of consensus out of a victim where they're afraid to poke the bear, all the things I've already talked about. So if that answers your question.
It didn't. Is it your testimony that once a relationship has these power and control aspects, that is forever, even if there's no continued allegations of abuse for years, no continued allegations of abuse, no continued allegations of emotional abuse, never any allegations of sexual abuse? The parties are living apart. They're independently, I keep saying independently wealthy. That's not what I mean. Independent, economically independent. They are, the female is telling him she doesn't want to be with him and has moved on to a new relationship. Is there no scenario, in your opinion, where people can get off this power and control wheel, even if they were on it at some point in their relationship?
I think it's possible, but it's not likely, and it's not the typical thing that I see. Usually there's still a dynamic of emotional abuse.
So even under my facts,
Yes.
with no allegations of emotional abuse in years,
No.
it's your opinion that not good enough. They're still on this power
Well,
control.
all I can speak from my critical learning and studying this, and also my practice. And I have custody issue couples where they're domestic violence, and 10 years later, there's still abuse taking place, even though they're remarried and don't live together. So by example, I see continued abuse. Could there be a couple that don't? I'll say it's possible.
Thank you. I don't have anything else.
Redirect.
Nothing further, Your Honor.
Can this witness be released?
Yes, sir.
I don't know.
Yes, sir.
Wow.
You're released from your subpoena. You're free to go.
Could ask a
Why
couple of
wouldn't you have asked the
questions.
question? Have, in your experience, hypothetically, if a pattern of abuse has been going on for years, and then say a petition for dissolution is filed, which will include components of child custody, in your experience, have you seen that the abusers will act on their best behavior during that period of time as to why there may not be the continued abuse cycle going on during that period of time? I mean, like them pretending like people aren't typically acting on their best behavior when they're in the midst of litigation to dissolve their marriage and to figure out custody is absurd to me. I mean, we saw it all the time. I mean, are there people that aren't able to control it despite the fact there's litigation going on? Yes. In Alley, I was talking about last week, like here in most states, I think use it. Like we have our family wizard, so where all communications between the parties has to take place through our family wizard or the like, which is an app that allows for the court, the GAL, the lawyers, that everybody can access it so you can see. So people are clearly going to be acting on their best behavior in those chats. You're not going to see what you would see in personal chats, private chats between the two parties, because there's an understanding by everyone that we're on the grid. Like everybody's looking at what we're saying. So like those kind of factors just have a big impact on people's behavior while these things are pending in court. You know what I mean?
Right, for sure.
So
And I was
thank you
gonna-
for all your help.
I was going to say something that I would have asked him, but I forgot what it was. If I'll remember,
Okay.
I'll raise my little hand.
Tiny hand? You have a tiny hand on this? Hey.
Oh, I remember. Pause it. So I would have just wanted to point out that when people in the scenarios where people are living separate and apart based on the dynamic of an abuser, your experience with the dynamic of an abuser, is it easier for him to create I don't know, whatever they call like the instances where they're being on their best behavior, like a honeymoon period or whatever. Um, you know what I mean?
Yeah, I do.
So obviously it's easier to not have instances where you're like punching while you're still kind of basically in a period of trying to get that person back.
Right.
So there's not the same everyday interactions. There's not that relaxation. I've already got this person. I'm married to this person. We're back, for him to fall back into his normal patterns. And then I also just would have pointed out, a false sense of security, Haven said, right? But also it's just easier for him to control his behavior, because their interactions are limited, and he's still sort of wants to create that false sense of security and get her back. But also just I would have focused on the fact that the scenarios that the prosecution were giving him were, were incomplete. If I were to say to you in the most, you've got this most abusive relationship any of us can think of, put something together. And then I pick one day where they're at a family function and there's pictures, and I ask you, does this look, someone who goes to an event and they're smiling and they're having fun, does that involve any economic abuse? You know what I mean? Like I would have put some kind of scenario like that together.
Yeah.
Man, I wanted to keep listening. Like,
All right, Mr. Taylor, call your next witness.
Gina Torsia, Your Honor.
Judge, I think we're gonna have to approach whoever comes in first.
Thank you.
I was really getting down there. All right, we got
Bob,
some
I think you
bloopies.
can blip a little bit.
I got
pretty
some bloopies.
significantly.
I got some bloopies going. Bloop 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 bloop.
You solemnly swear or
She looks
affirm
ready.
the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
This way, please.
Actually, as she's sitting down, attorneys come back one more time.
Huh.
Bloop 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 bloop. Bloop 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 bloop.
You can adjust it up, down, left, right, however you need. And if you just speak in a loud, clear voice, we should hear you just fine.
Yes, Your Honor.
Good morning.
Good morning.
Would you tell us your full name, spell your last name, please?
Gina Torsia, Torchia.
Ms. Torsia, did you at one time work for an attorney by the name of Stephanie Murphy?
Yes, sir.
Back in June of 2018, would you have been employed under Ms. Murphy's guidance?
Yes, sir.
Do you recall exchanging an email with Detective Gillum on June 5th, 2018?
Yes, sir.
Did you have an opportunity to review it?
Yes, sir.
I'm going to pass to you, Ms. Torsia, what I've marked as defendant's exhibit number 25. And ask you if you can identify it for us.
Yes, sir.
What is it?
It's an email from Detective Gillum.
And does it include a response from you? Or is it a response to your initial email to him?
It's a response from my initial email to him.
Okay, and is it a true and accurate copy of your email to him and Detective Gillum's response.
Yes, sir.
Move to introduce it into evidence at this point, Your Honor, Defense Exhibit 25.
Same objection?
Yes.
Oh,
All right. now-
defendant exhibit 25 will be received.
Ms. Torcha, did you on this day send Detective Gillum a copy of the South Carolina domestic violence restraining order?
No, because we were not aware of one.
Okay. Does he send you a copy of the order?
He does send me a copy of the order, but there was never an order entered into the Charleston County Clerk's or the Sheriff's Office.
Yeah.
So we had no proof of an order at the time.
Would you please read for us, Ms. Torcha, Detective Gillum's response to you on Tuesday, June 5th, 2018,
Gina,
6:19 p.m.
I noticed something that you both need to be aware of, unless there's something I'm missing. If you read that section just before the judge's signature, it states the order will be in place 6 months of the day of the hearing, which was May.
Can you slow down just a little bit?
Oh, I'm so sorry. I'm a fast reader.
Okay.
Sorry about
slow
that.
down a little bit for us.
Evelyn Wood School, huh?
Where do you want me?
You're good.
Okay,
6 months of the.
Dude just dated himself.
which was
Zero chance
May,
he knows what the
November,
Evelyn
which
Wood School
was
is.
May, November
reading.
3rd.
Ms. Torcha,
Yes,
I'm sorry. Would you start over, please?
yes, sir. Gina, I noticed something that you both need to be aware of. Unless there's something I am missing. If you read that section just before the judge's signature, it states the order will be placed for 6 months of the day of the hearing, which was May, November 3rd, not November 27th, and sets it to expire May 3rd, which would be 6 months from November 3rd. Again, it's not something I would have made a physical arrest on, but the SAO will at some point make a filing decision. If I am reading something wrong here, let me know.
Okay, we can agree that SAO would be state attorney.
Yes, sir.
So lastly, Ms. Torcha, this is Detective Gillum telling you that the order was in effect, the stay away order,
Objection.
as of November 3rd, 2017, correct?
Objection.
Sustained.
Based on this, you were aware, blah, blah, blah.
This
Come on.
is Detective Gillum explaining to you.
Objection asked. and
Objection.
answered. She read the email.
Sustained.
No. Based on this,
Just
you
a
were
moment,
fully
Your Honor.
aware. That there was a order in place as of November 3rd, 2017. Whose office does she work for?
This is for sending.
Bay?
What? Doug's lawyer.
So this is about them knowing that when they sent her the letter.
Yeah. No, this is
Ms.
about
Torcha, let me pass you what I've marked as defendant's exhibit
Doug being
26.
aware that
Can I see it, please?
the order was in place, the mutual stay away or the injunctive was in place when he sent the box. All right, I'm gonna should have some blooping. Bloop, 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 bloop.
So, Ms. Torcha, let me pass this to you. I want to see if this refreshes your recollection as to whether or not you sent a copy of the South Carolina order to Detective Gillum.
Yes, sir. Yes, this is the order.
Yeah, without referring to it, my question is only, did you in fact, now that your recollection has been refreshed, send a copy of the order to Detective Gillum?
Yes, sir.
And then he responds to you a couple hours later with the email.
With, yes, and there's also
No further questions, Your Honor. Thank you, Mr. Bush.
All right, any cross?
Can you finish your answer, please?
yes. There's also a predicament where Detective Gillum, there was no order entered in to the clerk system in Charleston, and there was no order entered into the Charleston Sheriff's Office. So he had no bounds to make an arrest just based on this when it wasn't entered.
Sustained.
Ask to
further
disregard,
questions.
Your Honor.
Members of the jury, testimony regarding an opinions witness about violation of criminal law is inappropriate, and you should disregard those last comments.
No
Anything
further
else?
questions. Thank you.
That's sufficient. Thank you, Judge.
Redirect?
No.
Can the witness be released?
Yes.
Yes.
Thank you, Your Honor.
Thank you, ma'am. You're released from your subpoena.
Would you like to? Thank you.
Mr. Taylor?
Your Honor, I wonder if we could publish the exhibit that we have.
No.
Okay, I'm not gonna be able to go very far with that.
Yeah, Sarah, I agree. If you're a victim and she's prosecuting one of your cases, it can't, like this prosecution can't make you feel very warm and fuzzy, I wouldn't think.
Can you fast forward?
Okay, well,
You want blooping?
Well, I don't know, maybe.
facilities, you can use your phones if you need to send or receive text messages,
Oh,
emails,
done.
phone calls, anything like that. Please don't begin any sort of deliberation to. All right, members of the jury, I think it's a great time for our mid-morning break.
I think it's a little early
So I'm
for our
gonna
mid-morning
sit you
break
out.
there.
You have about
Judge.
10 minutes or
What
so.
I think, a little early.
Feel free to use the facilities. You can use your phones if you need to send or receive text messages,
Still have time,
emails,
right?
phone calls, anything like that. Please don't begin any sort of deliberations or discussions amongst yourselves about the case. Don't discuss the case with anybody outside the jury.
Let's see if you
But
can
don't
say
do
how
any
long,
research
man.
on the people, places,
I
things,
thought he
or
said
legal
10
topics
minutes.
we've heard anything
Oh, did he?
about.
Let's
And
just say you might be
10 minutes, 15 minutes, because I also want to give everybody else a break as well. So, see you back in a few minutes.
Is this for an argument or is it just sending him out for break? Like
I
he's
don't
probably
know.
doing
No,
something?
there's some sort of objection or whatever. All right, now fast forward it, Bay.
I think we're pretty close, bro, to being end of loop time.
Oh,
A police report that I haven't seen, but it's my understanding what it says is that Miss Benefield went physically to the telephone reporting unit of the Manatee County Sheriff's Office. I'm going to summarize, you can correct me. With
You had it right so far, good.
I would have so wanted to let him summarize before he gave him the thing so that we could have heard what the judge's thought was thus far. Like if I was the lawyer, I would have wanted to hear what the judge's
Alright, so-
recollection was.
this isn't marked. Is it? Did you seek to admit it as an exhibit or just testimony?
No, just testimony.
All right, so you expect the testimony would be from a deputy with the
I'm going to guess it's the
sheriff's
latter,
office
Afton.
that Miss Benefield went to the telephone reporting unit.
I have to assume it's just to win. She's got to know her
On
premises
December
are failed.
6, 2019,
Flawed.
Phone call.
that Miss Benefield wanted to document the fact that her estranged husband admitted in a text message that he placed a tracking device on her vehicle in the past, that she has observed him driving behind her on multiple occasions, which concerns her, and she wanted this information documented. She brought her vehicle to a local auto dealer, but a tracker could not be found. Due to the fact a tracking device was never observed on the vehicle, an information report was completed.
He's like, is that it? I mean, it's something. He's stalking her. How is he getting behind her if there's not a tracking and he's just following her?
All right, any objection?
The objection, Judge, is that anything contained in this report, which the nature of this report, according to it, is information. But anything contained in this report is hearsay other than
Goes
that
to
Ms.
state of mind.
Benefield physically appeared at TRU on December 6th, 2019, because everything that Mr. Deputy Lindsay wrote down was told to him by Ms. Benefield. And so the state would object to his being able to testify to anything other than she appeared at TRU on that date, which seems irrelevant, if you remember.
Proponent, defense?
Yes, so it clearly goes to her state of mind at the time, and it also corroborates her defense.
Right, an implication of making the story up. It
I
counters
do
that
not
too.
plan to ask the deputy to read it. I'm going to ask him if he took a report from Miss Benefield, what the date was, and whether or not it was her reporting about a tracker being placed on her vehicle. That's all.
And seeing her. What
And
about
that's
seeing?
hearsay, in the state's opinion, Judge, because it's self-serving hearsay.
Goes to state of
It's
mind.
actually hearsay within hearsay, I think. But if he wrote something and asking him what he wrote in a report about somebody else told him, but it's at least.
Doesn't
one
matter whether it's true or not. It goes for state of mind.
All right,
Jury
thank
can
you
give it
very
whatever
much.
weight they want.
The purported reason for the introduction of this testimony according to the defense, is to show the defendant's state of mind and that it corroborates her defense. Both of those sound to me like the introduction of this report to the sheriff's office regarding a tracker is being offered for the truth of the matter asserted that a tracker was placed.
No.
That would obviously make this hearsay. It's the introduction of an out-of-court statement to prove the truth of the matter asserted. That being that a tracker was placed on her vehicle, thereby corroborating the testimony that has already been provided. My notes are that it's already been testified to that the tracker was placed on the defendant's vehicle. And my notes are that she testified, or it's been established, that the victim in this particular case admitted that he placed it on her vehicle.
Yes.
I think it's
So,
more important that she reported
that's
his
already
pics
in,
turning up
and
behind her.
I think I said this the other day, and it bears repeating. So this is self-serving hearsay. It's clearly excluded. I will just note a secondary reason would be
Cumulative.
the relevance of this report. The issue is not whether or not she reported it to the authorities. The issue is not whether it's true or it's not true. The case law is very clear on this. It's not relevant whether law enforcement believed her or didn't believe her. The purpose of allowing these prior bad acts, and I say prior bad acts instead of going into all the different ways that can be done, but in a self-defense case, once the defendant has established there was an overt act, prior incidents of violence and intimidation and threats can come into evidence. The case law is very clear. They may be true, they may not be true. The issue is, what did the defendant know on the day that
he was following her around?
Used?
That's the part. I don't know why the
So
defense
those
didn't raise
prior
that.
acts of the specific incidences of prior bad acts or prior violence don't have to have happened to her. She just has to know about it. And the tracker issue, while not necessarily violent, certainly it's intimidating. And I allowed it. I don't remember if the state objected or not, but I allowed that in. The testimony is in. Whether she reported it to law enforcement is of no moment. Whether it's true or not, because put it this way, the tracker wasn't found, so it was just an information report. It doesn't matter if it was found or not. It doesn't matter if this officer believed her or not. The issue is, it's something she's aware of. She testified to an overt act. It's already in evidence.
Did she already testify he was following her?
This is not
Yeah.
marked.
Oh,
That
well
came
then,
in.
What was
then that.
I don't even, who's the next person? What was his name or her name?
Lindsay.
That was Deputy Lindell.
Lindsay. Scott
Lindsay.
It's on the
Scott.
top of the report.
Scott Lindsay, I'm sorry. Lindsey.
They are prior consistent statements to counter any allegation or implication by the
I mean, you could call
prosecution
him,
that
but-
she was lying. If they implied she's
The
making it up
substance
at
of her
trial,
walking in, him taking a report, again, none of that is relevant to the issue of her knowledge of prior incidents.
That's all I was calling it for, so. Yeah.
All right, I do want to give you all a break, though. I know we started at 9. It's about 10:30. I think it's reasonable to go ahead and take a break. So why don't you guys take 10 minutes?
Thank you, Judge.
what was that last witness? Or there was a second witness, and what did he say that one was going to testify about?
The one that, what do you mean?
You might as well just rewind it because we have a 10-minute break anyway. The very last witness,
that- How far back was it?
like 2 minutes, maybe not even.
Like before his little colloquy about the.
I
It was
think
about
right
the
after.
tracker and the police report.
No,
Someone
the
other
next
than that?
witness. The next witness.
No, they were
And
talking
so
about
those
him.
prior acts of the specific incidences
Here, keep
of
going.
prior
It's
bad
after that.
acts or prior
Back?
violence don't have
After
to
that.
happen to her.
He's like, you can call
Certainly
him,
violence,
but he can't
certainly
comment
state
all this stuff.
objected
He's
or
like,
not,
well, I
but
ain't going
I
to call
allowed
him. He's
that
talking
in.
about this
Okay.
witness.
The testimony is in. whether she reported it to law
Because he also
enforcement
asked, I don't know
is
who's
of
your
no
next
moment.
witness, I thought.
Whether it's
And
true
that's
or not, because
Tim, the deputy.
put it this way, the
So.
tracker wasn't found, so it was just an information
All right, babe,
report.
we didn't
It
need
doesn't
this again.
matter if it was found.
Okay, well, we're at real time, so
I was just trying to hear if he asked him about the next witness, but it doesn't matter. Forget it.
no, he didn't bring up another witness. They were just talking about the witness that they were going to call. It was apparently a deputy. So I don't like. To me, I mean, part of what happened here is that the system failed her, right? I mean, she had many communications with law enforcement. She tried to get things done in court that weren't necessarily things that were agreed to. I mean, she tried to go through the proper channels. Do you think it's helpful in terms of the moment in time when this all took place for the defense to bring up the fact that the system and law enforcement had failed to protect her? Or do you think that hurts her in the sense that the state could then turn around and say, okay, well, even though he wasn't really threatening your life, you had reached the conclusion that you were never going to get any help through law enforcement, so you had to take matters into your own hands. I mean, like if I'm
I
the
think
state,
it's a closing argument. I think he makes that argument in closing based on what the evidence is thus far. But yeah, I think you're right that there's a risk if she says that it's because they didn't find, like that somehow that might open the door for them to explain why they didn't take action, which would be that we didn't believe her, we didn't find any evidence to support her, or so I think it's that's all something you just do in closing argument based on what's been said, thus far. But you know lawyers always tell their clients, whether it's divorce, usually a divorce situation, report everything to the police, make a report so it's documented. Oh, he didn't show up to pick the kid up for visitation, go make a report. So that's what they're calling like these informational reports. So the implication that she's doing this because she just keeps going and reporting him because it's her motivation and this is part of her plan and manipulation is disingenuous. And hopefully, I don't know that they addressed that they had her lawyer on the stand. I wish they would have addressed it with her lawyer. I just recall him talking about this whether they were going to have a hearing that day or not,
Yeah. I mean, that was definitely the focus of it. I mean, it's just, we've had situations from both sides of it where there's, whether it's a TRO, temporary restraining order, or a plenary, like a 2-year, I mean, technical violations, at least in Illinois, at least in the counties that we practice around, they take it very seriously.
Right.
Like first arrest is a misdemeanor, second arrest is a misdemeanor. If they arrest you a third time for a violation, it turns into a felony. So, and it's like, and if you have a situation where law enforcement's just not buying it, you got the girl who cried wolf type situation going on in the minds of law enforcement, which is what seemed to be happening here. Because
In their minds, right.
in their minds, so I don't know.
And then
Meg, that's a good question. It is not a silly question, Meg. It's actually a great question. Thank you for the $5. Bob O'Reilly, how does case become case law? Why don't you explain that, Al?
All right. So once you take an issue up on appeal, then, like whatever the issue is, like the legal question that you're raising, once the court rules on that, then that becomes case law. That becomes precedent. That becomes the law of the land. So if it's never been an issue, that's why you hear the judge sometimes saying this is a question of first impression. So when there's an issue of first impression, you'll often see that in the appellate court's written opinion. This is a case of first impression in our jurisdiction. This is what they've done in other states who have considered the issue, or this issue is similar to, logically similar to issue Y, and we ruled this way on that. That same logic applies to the question before us now. So we now rule that, courts should let this in, courts shouldn't let this in, and then sort of as that issue arises, the appellate courts start to develop um, tests for it or factors or things to consider. And it all gets developed in the appellate courts unless and until it's considered by the Supreme Court.
Yeah, and I've explained it many times, and and that obviously requires a conviction. Just so you understand, like when Allie's saying it goes to the appellate level, obviously that means the defendant was convicted, they're
And the
appealing
lawyer decided to appeal that issue. And
that issue.
because sometimes that's, if you've got something that's minor or, because you can't just appeal every issue in hopes that the court will take it up, because the courts will not take the opportunity to just consider an issue just to kind of clear it up. They almost often avoid doing that unless they have to. So if there's another basis to not consider the issue presented, like, look, whether or not this issue was, the judge was right or wrong at this case, there's no point in us taking it up because all this other evidence shows that this guy was so damn guilty that it didn't matter. And then they won't even consider the issue.
Yeah, and it's interesting because kind of the way that the law is created is which you guys should keep in mind. When you elect your state legislators and your federal, national kind of legislators, and like in a state or federally, when they go in and they create what they call a House bill, where they're proposing a new law. At that point, it's got to make it through both the House and the Senate. And then if it gets passed, either the governor writes it into law, signs it off, or the president, and it becomes law. And when you have a statute that's just new law, it's never been applied in any case. So, and just keep in mind, in any case, whether it's civil or criminal, you always have two sets of attorneys that are interpreting the same statute in very different ways, or at least trying to. They're trying to make arguments that, look, we're saying that the statute applies as such, and then the other side is saying, oh, we're saying it applies in this way. And ultimately, if it is a case of first impression, you're going to have a situation like Allie's talking about, where the trial judge may make a decision on it, and there is no case law out there when they're arguing it to give that judge any kind of guidance on which way the courts have ruled on this prior issue, because it's a brand new statute, right? So that's really how law develops over time. So you get a statute that's put into place. Typically, if it's a criminal statute, and you get somebody that's convicted on it, and you get a lawyer and says, okay, well, the way that this law is applied is unconstitutional. So, I'm going to appeal this issue, and you hope that the appellate courts will address it. And if they do, that precedent becomes the law of the land as to that everybody. Statute.
We are back on the record.
It's fluid. The law changes all the time.
Please have your seat, please.
You got some love there, aspiring DV victims are damned if they do, damned if they don't. She reports everything. She's a beautiful assistant.
Vince calls Vincent Physical.
We'll touch on that again after we do this.
You ready?
Yes.
Okay. Yeah, let's go ahead and bring him in.
Thanks for being with us, Ashely. We appreciate you so much.
Please make sure you have him spell that for the court reporter.
So I was trying to say that I felt like some of this could have gotten in as a prior consistent statement.
Do you need the
Please.
Seems so much louder than usual. I have to turn the volume down on my.
The court?
We'll wait to turn the lights down until If you give us
Yeah,
the
I
high
don't even
side,
have a
and the clerk will
booster
turn
on.
them down.
I'm just going to turn the volume down on my headset.
The court does sound louder today, though. I don't have the volume booster on at all. What do you think, J-Bo?
It's this entire time when I stream, I make it a little bit lower because it's just a loud.
How do you do that?
Like just on like the little on YouTube, like next to where the
Keyboard. Volume.
live thing is, there's a little volume thing.
Oh. Thanks, Jay.
No problem.
What a guy.
All right, Logan,
You
have a
guys
seat.
tell me if that's
Welcome
good.
back, everybody.
Might
Hope
be
you got to stretch a little bit.
a little
Maybe
soft.
run a
Maybe
jog
one
in
little.
place, warm up a little.
Blue?
So we've got,
I think that's good. But let's
the
see what the
defense going to
chat
call the
says.
next witness, but before we do that, I did want to ask that anybody begin deliberations amongst yourself, speak with anybody outside of the jury about the case, or do any research on those topics we've talked about. Everybody says no. Mr. Taylor, call your next witness, please.
Thank you. Vincent Vizzacaro.
Oh, please, say Vincent Vega. Vincent Vega.
Didn't we have a Vega? Wasn't there? I feel like there was.
I mean,
Does he have glasses on top of his head? Oh, reading glasses. Got it.
those are the weirdest looking reading glasses I've ever seen. They look like shooting glasses.
He came from racquetball.
All right.
Oh, sir.
Sorry.
Jesus.
As Debbie said, just make yourself comfortable in that chair. My name is Judge Whyte. I'm going to be presiding over the case. You can adjust that microphone up, down, left, right as you need. Stay about 12 to 15 inches away.
Did we
You
see
get a loud,
him
clear voice.
pre-trial? I feel like I recognize this guy.
Vincent Vega.
Good morning.
Morning.
You know who he
Would
looks
you
like,
tell us
baby? He
your
looks
full
like
name and spell your
Brad.
last name for us, please?
Vincent Vizzacaro, Bizzaccaro.
All right, Mr. Vizzacaro, I'd like
Alex
you to
and
try to
Buddy
keep
Brad.
your voice up if you could.
Will do.
What do you do for a living, sir?
I'm in real estate.
And where are you a realtor?
Lakewood Ranch, Bradenton, and Sarasota areas.
Do you have any particular specialty?
Residential homes in Lakewood Ranch.
How long you been doing that?
About 8 years now.
Why are your
I wanna
glasses
ask
on your head?
Whether or not back in
Why do you have your racquetball glasses
2018,
on right now?
you had occasion to deal with an individual by the name of Douglas Benefield.
Yes, I did.
Would you tell us the circumstances
Maybe he
under
rode a
which that
motorcycle.
relationship
Motorcycle
took
to court.
place?
Yes, he contacted me looking for a home.
Objection to those glasses on his head.
Thank you, Judge.
Things
Contacted
off.
you looking for a home?
Looking
Sure,
for a
I can't
home
concentrate on the
he was
question.
trying to acquire
Neither.
through a business that he said he owned in Lakewood Ranch.
All right. And back in 2018, Mr. Vizzacaro, did you use emails to communicate with him?
I did.
And did he communicate with you in the same fashion?
Yes, he did.
Were emails back then a normal and customary part of your business?
Very much so, yes.
Did you preserve the emails as they related to each client's files?
I do that, yes.
And were the emails under your care and custody?
Yes.
Mr. Vizzacaro, I'm going to pass to you what we've marked as defense exhibit number 27.
Can we approach, Jen?
Yes.
I don't know. This sounds like it could be hearsay. It could be specific instances of something. I don't know. We'll see what happens.
As Babe put in the chat, realtors have all the tea.
Right.
Yeah, they do get all the tea, don't they? They get all the tea.
Hi, Shan.
Yeah, what's up, Shans? Where is she? Is she lurking? Is she lurking in the spot?
She's lurking.
Is she laying in bed watching us?
No, she's watching us and the Olympics, I think, unless the Olympics are.
Dun, dun,
Ashley
dun,
Crump.
dun,
Nice.
dun, 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 dun. Oh! All right, we can give some love here during the sidebar. Ashely Crum, member for 1 month. Thank you for creating this wonderful fam. Love you guys. We love you back, and you guys are what make it, special. I mean, frankly, without y'all, Jay and I and Allie would just be 3 people talking into the void. So you guys should absolutely be patting yourselves on the back because you're all amazing, wonderful human beings. And we love this community so much. So thank you for that, Ashely. We appreciate that kind sentiment. Debbie with the $10 Hollow super sticker. Debbie is like, it's typically she'll give that $10 holla and she never says anything. Debbie, yeah, we really do. It's like,
she's like, here's a little gift.
Here's a little love, like that's so sweet. We're so appreciative. Thank you, Debbie. Ashely Crum, not that we mind when people say things. I just noticed that Debbie typically just gives a $10 holla and she's like, here you go. Love you. Ashely Crum gifted 5 DD podcast memberships. Thank you so much. And I'm sure that the folks that are the
Babe was one of them.
Oh, wait, about time. It's about time. Boy.
Well, she just put in she was already a member of the DD Patreon, so now she can use the emojis here. So thank you.
Oh yeah.
All right, so you started to read this off, but it was real loud in the background. Aspiring court reporter, DV victims are damned if they do, damned if they don't. If she reports everything, she's abusing the system. If she doesn't, it wasn't that bad. Exactly. And that's why I'm saying it would have been helpful for the jury to know
The jury. I do need a few minutes.
she's
to
doing that
resolve
because
a
the lawyers
legal
want
issue.
to.
Yeah.
Oh, my lad, he's selling them out again.
Yep.
What?
Yep. Now we're
Oh.
going to hear some argument. Yeah, we'll see where they're going.
God. Oh my God.
I feel like we might have seen this guy in the stand your ground hearing or something. Jay, does he look familiar?
I'm telling you,
you might be right,
No,
but
I don't even remember this guy that you're
he's the
speaking
spitting
of.
image of Brad Beach.
Oh,
like
I don't think so.
Oh yeah.
Well, that's not where I'm thinking of.
Big
It from.
time.
It's not.
Big time spitting image. Big time.
All right, hit play.
That's my responsibility. So if you could, please close up your notes and leave them there on your chair. And I'm going to excuse you back into the jury room.
Oh boy.
Discuss
Oh, you still have
other
some
witnesses'
time?
testimony or the questions asked of you with anyone else. Can't discuss other witnesses' testimony or what questions they were asked or what testimony.
Is there
they
more?
gave
You can keep
off
going.
the report. We're doing any research on the case.
Is he bouncing him?
Yeah, he's telling him to
he's
leave the
just
courtroom
telling
while
him
we
not to
talk.
talk to anyone.
Right.
Now
you're done.
We live.
He's doing the remix. That was the remix.
Oh yeah, he was getting down. Let's go back.
All right,
Oh
come on.
yeah, what's up?
Yeah, we saw it. We saw it.
Oh.
I'm just going to ask before I start doing my research, do you have any cases you want me to know about right now?
No, Your Honor.
All right, so I'm sorry, go ahead.
We're traveling under the words in the statute, specifically 9803(6).
Understood. All right, so I'm thinking I need about 10 minutes or so. So we're going to take
Damn
a
it.
10-minute recess, maybe 15-minute recess. I
Let
want
me
to
look
look this
that
up as
up.
well.
908.
I want to find a case that gives me some direction.
Sure.
Yes, sir.
You're all bloop it.
Florida rules.
Traveling under the words in the statute, specifically 9803(6).
Understood. All right, so I'm thinking I need about 10 minutes or so. So we're going to take a 10-minute recess, maybe 15-minute recess. I want to look this up as well because I want to find
All
a
right,
case
so
that gives me
it's
some direction.
hearsay.
Yes, sir.
So they're going under 6. Let's see.
I'm trying to figure out what they're going to have them testify to. What do they?
Of course, that means you can too.
Do we
When we go
get
back on the record.
Yes.
do we get kind of an idea of what he's
thought it
going
was
to
just-
delve into?
All right, so this is not what
Emails?
this is
I don't
not
know.
what he should be relying on. So he's relying on 6, which is what I thought, because he asked him about, whether these are records that you store in the regular course of your business. So it's and that covers a memorandum, report, record, or date compilation in any form of acts, events, conditions, opinions, or diagnoses made at or near the time by or from information transmitted by a person with knowledge, if kept in the course of regularly conducted business activity, and it was the regular practice of that business, blah, blah, blah. So this is typically what we see when they're like, you get the phone company in and they're like, oh, this phone, it was Jay's phone. And here's where he said he lived. And here's how long he was this is the medical record of so-and-so. This is the, so-and-so lived at this house. We don't know what they're putting this in for yet to know whether it would fall under this. But unless he is trying to get in the fact that, he was looking to buy this specific house, for example, let's say he was trying to buy the house right next to Ashley's house, then I think it could be considered like a records regularly kept in business activity. But
I mean, is that is that what they're trying to get in? Like emails?
yeah, but emails, like you would be using this argument about, the 6 has A, B, C. It has multiple, and he didn't say which one. Opinion diagnosis, a party's intending to offer evidence under paragraph.
While she looks it up, did you guys see Ariel's comment here?
No.
Hi, pals. I'm driving 8 hours today, so I can take the bar tomorrow and Wednesday. Perfect stream to listen to on my drive. Good luck, Ariel.
Oh, yeah. Ariel, just go in there, breathe. If you hit a question, especially on the multi-state with a super long fact pattern, do not eat up 10, 12 minutes of your time because each question's worth the same, right? So,
well, yeah, you don't know that they haven't changed the way they calculate it.
yeah, it
Maybe
has
they've-
been a while. It has
right.
been a
So
while.
we don't want to give any advice as to whether skip a question, guess on an answer, because
I
it
do
all
want to
depends.
give advice that you should, if it's a really long fact pattern,
Push
back
it to the end.
yeah. Like you want to get through as many as possible where you've actually had the ability to be able to read the questions as opposed to because I had a problem with that, like on really long fact pattern, multiple choice. Because the thing about the bar exam, especially the multi-state, and there's 2 portions of a bar exam. There's written, which is usually state-specific law, and then the multi-state, which is the multiple choice portion. And the thing that was so hard about the bar exam was that, like, typically when you have a multiple choice question, like going through schooling, it was like you'll always have 2 that were clearly wrong, right? Like, so it's like, all right, these 2 are obviously wrong. So you're stuck between figuring out which of the 2 that you have left is the correct answer. And the multi-state, all 4 are in some way, shape, or form typically correct, but they tell you that you have to figure out which one is the most correct.
Ugh.
It's like, yeah, there was no like process of elimination. These 2 answers suck. It's like boom. It's a tough test, but Ariel, I'm sure you've studied very, very hard. I'm sure you're going to be ready. Just go in there confident. Just go in there, knock out as much, and you want to get to as much as you can. So I'm really rooting for you. I'm sure you'll do great and keep us posted. Takes about when did we get our results, babe? It was
a while.
I think it was 6 weeks. I remember I think we took ours in August, our
There's
bar
not a chance in
exam.
hell I'd remember how long it took.
Or we took it in September and we got our results in October. It wasn't as long as you would have thought. I remember the night I passed the bar, I was with my dad. Like you were still in Philly. I was in Chicago. I think my dad and I were out to eat and I got the email. So that was pretty cool. So here's my bar exam story, which I always tell. What?
I think we want to answer some questions.
Wait, what? You don't like?
Oh, that one. Yeah. Okay.
Which one did you think?
There's a bad one and there's a good one. Allie doesn't want her to tell.
Was there a
tell him the
bad one?
Oh
my God!
I'll remind you later.
I can't even think of what story she thinks that I would tell.
No, this story's a great one. Go for it.
Yeah. So the morning I'm taking the bar exam, I think I had I was pushing like a Nissan Sentra this is like circa 19. It was probably like a 1996 Nissan Sentra. So, you know, like there was a CD player in there for sure, but you know, there was no satellite, there was no hooking your phone up, playing your own shit. It's like you went in, you either had a CD in there or a tape or, you know, the radio, like back when people actually used to listen to the radio. So I get in early morning, nervous as shit, getting ready to head down to the city to take the bar exam, turn the car over, radio pops on, and like immediately, like at the very beginning of the song, Welcome to the Machine starts playing by Pink Floyd, which I love. I love Wish You Were Here is definitely my favorite album by Floyd. And I
Plus,
love
it
a lot
is
of Floyd.
you're also kind of being welcomed into the machine.
Well, that was the thing.
Right.
Like that's the significance. Like that's exactly what it's about. Like you're like becoming a cog into the machine. So, and the bar in Illinois, in California, there's a couple states where it's 3 days, but like in Illinois, it's a 2-day test. So second day was the written, so the essay portion. Come out, like me and my buddies that were taking the bar that we had gone to law school with, we all went and got dinner. I think we went to a Cheesecake Factory, I want to say, down in the city by the
details.
Hancock. So, you know, we go eat. You know, all of us are still, you know, like you're coming out of that exam, you're still feeling like all the things. You're like, oh my God, I failed.
What'd you write for this? I did this. I did,
right.
Rethinking
And it
all
was
your
like we'd
answers.
all like made an agreement. We're like, we're not gonna like tell each other like how we answered shit, because then it fucks with your head. You're like, oh my God. So,
That
you
was
know, we
good.
have a nice dinner. I get back in the car. I'm getting ready to drive back home. I turn the car on. This is hand of God, man. Like I turn the car on, and as soon as the radio kicks on, it's Welcome to the Machines playing, like at the very beginning of the song. I'm like, oh my God. I'm like, this is some kind of weird, bizarro world sign that I've now entered the machine. I'm in the cog. I'm like a cog in the machine. It was really weird, but it was like I took it as such a like kind of a weird sign that that's what I was kind of supposed to be doing. So it was
Two questions
strange,
about
man.
that. Dark Side's not your favorite album, and second, did you have I'm sure some folks in the chat had this, when CD players first came out, you only had the tape option in your car. So did you have what I had, which was you had the Discman that you had to like take the tape, the fake tape, and you had to put it in the thing, and then you had to hope. I wasn't one of those fancy people that had like the thing for it. So my shit was just flying around and just
totally.
Hopefully it wasn't skipping.
On that Sentra, I had that.
Days.
Yeah, it was like that fake tape that had the little wire that came out of it.
And I think you charged it with like the cigarette lighter, which do they even have cigarette lighters?
100%. Yeah, back then they definitely had cigarette lighters, like that you could actually use. 100%. That was it. And then no, I love Dark Side, but I mean, Wish You Were Here is like amazing. It's an amazing album. It's so good. It's got Have a Cigar, you know, Wish You Were Here. It's great. And I love Dark Side of the Moon. Love it. So Jay, Latina wants to know if you grew up in Flushing, Queens.
No, I answered in the chat. I grew up on Long Island. My grandmother, however, lived in Flushing on Queens Boulevard, and we would visit her for all the Jewish holidays and, well, just visit her in general. So she was in Queens, but I'm on Long Island.
That's sweet. Thank you so much for that $2 holiday.
And of course, Citi Field and Shea Stadium, many a trip to Queens for that too.
Yeah, you and Doug Heffernan.
Yes, yes. King of Queens, baby. What a great show that is. Underrated, great show. Kevin James, Jerry Stiller, Leah Remini, just an all-time great show.
Oh my God. Susan. Bob talks and I yelled at my husband, yep, married to Bob. My husband's favorite is Pink Floyd. They're all right. But he gets mad because I said all their songs sound the same. LOL. What? Susan. No wonder your husband, like, he has every I'm heading to Delphi tonight. Or maybe I get up at the crack of dawn and it's like a 2.5 hour drive.
Is it like an all-day hearing tomorrow?
It's supposed to be 3 days of hearing.
Are you staying there for 3 days?
I mean, I'm gonna, if I like, I gotta get.
So what's the plan? Like I know they're very serious about not letting anything in. So like you're gonna take notes and then come out and like do lives on it.
Yeah, which sucks, because it's like you're sitting there, you can't really watch what's going on when you're trying to take notes. It
Right.
just makes for a long day, but I'm gonna go in and take the notes, assuming that Judge Gull lets me in. There's people that think that she's not gonna let me. I don't think that that's the case. I think that I'll get in just fine, but who knows? If I get bounced, then we're gonna put Allie in there. So luckily there's two Matas that are
Oh, you're
lawyers.
both going down there?
Well, we're talking about it because we're kid free. We're kid free this week. It
Right.
feels very eerie and sad a little bit. Like I was telling Allie, I'm like, oh my God, this is what it's gonna be like when we're like empty nesting. It's like I'm not really a fan. I like having the kids around. They make me happy.
And this is a
Scarlett was
dumb
so
question.
sweet last night. Oh man, she was like, because this is like really kind of the first trip she's taken without us. Did I talk about this already?
Yes.
Oh, all right, never mind.
Yeah, Florida.
It really hit me in all the feels. She was like just so sweet. I'm like, you're not gonna miss me. You're gonna be having so much fun, the beach, swimming, hanging with your friends. Yeah, it's probably true, Sleuth. I'm probably gonna lose my shit. I like having my smalls around,
Is this Frank's stuff? I'm obviously not up to date on Delphi, but these 3 days, what are they doing?
It's like 10 motions are up.
Wow.
A bunch of stuff. Like the most significant that I feel are probably going to be, she's basically going to have them try to prove up why they can use their third party culprit defense, which is the main reason I want to get there. And then also they're going
Wait,
to
does it start tomorrow?
Yeah.
Yeah, you're
Well,
going,
I feel
Allie.
like
You
we
didn't
haven't
know?
made any plans. Like, I need to get the dog into a doggy daycare or something.
Well, what I figured is that if I get bounced for whatever reason, then you come.
What?
So otherwise,
I know that. Well,
but leaving my dad for 3 days, I mean, he's like another child. I said it's like we had our we're kid free, but my dad needs.
well, it'll be a
help.
little late by then because it's a 3-hour drive, so might miss the hearing.
Well, you might miss the first day.
Right.
You guys see Nanook out there in front of the courthouse on like a bike rack with the leash. Make sure to give him some treats.
And he just wants to kiss your face. He doesn't want to bite you. He just wants to give snuggles, kisses, face licks. So yeah, no, but like there's many motions that are going to be litigated over the 3 days, but also the safekeeping. They're still trying to get Alan out of the prison and into a county jail. There's other ones. I don't think that there's a full Frank's hearing, but if they get through everything that they're getting through with the motion on third party culprit stuff, I mean it's basically the same information coming out. So should be really interesting. Should be really, really interesting. Can't just
Great
turn
idea,
around.
Taryn.
I mean, that's exactly right, Taryn. a lot of Moneyball would be watched over the next 3 days if we're both gone.
Does he watch actual baseball? Like, does he watch the Cubs or the Sox? Does he care? Does he watch it?
No, just likes baseball movies. Like he hasn't if one of the teams are doing well, I can get him engaged. Like back when he was younger, he still watches the Bears though. He's a Bears. He's definitely a Bears guy.
Does. And he's much better at like if I have a question during the football game.
Oh my God. Allison gives me so much shit because I'm not good at
because usually I'm asking about a rule and like a technical thing. I'm like, well, why was that an issue? Like, because I want to understand what I'm seeing.
I know. It's like the problem is that like during the game, I'm like psychotically like immersed in like I'm like watching every play like it's the end of the world, like, oh my God, it's like 3rd and 3. This is the biggest set of downs in the whole game. And then Allie's asking me a question.
That's ridiculous. I wouldn't do that in the middle of like an exciting, heated,
What?
up and clapping and screaming scenario.
Oh my God. Are you serious? You always ask questions right at pivotal moments in games.
All right, you guys ready to go back on the record?
Pivotal game moment.
Printing something.
Nanook is
the
half
objection is
Shar-Pei,
hearsay.
half Siberian Husky. And all heart. All heart.
Any other objections?
Judge, also, I would like to make a relevance argument that the fact that he's going back and forth in this email about a specific property, there's no relevance.
Why can't we see the thing?
Yeah, what's going on?
Oh. I should probably put it back on the screen.
It was. Oh.
There we go.
Hey-o.
All right, proponent, go ahead, sir.
Well, I think it's admissible, one is a business record, which we've already qualified. Business records traditionally contain hearsay. And under the statute, Your Honor, specifically subsection C, we got this email from the state. However, we then gave it back to the state in its isolated form. They have not filed any objection to it, so they've waived that objection according to the business records exception. We also believe that it shows.
I don't think that's the. I don't think that's what C said.
That he was in the process of buying a home directly behind Ashely Benefield's home during the time period when the South Carolina injunction was in full force and effect.
I really didn't think that's what it was going to be.
Be nice. For the record, I didn't even take the cord screen off the thing. It was Jay or Allie.
Not me.
All right, anything else, sir?
That's right.
State.
Judge, I found a case I would like to put on the record. Thomas v. State, 993 Southern 2nd, 105 from 2008. It is specifically addressing an email that was put in as a business record. I didn't have long to read this, but it was an email that was sent to an apartment complex manager of some sort. And it appears as though it was not qualifying as a business record. And additionally, the hearsay within the email was not admissible.
Can you give us
There is a yellow flag, and I'm trying to look at it now.
Factual basis? Like, you didn't give any facts. All right. Well, we would need to know, like, she would need to be telling the court, like, why it wasn't admitted. Who knows? It could have been any number of reasons that aren't relevant here. I think the business record stating the address of the place that he was intending to but the question is, did she know that? You know? Oh, now I see the gray hairs, babe. She's also probably just not that worried about what she looks like right now with all this going on.
Christy, is yours the same color as our guy? Because he's definitely churro colored. It's a great name.
I'm not sure if he's waiting for them to read this case and figure out an actual argument beyond. Oh yeah, Catgrove. I've been trying. I need to find like a person who can. I can't do the whole process of growing out over time and look ridiculous for like 3 years until it's done. I don't know. Can they? What is happening right now? I wish they'd show us what's going on at the bench.
Are you talking about Vasquez from kept and heard. Yeah, that was different. Yeah, they were very different. There was no prosecutor in that case. They were both. That was a civil case. Remember, that was not criminal. Very different. Different burdens. Different things can get introduced. And there is no prosecutor, defense attorney there. You just have two civil attorneys going at it. So it was different. She felt like a prosecutor, though. Latina, for sure. I'm talking about Camille. I'm assuming you're talking about Camille Batso. I mean, her bosses were pretty prosecutor-like. So, and thank you for that $5 hollow.
I think the judge pulled up that case that she cited and must be reading it.
Sleuthie's giving you a hair tip.
So, Susan Skinner said she stopped coloring her hair and she doesn't have any.
She said she started going gray at 16.
Right, but she colored her hair for years, but then she hasn't colored it and she has very few grays.
Huh? What? Is that
started early and then stopped, it sounds like. Because that's an odd thing to happen, right? For it to start at 16. I don't think it actually can carry over to someone who started getting gray. No.
More hair tips.
Starbound's letting hers go in natural too.
All right. Did you review
Looking at
Thomas B. State?
Condition.
Mr. Taylor?
Yes, sir.
All right. Do you want to make any argument on it?
No, sir.
My mom went gray.
So Thomas
really young
Wait,
too. Not that
B.
young.
State is helpful. So 993 Southern 2nd 105 First DCA. Although it was the state introducing the email against the defendant, the state sought to introduce an email that was prepared by an employee of the apartment complex where the victim lived and was murdered regarding statements made by the victim that she had someone living with her that was not on the lease for a year and she wanted that person out. And obviously the state was introducing that to prove that that was the defendant and that the victim was trying to evict him, and that was part of the reason why he then murdered her.
Oh, that was Allie.
The first DCA found that even if the email from the employee's side
was a business
qualified as a business record, and it seemed to.
I don't know why the defense hasn't argued this is
I
distinguishable.
don't see where they actually found and held that the email was a business record, which was my original question, but ultimately concluded that the statements that were made and then by the employee and then communicated through that business record, those statements were not, well, first they're hearsay, but they were not part of the records and the data compilations of the business itself. And that.
But this is, she's comparing apples and oranges. That I understand that scenario.
Hearsay may exist within exhibits that fall within an exception, such as business records. Those hearsay statements must still qualify under a separate exception to the hearsay rule. And in this particular situation, if I'm understanding correctly, what the defense is asking is to introduce Defendant's Exhibit 27 through Mr. Vizzacaro as his business record that he keeps. But according to Thomas, and then they also cited a prior case of theirs, Van Sant v. State, VANZANT, 372 Southern 2nd 502, Florida 1st BCA 1979. Even if this qualifies as a business record, which again, I have not found a single case that says it does or doesn't, and I don't see in my review of Thomas where it says it is or isn't. But the statements of Mr. Benefield are being offered to prove the truth of the matter that he's looking to buy a house in Lakewood Ranch are hearsay without exception.
But the exception, Your Honor, is his state of mind. It clearly shows Mr.
His state of mind is not
Benefield. Let's
relevant.
forget what the defense is here. The court's allowed me now to bring in evidence of domestic violence. And here is Mr. Benefield.
Yeah, no,
Judge
I guess.
Whyte, negotiating with the Realtor to buy the house directly behind the home where Ashely Benefield lives. And he's doing it at the time the South Carolina domestic violence injunction prohibits that. He would not be able to buy that house directly behind
Well, he wouldn't be
Ashely
able to live in
Benefield's
it.
home. It's like 200 feet away, 100 feet away. And it's a continued pattern and practice.
There could be something there. I just don't know that he is.
That cooperates.
Do you want to be heard on
Don't say those words.
90.8033, than existing mental, emotional, or physical condition?
Judge, his emotional, mental state, that still has to be material to a material fact. And his state of mind at that time is not a material fact. Also, I think the defense is misrepresenting some of what's in the email. Mr. Benefield never said he wanted to buy the house. He said he wanted to rent the house, and he said, I'll have to check with Ashely first. So I think some of the misrepresentation that's going on, we should probably just read the email. But I don't think it has anything to do with his state of mind. His state of mind at this point in time is not relevant.
Well, just because he told that guy he's going to check with Ashely first doesn't mean. I thought it. Now I got to refresh on the rule. Does she have to know, have reason to know the information for it to be relevant? Like, even, for example, if he had been buying a gun and had a bunch of notes in his drawer that he's going to kill her.
As I've said before, are you going to establish the location of the home through Visicaro,
Yes, sir.
where it was
Yes, sir.
in relation to the house where Miss Benefield lived?
Yes, sir.
And then are you going to then just argue during
Exactly.
closing?
Right.
I would assume.
Yes.
All right, so there's going to be no more witnesses. This is the end of this road to establish
Yes. This is just,
witness-wise.
this is an isolated act.
He doesn't even need the emails.
Yes.
He just needs to say where were you going to show him houses?
Judge, if she didn't actually know about this, and I don't know
There
that
you
it's
go.
relevant.
Well, and that's what I was thinking,
There you
because, hold on, it's not an act of violence, though,
Right.
or
Right.
threat. But under 9803 subsection 3, a statement of the declarant's then existing state of mind, emotion, or physical sensation, including a statement of intent, plan, design, when it's offered to prove the declarant's state of mind, emotion, or physical sensation at the time or any other time, or prove or explain acts of subsequent conduct of the declarant.
Then, Judge, I would just ask that this witness be asked questions if he is allowed to testify. I don't know why we even have to speak about an email.
Exactly.
Just, were you helping Doug Benefield, and were you looking at a certain house?
And was
I
that
think
at his
would obviate
request?
some of the evidentiary concerns I have, that you asked if he was assisting him in finding a location. Did you find one? Where was that location at that you were talking about putting an offer on?
Did he-
Indeed, and if the court rules against the admissibility of the email, that would be my intention. On
You
behalf
don't
of
need
Mr.
the email.
Benefield, though, I would like to present the best defense that I can. And I think that the email clearly is something the jurors can have, read, see. It's tangible. It has the same kind of impact, Judge, that the prior inconsistent statement of Gillum or the emails involving Stephanie Murphy does. And in the absence of a reason why it should be kept out, I would like to admit it.
All right. Thank you both very much. I'll allow the admission of Defendant's Exhibit 27 under 90.803-6 for the Realtor's portion and 9803-3 for the Benefield portion. With the understanding that, again, this is a relatively collateral matter.
In and out, Judge.
Right. I was going to say that this is all. He just needs to get the address, location, and then make the arguments in closing. We don't have any time, right?
No,
Bloop time.
no blooping. Very little blooping.
Thank you, Susie Storm. Thanks
Susie
for watching with
Storm,
us.
we appreciate you so much. Thank you, thank you, thank you. Who's that young whippersnapper back there, all suited up?
Well, I'll tell you this. I learned that young lady over on the side is apparently Jules. I did a video about her reaction. Everyone,
Yeah,
I was like, "Oh, check out this woman." Everyone's like, "That's Jules." I'm like, "I didn't know who Jules was."
I didn't know who she was either.
Everyone
until
else
your
knew who
post.
she was. Apparently, she goes to a lot of trials.
Yeah, trial observer.
Yeah.
All right, y'all can have a seat. Welcome back, everybody. Get ready to begin deliberations. Talk with anybody outside the jury about the case or do any research. Everybody say no. Mr. Taylor, you may resume your direct examination.
Thank you, Judge Whyte. Mr. Vizicaro, when we last broke, you told us you were a realtor and that Douglas Benefield had contacted you relative to a house in Lakewood Ranch.
That's correct.
All right, I'm going to pass to you, Mr. Vizicaro, what I've had marked as defendant's exhibit number 27. That would be the email messages that you referred to before when we were last in front of the jury, correct?
Correct.
Is that a true and accurate copy of the email exchange between you and Douglas Benefield?
Yes.
What is the date of that exchange?
The last email I see here was March 12th of 2018.
March 12th, 2018. Your Honor, at this time, I would move to introduce that into evidence on behalf of Ms. Benefield.
All right, same objections, overruled. Defendant's Exhibit 27 will be received.
Now, Mr. Vizicaro, I know you've told us that the home, do you recall the address of the home?
Yes.
What was it?
5060 Newport News Circle.
All right, I'd like, with the court's permission, to dim the lights, and we're going to put a diagram up there for you. And as luck would have it,
I can't make this work.
pointer. Okay, so this will give you
The beam?
Okay. Would you please show us on that diagram where the house was that Mr. Benefield contacted you about purchasing?
This one right here.
Right there. Now,
What?
that house,
Where's the beam?
directly behind the house in front of it with a red dot on it?
Yes, yes, it is.
Okay.
Do you know whose house the red dot is?
Do you know, Mr. Vizicaro, who was living in the house with the red dot at 11331 White Rock
Also known
Terrace?
as a pin.
No, I don't.
And do you know whether or not, if I may,
He had to.
whether or not you don't know who was living in this house?
No,
This is the house that Mr. Benefield was interested in purchasing.
correct.
Do you know whether or not Mr. John Samp lived in that house?
I don't know.
Give me just a moment, Your Honor. I don't believe I have anything
Well,
further.
Why would he be saying I have to ask Ashely if he didn't know that Ashely lived there? You should have used a map that's already in evidence. So I'm assuming they've already acknowledged or established that dot belonged to Ashley's house. But
This guy's like, can I just go back and play racquetball? Because I don't know why.
Do you see my racquetball glasses on my head? That's what I need to be doing right now. Not that.
Mr.
No.
Carl, my oversight. I'm going to pass to you what I've marked as defendant's exhibit number 28 and ask you if you can identify it.
there you go. So this is probably, well, let's see. I don't know.
Yes, that's the house.
That's the house that Douglas Benefield had contacted you about purchasing.
Correct.
And is that in exhibit 28 a true and accurate reflection of the locale?
Yes,
Does it have a dot on it?
it does.
Does it have an address?
It does.
What is the address?
5060 Newport Circle. Newport News Circle.
On
Excuse me.
behalf of Ms. Benefield, you want to move to introduce that as defendant exhibit 28.
No objection.
Received.
That's all. Thank you very much, Mr. Fisicaro.
Wait, not done.
No, you can wait.
Gotcha.
Cross.
So you've had the opportunity to review the email, correct?
Yes, I have.
If I could just grab it real quick. And for the record, this is State's Exhibit 27. And it appears as though
Now he should be objecting.
you're speaking with Mr. Benefield about potentially this house coming up or the price being lowered on this house, correct?
That's correct. Yes.
All right. So you were contacting Mr. Benefield about
I reached out to him about that.
Okay. And he actually said he may just want to rent. Isn't that correct?
That is correct.
And he also said he didn't want to do anything without speaking to Ashely first.
That was a comment that was later in the conversation. Yes.
Okay. And if I could show you State's Exhibit 27, it's very small type at the top. So you might be able to.
That's why.
Record defense exhibit.
I'm sorry, Defense Exhibit 27. Does he say there that he needs to speak with
Wow.
Ashely first?
It appears that way. Yes.
Those
Okay.
cheaters are next
Thank you.
level.
No further questions.
Can you redirect?
Yes.
Can the witness be released?
Yes.
Oh, he's so. Why does he leave that
Yes.
hanging
All
there?
right, sir, you're released from your subpoena.
I thought
You're ready to
that-
go.
Thank you.
I thought that. Oh my God! I thought Doug proposed that house
Mr. Taylor,
initially,
can you-
and then he
state
reached
defense
out
and
about
approach
the
real quick?
price being reduced. I don't know why he didn't. I don't know why he didn't clear that up. Jesus.
Hanging Chad. Hanging Chad. Oh,
I need to recall him. I screwed up.
I left a hanging Chad.
I'm hungry.
Me too.
500 people here. Thanks for being here. Please hit that like if you haven't already.
Yes.
I'm gonna check everybody. I'm gonna
welcome,
check it out
welcome.
right now. Let's see.
What? The likes?
Yeah.
Oh, Allie's on the like mission.
All right, call your next witness.
Defense would call, Your Honor, Dr. Jason Quintel.
Doctor.
What are we? There's 352. So 150 some more people could, if they're sweet and kind and up to it.
Wait, is this
minimize
Andy
that
Dick
chat
again?
and Click the thumbs up. Click the thumbs up.
Yeah, hit that like. Was Quintel Andy Dick? Does anyone remember? Babe says yes. I think Andy Dick is back.
Who's Andy Dick?
One of the
Great comedian.
One of the what did he mental health guy?
Okay, wait. Did the defense
There he
rep-
is.
There he is.
No, the defense did not rest. This is their witness.
Oh,
I really
Who
think
was-
it's
who was
Love
called by the
Child,
state
Will
initially.
Ferrell, and Andy Dick.
Hello, Doctor. Welcome back.
Hi there. Thank you.
As you may recall, my name is Judge Whyte. I'm presiding over the case. Same rules as last time. Just make yourself comfortable. Adjust that microphone as you need. Speak in a loud, clear voice.
so many times where someone does that and then the lid just pours right off. And those little courtroom.
Good afternoon,
Big
Dr.
drink.
Quintel.
Hi there.
Welcome back.
Thank you.
As a result of the counseling
Big sigh.
sessions that you had with Douglas Benefield, did you reach any conclusions with respect to Doug?
Objection. Improper testimony. Opinion testimony.
That's expert testimony.
Can you go ahead and approach?
Oh, Lord.
Taylor says, "I think this is our last witness." What, is that right, Taylor? What? I haven't heard that, but do we know of any other witnesses?
Yes, I actually see Gene Weidler a little more than I see Larry David. Maybe it's a combination of the two.
Who? Gene Wilder?
I mean, I can see it. I don't know.
Hmm.
Nay said it.
It's Will Ferrell.
Someone else
and
said
Will
Larry
Ferrell
David.
and Andy Dick had a love child. That's the dude
I
right
mean,
there.
I could be that too.
It's mostly the hair with the Will. It's from the eyes up. Really reminds me more of Will Ferrell.
Thank you, Kristen. Kitty C. $5 holla.
Oh, thank you, thank you, thank you. Let's see. You guys here in Jade Defense Stars, Bob and Alley Law, all make Mondays more like other good regular days to me. Aw, thanks so much. Thank you so much.
Thank you.
Early Bagley. Aw, family hug.
Taylor believes, unless he or she made it up.
Oh shit. I mean, that would track with me.
And then we got rebuttal. And wasn't there an issue where they were? I don't know if he ruled on it, but as far as bringing back Eva because she did interviews, I don't remember how that was resolved.
Yeah, Joni, I threw David when Jay was asking who, I threw Larry David out there. He's got a little Larry David in him.
I think
Got
it's
more
more
hair
the
than Larry,
glasses and
though.
his height.
You could be right, Taylor.
Your wife says you're correct, Jay. She's got your back here.
Ooh, everyone please screenshot that, save it.
Oh, let me tell people how they did after we gave them instructions. So looks like not much changed, but let me update. Except that a bunch of people left. They're like, if she's going to tell me that I got to click that thumbs up, I'm out.
By the way, Allie, you always say to lower, I forget what you say. How you say it, but I
Minimize
always
the chat.
minimize. I have the chat when I watch YouTube. I have the chat next to the thing. Am I the only one that does
Well, are
that?
you turning your phone?
Oh, you're talking about on your phone. See, I watch on my computer. That's the difference.
Yeah, on your phones, you have to.
Oh,
You
that's why
can't see the thumbs up unless you minimize your chat.
Gotcha.
Mm-hmm. Mm-hmm.
But I guess I should assume people aren't standing around for extended periods of time watching it on their phones.
I mean, when I'm
How
thinking about the rebuttal case, I don't know. I'm trying to figure out what they're going to be able to rebut.
Me too.
I
I'm
mean,
just
they can't
surprised.
use it as an opportunity to put on additional evidence that they just forgot in their case in chief. That's not what rebuttal is. So I don't know.
See, Beyond the Veil Oddities says that they have to actually close it out and come back. So I do it before I enter. Oh, she's meaning the chat. Right. That's or he or they. Um I forget what I said. It looks like, you know, it looks like a bunch of people actually did that. So thanks guys for the likes, thumbs up. I'm just surprised that they haven't talked about this beforehand. Like everybody knew he was recalling this guy. So it, I just think the argument is if you're what he decided this guy's tendencies are not what your client knew. And then if I'm the defense, I'm arguing, but the prosecution has put his mental state at issue by trying to imply that none of the things that he did either happened or that he was wonderful. I mean, I honestly think the putting on of his lawyer to say what a wonderful, amazing guy was open the door to this testimony that supports that she is not making these things up.
Mm.
I got to think about it, but you can like tell like right now the judge is focusing on the defense and defense is getting animated. But I do think that it's not relevant to her state of mind, but it's relevant to lending credibility to her story where where the prosecution has put in issue her that she's making all of this up about his about the stuff that she endured at his hands. So, you know, in a typical scenario, like I said, if there's like a letter in the drawer that says I'm gonna murder you on Tuesday, and then you know, there's commit defend yourself on Tuesday when they come to murder you, that letter in the drawer is never coming in unless you had found it before, and so you were prepared and knew that he was coming to kill you, so you acted more quickly. But if they tried to put into evidence that she was making it up and he like specifically, like if they were trying to argue that there were facts that established that this guy was planning to come murder her and the prosecution is arguing there, you know, like that's all nonsense. There's nothing to make anyone believe he was actually coming to murder you, then that might then put that letter into they may open the door for something like that. I mean, this is a stupid scenario that I'm giving right now and we're hypothetical, but I just haven't heard him making that argument all along. Like I think he could have made arguments that her statements to the police were prior consistent statements to rebut an inference that she's lying at trial.
I can't. What was he testifying to, Jay?
To his examination of like what his opinion was after he did his mental
Oh,
health
is
evaluation.
this Broder?
Am I
Oh,
wrong?
this is
No,
when-
no,
this
no,
is
no. They
Al?
had two of them mental health guys, I think.
Uh-huh.
He was after Broder.
He definitely said, "What was your opinion after you examined?" That was the very first question. Unless now I'm making things up. I don't know.
No, you're right. That's what he asked.
Okay.
No, yeah, I think Dizzy has this as Quintel. I cannot for the life of me remember what he was testifying about. I just remember the whole, you know, the funny little area there where, well, it wasn't really funny, where Taylor said something snide. Oh, you wouldn't believe, or you've seen nothing yet, or whatever he said. And Judge Whyte went off on him. That's what I remember from his testimony.
Me too.
So nothing substantive at all.
So imagine how that, and you guys are literally talking about it, covering it. Imagine how hard it is for the juries to remember.
Mm-hmm. Mm-hmm.
It's quite a long argument here.
Yeah, that's what I'm saying. It seems like something that should have been addressed pre-trial. Or
Oh, okay. So Shan says he testified that she was deferential to Doug in session. Right. Okay. So that was on during the state's case in chief, obviously. So
I mean, if he's getting an adverse ruling here, he needs to ask the judge
Right.
for time to
GG.
think so that he can like have a mental break and conceptualize other things that he might be able to get in and workarounds. And because I think that this guy offers important testimony only because he's calling him, and the comment you just said that this witness made when the state called him, it seems he's got some important intel on the mental state of the emotional well-being of Doug. I think that the prosecution has put his characteristics as an abuser at issue by trying to deny he had any such characteristics.
I mean, that's, if I remember, like Shan's comment kind of jarred some things. Yeah, like that was kind of the thing. But I thought he was more helpful to the defense during his testimony than he was to the state. So I don't know.
He seems like he's all right, like he's understanding.
This guy's like, please just don't yell at me again.
Okay, Dr. Quintel, so
I do definitely see some Gene Wilder in there.
Yes, sir.
Gene Wilder.
I think you
Wilder.
told us your specialty was trauma.
Correct.
And for purposes of practicing your profession, various clients come to you and relate their backgrounds, correct?
Agreed.
Various people come to me and they've had traumatic experiences in their background. Some may be upfront in presenting them, some may not. But purpose of treatment is to get now to work better, and sometimes that requires unplugging and healing emotional wounds from the past.
And as part of your art and science, you are trained in picking up and diagnosing various cues in your effort to reach conclusions.
What? That's the worst
to
question
try
I've
and
ever
help
heard.
them.
Look, he's like, oh, I'm going to re-say this again.
I'm not following the question.
As part of your practice, you're trained in being able to observe and detect various cues from these patients, are you not?
What do you mean by cues?
Indications of areas of trouble. For example, you don't always have patients that come out and say, oh, I am traumatized because of this. Rather, they may speak in obtuse terms, and you are charged with, among other things, trying to figure out where the trauma lies and why.
I would answer that slightly different than the way that you're framing the question. So when somebody comes in to see me, my job is to understand what's not working and really what's not working in their life today.
Okay.
If that leads us to unplugging earlier trauma, which frequently it does, great. But that's the purpose when they first come in, is me understanding what's going on with them today that's not working, and hopefully saying it back to them in a way that they're getting it, that I understand.
And in that process, you rely upon various statistical manuals and things that are reflective of your profession, do you not?
Again,
I
off
don't do
question.
specifically a lot of diagnosing, so I'm not going to use the DSM frequently. I'm going to understand the background of why trauma sticks and how to get that better.
And to understand the background of trauma, have you in the past, or do you periodically consult learned treatises and periodicals, things that help you to reach that understanding?
If you're asking, do I go to continued ongoing training and development? Yes.
All right. Now, in this particular case, did you reach some conclusions about Douglas Benefield?
Objection. Qualifications.
Sustained.
Yeah, he didn't lay the right foundation for this.
Did you counsel Douglas Benefield?
I did, yes. Both Ashely and Doug.
All right. And in counseling Douglas Benefield, did you listen and absorb the various points that he was making to you?
Yes, both when they came in as a couple and then when I did individual therapy with them separately.
And when they were in there as a couple, was part of your process observing the dynamics between the two of them?
Yeah, I wanted to understand why they were seeing me and what stuff we wanted to get better. So certainly I'm paying attention to what they're telling me, how they're communicating, what they're communicating, and such.
Okay. And part of that included how they acted when they were together and how they acted when you saw them separately.
Yes, I would say so.
Okay. Now, in making those observations and questioning them and listening to them, in your effort to try and identify the objective, did you reach some conclusions about Douglas Benefield?
Objection. Foundation.
Would you approach, please?
I mean, he's not, he left an open-ended question like, you know, did you reach some conclusions? He hasn't even said about what. Well, yeah, I concluded the guy had, you know, red hair. His mom's name was Sarah, you know, like, now the judge is probably going to be like, well, maybe if you ask him, you know, blah, 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 because it's the last witness, he might just give him a little nudge in the right direction here.
It's possible. A little leeway, a little nudgy poo.
Oh, yeah, the prosecution's doing everything in their power to not get whatever the hell he once said. I mean, if it's admissions that he wants, it would be non-hearsay because it's given for the purposes of therapy. So it has inherent inherent reliability. It's or for a mental health impression, like he said, the state of mind. All right, I'll be.
Has he figured out how to do it? Let's see.
Brief deviation, Dr. Quintel. Tell us what degrees you hold.
So I have a bachelor's in psychology, a master's in social work, and a PhD in clinical sexology.
How long have you been practicing as a psychologist?
I got my master's in 98 and started working in the public school system. So since 98, 2006, I started a private practice.
And since you've been in private practice, Dr. Quintel, can you give us an idea of the number of patients that you've seen in counsel?
Thousands.
And your specialty in counseling patients runs to all three of those fields that you have degrees in?
Yes, I have a background in all of that, but my specialty is in trauma resolution.
Okay. And when we speak of trauma resolution, explain to us what that is.
So I think the first thing that somebody has to understand is trauma, or what we go through, isn't troubling because it happened, which is the conventional wisdom, is that because it was awful, it still hurts. But we're not troubled because it was bad. We're troubled because when it happened, emotionally, the brain short-circuited and doesn't know that particular experience ever ended. So where therapy missed the boat is we felt that people buried and repressed, and we have to help them process and get it out of them. Where the methodology that I use is the reverse. It's about getting the good news in to the emotional part of the brain that doesn't know it's over. Think of it more like unplugging the memory, so emotionally the brain can read it as data about something that happened versus where it's been stuck as happening, which explains why when somebody frequently either talks about it, is reminded of it, or is in something similar to it, emotionally they're transported back to that awful moment, right? If you have a friend telling you about something that was troubling them, and as they're telling you about it, it's almost as if they go back there to that troubling moment.
Mm-hmm.
So our goal is to keep the person more emotionally present as we unplug the emotional effect that the past has had.
And in that process, do you typically employ listening to patients?
Yes.
Do you typically employ making suggestions to patients?
I don't know if I would say it's making suggestions versus more kind of having a mutual outcome of how we want them to be in mind. So if I'm kind of creating a future self or an outcome, it's got to be something that they're good with, or if it shows up as conflictual, we're never going to be able to reach the outcome.
Mm-hmm. Okay. Now,
so more, instead of a suggestion, it's more of kind of a mutual outcome.
All right. And you went through this process with both Doug and Ashely Benefield?
I did, yes.
Your Honor, I would tender Dr. Quintel as an expert in the field of psychology.
Do you want to voir dire the witness?
Objection.
Do you want to voir dire the witness as to experience, training, and knowledge?
Yes.
All right.
I mean, this is wild. Didn't the state fucking call him in the first place?
Yes.
You do most of your work now in trauma resolution, correct?
I do, yes.
Okay. And how long have you done trauma resolution?
Since 2006, October.
So for many years. And you said you don't do diagnoses anymore, correct?
I don't look at diagnoses with people. I look at people, because the notion of the diagnosis will help in understanding maybe some of the background of why somebody acts, but you're really working with the person. So if somebody says to me, do you treat OCD or, bipolar? I would say I work with people, not the disorder.
Okay. So when you're dealing with, for instance, Doug and Ashely Benefield, you're not doing so in order to create a diagnosis or evaluate. I guess what I'm trying to get at is there's a difference between therapy and a diagnostic evaluation.
Yes, ma'am.
Okay. And so your relationship with them was what?
They were referred to me by another therapist, and my job was to do trauma resolution. What I was told is that both had their own trauma, and there was some stuff within the relationship, and that I was tasked with unplugging the emotional effect of those experiences.
Okay. Thank you for this question.
Maybe you have a question.
So in treating people, not the disorder, you still, though, do you not have the capacity and the training and experience to understand if a disorder is present?
Yes, sir.
At this point, Your Honor, I would now tender Dr. Quintel as an expert.
And I
Anybody
would
heard any-
object.
Same objections?
Same objection.
All right, I will rule the objections goes to weight, not admissibility. Go ahead, sir.
Thank you.
Suck on that.
So, Dr. Quintel, all right, we're rolling.
Okay.
Did you reach any conclusions with respect to Douglas Benefield?
Yes.
Would you tell us what those were?
Based on the conversations with both Ashely and Doug, Doug occurred as someone who was domineering, and the terminology that I would use at times would be super controlling. He was very dedicated to wanting the relationship to work. He was very interested, despite conversations with some of the disparaging things that Ashely had said to him. He was very much still wanting this to work, and their plans were to move to Maryland.
All right. Did you reach any conclusions with respect to him being a real alpha male? Do you recall?
I would say that Doug occurred as somebody who was very built and well put together. And yes, I would say that he would fit the stereotype of an alpha male, in my opinion.
Did you conclude whether there was an intimidation issue present?
Ashely stated that she was scared of Doug.
Did you reach any conclusion, Dr. Quintel, about whether Doug's depiction of himself as being godly was reliable?
Objection outside of expertise.
Oh,
You can answer.
Can you say that again, please?
Sure. Did you reach any conclusion with respect to Doug's presentation of himself as being particularly godly?
Yes, I think it was over the top.
All right, and did you reach any conclusion as to whether it was genuine?
I did not think it was fully genuine, no.
Did there come a time when you inquired of Doug why he would want to remain in this relationship?
Yes, I did.
Why did you do that?
Ashely had a lot of disparaging comments, stuff with CPS, claims of abusing their child, and I was concerned and curious why, with all of that negative stuff that may even negative affect his job and career with government, why he wanted to stay.
And was it true that you felt he was hell-bent on being together?
I know that he really wanted the relationship to work.
Did you conclude that he was never going to let her get away?
I don't know whether that's true, whether or not. I don't recall that.
All right, let me pass this to you and see
Please.
if it refreshes your recollection, if I may.
Thank you.
Does that refresh your recollection, Dr. Quintel, as to Doug's perception of letting Ashely get away from him?
Yes, I said that to the detective. I said it seemed more like I'm not going to let her get away from me.
referring to Doug.
Yes, sir.
All right, and lastly, Dr. Quintel. Did Ashely have anything to say to you about Doug's interest in Emerson and whether or not it was just as
Objection, hearsay.
Sustained.
Did you reach any conclusions, Dr. Quintel, about Doug's interest in the child as opposed to Ashely?
Objection, Judge.
I'm going to sustain this to the opinion.
Was there an incident on one of these occasions when Doug was in your office that you thought was very strange as it related to the child?
Objection, relevance.
Overruled as long as it's factual.
Yes.
Can you say that question again, please? Thank you.
Was there an incident that you observed that you found particularly puzzling between Doug Benefield and the child, Emerson?
Yes, at the time that I spoke with the detective, I had an appointment and Doug had waited in the reception area, and it was a couples counseling, and Ashely was out in the car with the child. And I thought it was unusual that he didn't go out and see her. Given that they had the relationship they had, it may not be as unusual as I thought, but I was coming from having two little girls and what would be in my mind to do.
And how long was Doug sitting in your office at the time? Do you recall?
Well, it would have been at least an hour. I don't know how long I was in the appointment before.
And in that hour, from what you observed with Emerson, the child, outside in the car, Doug Benefield never once went out to say.
I wouldn't have been able to observe that because I would have been in session. I just knew that he was waiting in the lobby. I don't know whether anything other than that.
That's all, Your Honor.
Cross.
So you mentioned that it bothered you, or at least you noticed when he didn't go out to see the child. How long did you observe Doug Benefield in the waiting room?
I would have seen him when I first went out to grab the client, and then would have seen him when I came back out of my office.
And because of that, you came to the conclusion that he never went out and saw his child?
Yes, I did.
Okay. And I believe, correct me if I'm wrong, in your direct examination, you said you met with Ashely Benefield alone 5 times.
Yes, ma'am.
And you met with Doug Benefield alone twice.
Yes, ma'am.
And you met with them together twice.
Yes, ma'am.
So the majority of the time you met with Ashely Benefield, over half of the times you met with her.
To do trauma resolution. Yes, ma'am.
And her discussions with you and her recitations of things played into your decision about this opinion that Doug was being domineering and super controlling, did it not?
Yes, they were comments that she made and frustrations that she had within the system.
Okay. So it was not solely based on things that you were observing in Doug Benefield.
No, ma'am.
Thank you. No further questions.
Redirect.
Nothing further.
Can this witness be released?
Yes.
State.
Yes.
All right, sir, you're releasing your subpoena. Thank you very much. There you go.
Thank you.
You go.
He's so happy to be out of there.
We published the couple of exhibits that we put in through Mr. Mizzacaro. And then I think 4 months break for lunch. I don't think that's.
Oh, that's not, yeah. Oh, you have 27?
27.
One photograph was already in,
One.
and then one we added together with the
He did it again. Didn't
Yes, so
redirect.
the
He could have
jury,
said,
we're gonna
"Didn't you
hash these
observe
out and
him?
publish
Didn't you
them.
also observe
I'm
him?
not rushing you, but I'm gonna talk while we're
Determine he
doing
was
that. I
domineering on
think
your
at
own."
this point, it's a good time for our lunch break. It's about 10 minutes after 12.
Oh boy, I'm out.
So take your time. I want you to look through all of this, look through these exhibits, and then I'll excuse you.
Exhibits 26 and
So
27.
that was the defense's last witness.
Those
We don't know that yet.
27 and 28, and they'll be marked on them. There's a little sticker on each.
Oh, they're
Which
looking.
should say 27, 28, and I think the other one is Defense Exhibit 1.
The jurors are looking at it. It's been published just now. I didn't like the defense asking that question about the kid because it kind of showed that the therapist, was putting his own kind of perception on things and thinking about things more from Ashely's. Like, why wouldn't he go out and say hi to his kid and then like drawing conclusions from that as opposed to stuff that happened in session? It wasn't even that big of a point. I don't think it was.
Yeah, I agree with that. He could have went out the entire time he was in.
Right.
Session.
That's
Yes,
even the
no.
worst part about it.
Yeah. And also, if it's like this contentious thing, I probably would be waiting myself. Like, I wouldn't want to go
Right.
out and be like cause a problem that could have.
Getting accused of some shit. It was a stupid question. Babe, ads are out of control. She's stupid thing. I don't know why that happened.
I mean, YouTube inserts them. Like I can select between balanced and aggressive, and I always put balanced. I can only imagine what aggressive ad would be like. Super aggro. What do you put them as? Jay? Balanced?
No, I pick. There's an option where you can put like how often they come up, and I usually put like the least. There's like 30 minutes, 24 minutes. Like there's a different.
Oh, you got to show me how to do. Do you let YouTube?
All right, you guys. We'll talk about that when we're done.
Yeah. All right.
Why
There,
you
look
hear
in
this?
there. Say hi.
We don't want to miss this paper rustling. That's important.
I know.
Don't want to miss it.
Who is that? Is that Ashley's rustling the papers?
So what I think as opposed to killing the stream here, what I'm going to do is I'm going to play the Down the Hill reunion since we have 3 big days of hearings coming in Delphi. It's pretty interesting. It's got the whole crew put together the Down the Hill podcast, starting with Barb McDonald. And,
All right. Well, I've got conference calls starting at 1, so you guys won't see me again. I might as well just let's see if they have any discussion here. But you're gonna play that. That's a good idea.
yeah, I mean, assuming they're going to handle some stuff in court here, it seems like.
That's a good idea. Get everybody warmed up for Delphi. I was thinking we might need to do something.
The next time you see Allie, she'll be walking the nook around the courthouse as Bob is inside the courthouse tomorrow.
Or I'll be walking the dog around the courthouse. Maybe I just send Allie. We avoid the.
No, I don't like that idea at all.
What? I think that's a great idea.
No, that like assumes something. No, I don't think so. I don't think it's an issue. I don't think it should be an issue. I think it's wrong if it is an issue, and you're gonna go and handle your shit.
Yes, ma'am. I got to record 3 ads before I go anywhere today, though. I'll tell you that.
Podcast.
Yeah.
Commercial. Sponsors. So my understanding is the jury right now is looking at exhibits that were published, and then they're going to be let go.
Yep, and they haven't
judge-
said yet.
Right. The
when-
judge might just pop off, or he might say something when they're coming back. There might be some. Sure, he's going to ask the defense, "Is that it? Are you done? When we come back, are you going to rest?" And state how many witnesses in rebuttal.
We had a great crowd so far, 500. If
Yeah,
you're new to the
awesome.
channel, welcome. We're so happy you're here. We're hoping that you enjoy the content. We're hoping that you enjoy the chat. You can tell we have a bunch of wonderful people in here. And we're not an echo chamber, and everyone stays pretty well behaved. We're pretty proud of that. We thank our mods for that, for their incredibly diligent work. And if you haven't, please sub to our channel. We'd love to have you. And if you haven't, please sub to my brother from another mother's channel,
All right.
Jay.
So it's
Depending on what goes on today,
If I could have you
closings
back
could be on
down in the
his
jury
channel
assembly
tomorrow.
room where you began everything this morning
It
and
sounds like
last week
either way.
at 1:30. Should give you plenty of time if you want to go somewhere, if you just want to walk downtown. Be in the jury assembly room at 1:30. We'll get you back up here as soon as we can to get started for the afternoon. Remember the admonishments. Don't talk amongst yourselves with anyone outside of the jury. We're doing any research on the people, places, things, the legal topics we've heard anything about. Thank you. All right, y'all can
No
have a
blue
seat.
bloops, huh?
I would
No blue
assume,
bloops.
before I let you all go, that
We
the
go anyway.
request for an exhibit list from the defense of the items that they expect to introduce has been provided,
Yes.
and certainly a list of witnesses that are expected to be called.
Yes.
I didn't get a copy of that. If it's been amended from the
Why
witness
does it
list
matter?
that I
They're done, aren't
received,
they?
it looks like it was filed June 21st of 2024. So I'll just mark, but who do we have on tap
The
for
mom
this
James
afternoon?
has bingo.
So we
I don't need to
have-
know the
Wait.
order, but just who?
We have Jason Alexander,
Hey, George
Hey,
Michael
Costanza.
Haag, Haag, Dr.
Hold on
Emma
one second. I'm sorry. I got it. My list is, okay. Michael Haag.
Michael Haag,
George Costanza.
Dr. Emma Lou,
George likes the
Wait,
chicken.
are these people who've already went, or
All
there's
right.
No.
and Warren
No.
Justin.
oh god,
Warren.
Justin.
a lot more
the
witnesses.
Lead homicide detective.
Oh, shit.
Hmm. The defense is calling the lead
All right,
homicide
we-
detective?
Have none
Oh,
of
yeah.
these, have all these folks been deposed?
It's gonna be objectionable.
Yes.
All right. Are there any objections or anything I
Right.
need to hear before, before we get a jury in and get them seated and make them
Right.
sit there for 5 or 10 minutes while I hear arguments at the bench? I would much, much rather have the objection made. Let's talk
Right now.
about it, and then let's call the jury in so it's a little bit smoother.
Do you have
With
any
Detective
objections?
Warren, I may have objections, but I don't know what's going to be asked. So without asking what they're going to ask, I don't think we can have that conversation. And additionally, if
You could make a
Detective
motion to
Gillum is
eliminate.
set to testify, I would have similar objections.
You didn't say that name.
No, they've been keeping him here, so.
Okay. You think just 1, 2, 3, 4 witnesses are going to take us the whole afternoon?
Yes, I think there's a reasonable good chance we rest today.
Okay. Oh, is this the bulk of what you're calling at this point?
Yes, sir.
Okay. Well, that would be fine, because then we could do a preliminary charge instruction this evening. Then you guys can decide if you want to do any rebuttal. Okay.
So the one request I do have, Your Honor, is for Mike Haag, who's our ballistics expert.
Mike,
We need
Mike
Mike Haag,
Haag, yes.
J-A-G.
Okay.
We need the HDMI cable to run to the witness stand so he can plug his laptop.
To where? Here? I don't understand.
Yeah, project it. Yeah, so it'll be up on the projector.
So he's going to use his laptop to project here.
His testimony, yes, sir.
I know this is the one we used. I don't know, Deputy, does that stretch to here?
We'll inquire and we'll check it out.
Oh, you know what? IT has got to come and fix my computer anyway. So can you tell them that we also need that a witness this afternoon is going to have to run
I don't know
to
why
that.
the
Thank you so much.
prosecution
And
is not
that'll
making
take
a
care of both,
motion.
because my goblins, just you know how it goes.
Tell that nerd to bring a longer
All right.
cord.
Thank you,
All right.
Judge.
I guess the only other questions they would have is there were other witnesses that were held by the defense. If these are the remainder of their witnesses, are those witnesses being released? Because they're asking the state. For the
We don't know what they're presenting in rebuttal.
Okay.
Their rebuttal, huh? Oh, somebody was nasty, they said.
Somebody was
All right. So all I'm gonna say is that, oh, hey, do it like that. Man, I already forgot. There
Was it
something I
about someone making an objection? I thought that's what you wanted.
Oh, yeah. Thanks, Jay. So I don't understand why she is waiting for a question she's expecting instead of she could have made an oral motion in limine. The judge should have said, all right, well, let's discuss what are you objecting to? What can't happen? That's what lawyers do all the time on motions in limine. We're assuming based on the evidence, they're going to put someone on to do X, Y, and Z. You want to make sure that they don't do that. He could have pushed them a little bit, and it seems like they don't want to show their hand, and it's just, makes everything take longer. But I am going to hop off. I'm going to get ready. And then I'll catch you all later.
Good
All right,
luck
babe.
with your stuff.
Good
Thanks.
hangs. Good
Bye,
hangs.
guys.
Super good hangs. All right. So I think what I'll do, Jay, instead of starting a new live, and this was actually Jay's suggestion back when we were, I think, on Read.
Yeah.
I think it's a pretty good one. So if you're not familiar with the Richard Allen case down in Delphi, Indiana, it's a crazy case. Very, 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 very toxic communities on both sides of that. Very similar in a lot of ways to Karen Reed, but different. A lot of the issues that have been going on in the Delphi case really revolve around the judge and her handling of all the procedural issues that have to be handled in any trial prior up to court or leading up to trial. And, there's just been an unbelievable, it's been mind-blowing, really, in terms of how this thing has gone. I mean, the lawyers that were handling the case were booted off the case by the judge, and then the Supreme Court of Indiana put them back on. And it's been crazy. When you're really just, we all think about the victims in all these cases always, as we should, but the trial process is always really just about the defendant, because you're trying to make sure that defendant gets a fair trial. You're making sure that the cops did their job properly, the prosecutor's doing their job properly, and that the defendant's rights are being protected through the process. And, in this case, it's been not that. It's been, and I've been very critical of the judge in that particular case, Judge Gull, with respect to how she's handled not only the docket, but almost everything that's come in front of her. I've just been in shock at how she's decided to handle it. On top of the fact that she's refusing to allow cameras in the courtroom. So at any rate, I'd say probably a little less than a month ago, I did a reunion with Dan Samitovich and Barbara McDonald and one other guest who I think was Andrew. Andrew Iden was the other host on the Down the Hill podcast. So they hadn't been together in years. So I got them all together. And it's a pretty interesting show. It should give you a bit of a primer if you know what's going on with the Delphi case. It'll probably be more of the same. If you don't, I think it'll be helpful. It's interesting either way.
Either way, it's a place to chat during lunch if you just want to
Yep.
chat with the folks in the chat.
Exactly. You can completely ignore it and just chat and not even discuss it. So, all right, I'm going to throw it up here.
What time did he say? I want to give people like if they're not on East Coast, what time did he say
Sounded
again?
like an hour, right?
Was it 1:15 or 1:30? Does anyone know in the chat? 1:30. So that is in an hour and 5 minutes if you are not on so about an hour, folks. We'll be back just so for folks. No, you're not going to be paroled anywhere. We're keeping the stream up, CJ Drake, and then so you can watch this during the break, and then we'll just come right back on. So you just stay here.
Yep, exactly. All right, so I'll throw this up. Jay and I will probably grab a bite to eat, scratch some puppy's belly.
Starbucks salami.
Starbucks salami. It's so delicious. All right, let's see. Okay, so pull this guy up. I'll close off that chat. That chat was pretty hairy. that was a chat that kept the mods really busy, Jay.
I bet.
That was a busy one. All right, so boop. All right, enjoy.
All right, guys, have a good lunch.
See you guys. I'll come back around probably 1:25. Welcome to the docket presented by Defense Diaries. I'm your host, Bob Mata, and welcome back. It's good to see you guys again. It's been a whole 2 hours since I got off the live for Karen Reed's closing arguments, and jury's currently deliberating. And I'm really, really excited about tonight's show. My friend Dan, who I'm going to bring on here in a minute, hit me up, I don't know, maybe about 2 weeks ago. He's like, hey, I've got a concept I think that you might like. We were talking about maybe doing a headline news down the hill reunion. And if you guys aren't familiar with that podcast, it was an award-winning, amazing podcast about, of course, the Delphi case. Obviously, I'm knee deep in that case in terms of following it pretty religiously. And the three folks that we're going to have on us with us tonight are equally knee deep in that case and have been for years now. So I'm really, really excited about it. And it's a twofold thing tonight. We are obviously going to be talking all things Delphi, but we're also going to be talking about a podcast that I'm very excited about because I know that the production value is phenomenal because I was given a sneak peek of the first episode. It dropped today, and it is Deviant. That's right. And Deviant is a new true crime series that dives into the dark corners of the human mind and what human beings are capable of. And Dan Samatovich and Andrew Eden, or I still screwed it up, Iden. He's like, it's like Biden, except without the B. And Andrew Iden, they tell good stories about bad people who do very, very bad things. And they're starting their project with Israel Keys, who, if you're not familiar with him, he is a fascinating and incredibly terrifying subject matter in the sense that he's kind of widely thought to be one of the most meticulous serial killers of all time, just because like this is a guy that would bury kill kits around the country, sometimes years in advance, and would kill randomly. He had no real MO. There wasn't like, he wasn't into, young, thin women. He wasn't into men. He was like, there was no MO for him. There was no set victim that he always targeted. This guy would kill kind of anything that he had a taste for at a given time. So it's going to be amazing. Later in the show, we're going to dig into a little bit of it. I'm going to give you a little sneak peek. As I said, it aired today. It dropped today officially, but we're going to listen to, at the very least, the trailer, because I think it'll be a great way to be able to prime you to go and subscribe to it and start listening to it immediately. So without further ado, I would like to bring on our fabulous guests. I'm going to start with the best looking of the bunch, which would be the one and only Barbara McDonald. You all know and love her from all of her work at Court TV. Obviously, she was one of the hosts, the writers. She's a senior writer for Court TV now, and she's an amazing human being who I adore.
Oh.
Welcome, Barbara.
feeling is mutual, Bob. It's wonderful to be here. Thanks for inviting us, and I'm really looking forward to this conversation.
Yep, me too. Me too. And then next, we're going to bring on her co-host on the Down the Hill podcast, whose name I butchered, despite the fact that I asked him right before we came on air, how do I pronounce your last name just so I don't screw it up? And then I proceeded to butcher it anyway. So that is Andrew Iden. Welcome, my friend. Welcome, welcome, welcome. Happy to have you here.
Bob, thanks so much for having me, man. It's a pleasure to be here with you and with Barb. How you managed to butcher Iden, but you're not going to butcher Semitovich.
It's
I don't know, man.
Dude, it's one of those mysteries. It's a mystery. It's one of the great mysteries.
It's good to be here, man. Thanks for having me.
Oh, I'm very thankful you're here. And then finally, last but not least, the man in the middle, the guy behind it all, the man that I love, the man who saved me in Delphi when I had no winter jacket, and he so just graciously gave me his giant parka when I was going to go stand online in 30-degree, probably less 30-degree weather. Dan Semitovich, what is up, my brother? How are you?
To see you, Bob. And yeah, the price for Bob borrowing my coat was him learning how to say my last name.
Exactly,
and
which I did, which I committed
dividends. Yeah. Thanks for having us.
Of course, man. So welcome, y'all. So when's the last time y'all kind of like reconvened and started chatting? It's been a minute, right?
Yeah, the last time I think we were all together in person was at the Richard Allen arrest press conference back in 2022. Wow. Yeah, we've chatted a few times over Zoom since then, but since we went sort of our separate ways career wise, it's been a while. This is the first time I think we really gathered together to really talk about this.
Yeah.
It should be noted though, Bob, we do still have a text chain.
Oh boy,
the text chain never went away.
Yeah, I mean, those always survive.
Right.
I mean, the frequency in which you hit that chain up probably becomes less and less frequent, but it still always lives.
It goes in waves. Every time there's a new ruling or something new pops on the docket, Barb, what the hell is this?
Yeah. Did you guys see this?
Yeah,
for sure. And all right, so I love our community here. I love, and they know how much I love them. I'm just going to warn everybody. All right. We know, we all know, everybody on this panel knows how controversial Delphi is. So I'm just going to remind everybody, mind your P's and Q's. The mods are on it. You can agree, you can disagree, you can have thoughts as long as you're civil. The second that you start attacking anybody, any one of my guests, I'm just telling you, you're booted, and you don't have to wonder why, because I'm telling you, just be cool. Like, if you have thoughts, use your words and
we
type out a nice
disagree
question.
respectfully.
That's the bottom line. Like, we're all grown-ups here. We're all classy people in theory. So let's prove it tonight, and let's have a good time. Let's have a great discussion, and maybe, who knows, maybe we're going to learn something new. I mean, y'all, these folks were in the thick of it when it mattered most in the beginning of this investigation. So we'll see how it plays out. We'll see how it plays out, but I'm really excited about it. So I kind of wanted to jump into who came up with the concept? Who was like, you know what, this is a case that I feel like we need to dig into. Who came to who sold it to HLN and said, this is something that we got to do? Like, tell us a story.
Well, I'll start it about the HLN part. So in late 2018, we had been following the Delphi case at HLN and our news shows. But at the end of 2018, there was some extra money in the budget. And some of our managers said, hey, if anybody has a pitch to travel somewhere and do a longer dive on a story, we're all ears. And so I pitched Delphi. I thought it would be a great story to get there and see the town and get that sort of first person perspective on what was going on there. And so that turned into a thing. And Susan Hendricks and I went out in February of 2019 and interviewed the sheriff and Tobe Lesenby at the time. We interviewed Kim Riley and Jerry Holman from Indiana State Police and the families. and just started really getting into the story. And I could just tell immediately there was so much there that even though we put together an hour-long special, I knew there was much more that could be done on the case. And then Dan, if you want to pick up the audio portion.
Meanwhile, elsewhere in the gigantic company that was HLN, CNN, Turner, Warner Media at the time, now Warner Brothers Discovery, my job there was to make podcasts for all the different brands that wanted to, delve into podcasting. And my background, was journalism in news. I'd spent time at CNN as well. And so, I was I made the Impractical Jokers podcast. I made Bleacher Report podcasts. And then we heard from the HLN executives that they were interested in trying doing something for podcasting as well. And so myself, a couple people from my team met with some of the HLN folks, and we talked it through. What stories should we do? And there was this story, and there was that story, and there was this story. And then they said, how about Delphi? And I'm like, wait. Yeah, I only had a very cursory knowledge of it at that point. I said, is that the one with the guy on the bridge? I'm like, yes. I'm like, that one. And it just sort of developed from there. And everyone was sort of, enthused about this is a story to tell that we think would be, capture a lot of people's imaginations, that there's a lot of fertile ground to till. And, so everything I just said sort of married everything with everything that Barbara just said, and Andrew was looped in at that point also as someone who was interested in, working on an audio project.
Hold on. I'll tell my part.
Andrew was out on the street begging for scraps.
No, this is Barb spent a lot of time working with all us, separating Dan and I because we have a tendency to bicker like brothers.
Absolutely,
like Allison and I.
Yeah, exactly.
Yeah.
So in 2017, I started a podcast on my own that was completely non-true crime related, but I had been in HLN for a long time, and I had kind of banged on the table a couple times with the folks in charge of, like, if we're doing true crime, we've got to do something in the audio space. Like, there's like us not doing audio is like a complete shirking of our responsibilities. And so, like, I pitched it a bunch of times and it just never went anywhere. And then, like, a year later, they're like, oh yeah, by the way, we're going to do this thing. And it was like, I was like, okay, great. Finally. So they're like, we're going to do Delphi. Barb's obviously one of the network leads on the editorial side. The story from TV as well. And then Dan, they kind of put us in a room and said, figure it out.
Yeah, we figured it out. And the problem with, after we got the green light and we're like, okay, let's all get in the room, let's figure things out. The thing we didn't consider at the time is it's tough to tell a story without an ending. And it's tough to tell a story without a lot of details, right? Because at this point, we're talking 2019. We knew nothing about the crime scene. We knew very little. The new direction presser had just happened where, maybe he's in this room, the big dramatic Superintendent Carter speech. And, that's really all we had. So we had to try to find, we may have reconsidered it had we thought it through that much, but we were in it to win it at this point. And, we're like, what's a story that we could tell that would actually be useful? So we just went to Delphi and just started talking to the people in the town and the families and the people who knew the girls and, the people who work the law enforcement, first responders, the people who were connected firsthand to the story. If you can't tell the story of the crime, you just try to tell because you don't have the details. And while we were trying to work to get details at that point, police, and they still are very, very, as we know, reticent to say anything, right? Anything we've gotten has come through leaks or wonderful reporting, particularly from one Barbara McDonald. We'll get into some of that later. But, so that's sort of the product of how Down the Hill developed over the first couple episodes. Then we started getting more news. We were able to find out there were signatures at the crime scene, although we weren't able to find out what they were. And Andrew always put together the metaphor he always used was Delphi, sort of a painting with spots missing. Actually, I always mingle your metaphor, right? The blank spot.
It's close enough. It's been a while. I can't even remember at this point, but yes, it's basically like a painting where you can see parts of it, but there are huge black spots. Or like if you're watching a movie and the movie just cuts to black for 5 minutes at a time, and you're supposed to piece together the narrative of the movie without having huge chunks of the plot.
Right.
Yeah. And my thing about podcasting, which is my first love, I mean, I left practicing law because I'm a storyteller. by nature. I mean, that's the one thing that being a trial attorney gave me over 20 years of trying cases in front of people, was to learn how to tell a story. So like many of us, Serial was my first introduction to true crime podcasts. And I was like, wow, I've always been an auditory guy, and just the kind of unencumbered ability to be able to tell a story where that things don't necessarily have to end on the cutting room floor because of time restrictions was so incredibly attractive to me, that is really what drew me to this genre in terms of podcasting. And like when you guys put together Down the Hill, and that was my introduction to the case, because I was not covering the case prior to an arrest, because I just could not get involved with all the craziness that was going on, like you get in any high profile case that happens in a world where the internet exists, in a world where internet sleuths exist. Like when those two things exist in the world, you are going to get a toxic mix, because everyone on the planet has a voice, no matter whether or not they have sense enough to be having a voice and should be airing it in public. It matters not, because the internet has given that to us, that gift and that curse, to where every single person can puke out their thoughts, no matter whether they're valid or invalid, for the world to see. So, I loved the podcast. I thought it was beautifully done. Of course, the production value was off the charts. The writing was phenomenal. And I loved the concept of you being boots on the ground out there and just giving us that flavor of a case that we just weren't getting anywhere else. So it was such a well done podcast, and it really was my entry point into the case. So for that, I'll always be thankful to, because without that primer for me, I would have been starting from scratch, and there wasn't much out there other than kind of, digging around online.
Right. Well, and that was part of our purpose, right? It was an unsolved case, and let's bring some awareness to this case. I mean, you've got this video of this man on the bridge. You've got this audio of him saying, "Guys down the hill." Like, surely if we get that to enough people, we're going to end up with an arrest, right? Which was certainly our goal. Didn't quite play out quite that way, but I mean, we did get to an arrest.
Yeah, when we kept saying throughout, especially in the early episodes, we're not out to solve this, we're out to understand it. And I think part of what was behind that was, well, I mean, how can we solve it with so little information, right? There's just guesswork at that point. Another part of it was, the CNN's editorial stance at the time was, we don't solve crimes, right? We report on cases. And another part of it is, I mean, I guess that's really all we felt we could accomplish. But as we kept going, as the episodes kept going, we started getting more information. And then we didn't say it on air, but we had this little room at CNN Center. We called it the War Room. It was sort of this glassed-in fish bubble of a room with a whiteboard that we would do all our doodlings on about theories and whatnot. We start to think, maybe we can start to make more actual sense of this. Maybe we can put the pieces together in a way that's more useful. Than maybe it remains to be seen. And our first season of 9 episodes, the last episode 9, sort of gave our theory of the case, of what we think happened out on the bridge that day. We had someone we liked for it at the time. We were totally wrong in retrospect, but I think for the facts of what actually happened, I think we were fairly on as far as the movements of the bridge. Then we went away. We came back, a few months later for an episode 10, and then we took even more time off, and then came back for episode 11 when the Richard Allen arrest happened. But the entire time between sort of those long periods of times, we were constantly trying to dig up new information, especially Barbara. Barb never let go. I was given another assignment. Andrew was given another assignment, but we were never far away from this. But Barbara was really the lead on this. And we actually recorded an episode that never made air.
I like that.
And
The vaulted episode, man.
I guess we could tell the story and sort of the backstory of it, but it was, I'll just say it was our Ron Logan episode. And that has sort of an interesting, this would have been an late 21, right, Barb?
Yes.
When we did this?
Yes.
Yeah.
Definitely wintertime because it was freezing cold when I listened to it.
Right. But
Yeah.
it actually started in August
Right.
of 21 when Barb had made a visit to Delphi. And I'll let Barb pick it up from there. It's your story to tell, and it's an amazing one.
Well, I don't know how deep you want to get into any of this, Bob.
Deep. I want to get super, dude. I am a deep diver, Barb. You know that.
So-
as deep as you want to get.
I was interested in talking with Ron Logan. Over the years, I had tried numerous times to talk with him. The first time I met him was my first.
The Barb
How-
just freeze.
Right when shit's about to get real.
You froze for 2 seconds. What a tease.
Luckily, it was like it was like an attractive freeze. It
Oh
wasn't
my
one
God.
of those things where I'm looking
Not like, yeah.
Yeah.
But anyway, so I had first met Ron Logan in 2019 when we were out there. He told me flat out, I don't like the media. I'm not interested in talking to the media. And that was sort of his position for a long time. Every time I would reach out to him and ask, can I at least come onto your property and look at the crime scene? Will you walk me down there? All that kind of stuff. And he was no, 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 no. And then in 2020, when we were working on the documentary to accompany the podcast, I was with our director of photography and we were in Delphi. I think Drew had already headed home. And we thought, what the heck, let's just run by his house and knock on the door and see if he'll talk to us. And so we did. And he didn't want to talk to us, but he said, I'll walk you down to the crime scene. And so we were able to get video. That was the trip that he said, I absolutely don't want to be on camera. So we didn't put him on camera. But as we were trying to get down the hill, it is rather steep from his property down. I was struggling. He came over and put his hand out and steadied me and led me down to the area he identified for us as where the bodies had been found. And then heading back up, it was the same thing. He, said, come here, and grabbed my hand. And he was, at the time, he was 80. And he was very, very steady and very strong. But he said, absolutely not. I'm not going to talk to you. Then I decided I wanted to look into writing a book on the case. So I reached out to him again and said, hey, I'm going to be coming back to town. I'm thinking about writing a book on the case and I'd like to hear your story. And he said, your book must be about sex. And I said, what do you mean by that? And he said, well, you want to talk to me about how Carroll County screwed me. And that was sort of the beginning of our relationship. We started texting after that. I went to visit him at his home. That's where he gave me the probable cause affidavit that had been written by the FBI. That it was a really bizarre situation because he said, you're going to laugh your ass off when you read this. He said, it's just hysterical what they wrote in here. And so we were sitting out in front of his home. It was a really hot August day. And he handed me the document, but he didn't let go of it when I grabbed it. And he said, promise me that as you read this, you're going to call out all the funny things that you read so that we can laugh about it together.
Wow.
And if anybody's familiar with that document, it's not a particularly funny document. It spells out a lot of very what seemed like very valid reasons that the FBI had to believe that he was the killer and want to search his home and property. And so that began just a really unusual relationship with me talking to Ron on a regular basis for about 4.5 months about the case, about that document, about the lies that he told, about his relationship with Carroll County, his relationship with the families of the girls. And I definitely found that he wasn't a very truthful person. There was a lot that he lied about.
And so I want to walk it back a little bit, kind of like for the bones of the profession of an investigative reporter, because I've always found that to be such a fascinating profession. Because especially in a case like this, like you had to build relationships with anybody that you could, because the best way to be able to cull information from people is by getting them to trust you as a human being. And like that's how human beings are, like and so you have this task where you're like, all right, I'm going into this because I'm gonna try to root something out. Like you want to try to root some information out that other people have not figured out, and the way that you do that is by creating these relationships. And like you've taken grief like over the time that I've known you, like, and I always, like, if I become aware of it, I always come to your defense because it's fucking bullshit. Like you're a person that's just doing her job and always have been, and done it very well. And and I just know how brutal this particular true crime community with the Delphi case can be, but like how do you do that in terms of, because understanding like, all right, I've kind of created a relationship with law enforcement, and then as we progress through this thing and you're like, oh man, the same guys that like I've formed like a somewhat of a bond with, and there's somewhat of a trust between the two of us. And now I feel like I need to kind of say something derogatory. Like, how do you handle that kind of stuff? If like, especially when we fast forward to when the arrest is made, and everything starts kind of like coming together, and you're having to think back on all these relationships that you have with people, and they're tender, and you don't want to burn bridges because those are sources. You know what I mean? How do you
not only that, but I pride myself on being a very honest person and being very upfront with people, and being honest about what I'm doing and what I'm seeking. And yeah, a lot of the criticism has been really difficult. I've been accused of a lot of really crazy things that, like you said, I'm just doing my job. And, I think in not only with Delphi, but we see it a lot with Karen Reed, right? Which you've been covering a lot of. People take opposing sides, either she's innocent or she's guilty, and they're so entrenched in that belief that there's no room for a conversation about it. And for a lot of them, they start losing the respect that other people can see things differently. And it's so amazing, like watching the Karen Reed case from afar. I haven't dived into that the way you have, but to see how people are just criticizing people for just reporting, like, this document says this, and people jump out like, no, literally, this document says this.
I'm a glutton.
Yeah, and
it's the same shit that I've taken on Delphi, wherever, and it's like, like like I've taken the same beat. I've had podcasts where they're putting out hit pieces on me saying that I'm literally a paid shill for the defense, when all I've ever done with that case is literally read the documents and be incredibly offended that this guy's constitutional rights are being shit on. That's been like my, you know what I mean? Like that's where I've been with this case. So I feel your pain. And what the thing about Karen Reed and Delphi, the similarity, the one thing that connects the connective tissue into what has created these two toxic environments is the fact that the defense teams for both of those defendants came out in full blast, put out their third-party culprit defenses for the world to read. And it doesn't happen in cases. It does not happen in cases. I've been practicing a long time. I cannot remember a detailed filing by defense teams where they're laying out their entire theory of the case. Hundreds of pages in both of them. And they laid them both out. And if people find them to be either insane, or they find them to be incredibly compelling, that's where you get these two sides that dig in, which creates this this warlike atmosphere. I mean, it's crazy. And like those of us that are stuck in the middle who are just truly trying to report on what we're seeing. I give my observations as an attorney. You give your observations as an investigative reporter. And like, we're just getting hammered from every side as if we've got an agenda. I don't have any damn agenda.
We talked about this, Dan and Drew and I, earlier today, that, we don't know if Richard Allen is guilty or not. And if he is, we don't know if he acted alone. But we want to see it play out, and we want to see it play out in a court of law and following all the rules that everybody has to follow. And let's see what happens and what the jury decides, right? I was listening to the judge in the Karen Reed case today, and she was talking about how, the jury is the ultimate arbiter of what is true. So it doesn't matter what any of us think about what the prosecution says or what the defense says. Ultimately, at the end of the day, it's what the jurors believe, which witnesses they find credible, which evidence they find credible. It's not about our opinion.
Exactly.
And you said, possibly with someone else, whether Richard Allen was involved or not. That's the gong I keep banging. I keep coming back to Nick McClelland saying in open court, we believe we have reason to believe there are other actors involved with this. We have Tobe Lesenby saying it in that Franks memo that this took more than one person. Where is this other person? What does the search for that person look like? Where are we with that? We haven't heard a thing about that.
Right.
I've always, when I talk to people about this case, they say, what do you think's going on? And it's sort of couching it, but it's genuinely the way I feel, which is the full story of what happened to those girls does not begin and end with Richard Allen,
right? Even
if he is guilty. Like it is the tip of the iceberg. I don't know what the rest of the iceberg is. But there is something else to be said. And like Dan said, I mean, Nick McClelland said it in court. Tobe Lesenby said it in the affidavit. It's like, there's something else here. We've got to get to what that other part is, though.
It's such an important point, because like when that PCA dropped, and it dropped, I think about 2 months prior to Koberger's PCA dropping. All right. And we have now entered the world of where people actually give a shit about probable cause affidavits. They've been a part of my life for 23 years. I've been reading probable cause affidavits forever. And, that is essentially where the case is being laid out by the prosecution and or law enforcement and or both in terms of what their evidence is at the time. And, I had read the PCA in this case, and I was stunned by just the weak nature of it. Like to me, it amounted to nothing more than mere presence and a specious. I can't even call it actual science, because just an unspent round being cycled out of a weapon is just not evidence that has been used as the primary piece of evidence to convict anybody in this country.
And now we know more about how that round was recovered, which is the chain of custody for that is just, I don't understand how something like that happens.
Right. And that was my whole thing. And people mistook my comment that, look, I think it leans innocent. That doesn't mean that I think that he is innocent. Mm-hmm. I'm just saying, based on my career and what I've done for a long, long time in terms of strength of evidence, it reads weak. And they're going to need more in order to prove beyond a reasonable doubt that this guy is the guy. And that was all I was saying. And people just ran with it like I was a Richard Allen apologist. And that's just not the fact. Now, when we move deeper into it, then I become very defensive in terms of his constitutional rights moving forward, and the fact that I am a defense bar lawyer. I have been a defense attorney my entire career. We are a weird little tribe nationally, and we really do. We have each other's backs because we are collectively fighting the immense power of the government. That is what we do for a living. And that's just the reality. So if I feel that I need to bolster up a couple of defense attorneys that I think are getting hammered, I'm going to do it, and that was always my thing with it.
And we all want to have confidence in whatever the verdict is, right? And 100%. The way that you get to be confident in the verdict is that the process was followed and that his rights are protected to the extent they should be. by the law as the defendant in this case. But, as we've been talking about, there's a lot of unanswered questions. I went back and looked at transcripts from those first interviews I did in 2019. And even then, law enforcement waffles on, is it one person? Is it two people? Sometimes they sound more confident that it's one, and then other times more confident that it's two, and they go back and forth. And, the other thing with the prosecutor filing this motion in limine that he wants to ban certain words from the trial, I kind of feel like you need to address Kegan Kline and Ron Logan at the very minimum. You guys are the ones that put that stuff out there,
Yeah, Ron Logan, I'm not here to argue that Ron Logan was a part of this crime, but I do think he was a part of this story. And the reason for that is if you read that probable cause affidavit, the one thing that you can't explain away is he was inventing an alibi, proactively inventing an alibi for a crime that had not yet been discovered 12 hours before that crime scene was found. Why? There are three reasonable explanations. One, he was a part of the crime. Two, he helped cover up the crime. Or three, which is the one I lean towards, he was a witness. And one thing what we learned about Ron Logan over the years is that he had a persecution complex. He always thought the police were out to get him. So, especially with knowing what Barb knows from his conversations with him, I very easily see a world where he thought, I'm not saying anything. I'm not helping these motherfuckers.
Right.
Right.
That was the type of person he was. He's dead now, by the way. He died of COVID in early 22. But when at the Richard Allen arrest presser, when they were announcing an arrest, when we heard the name Richard Allen, our first instinct was who?
Yeah.
And my second instinct was, well, where does Ron fit into this? And so that was my first question when it was time to go talk to law enforcement after the press conference was over. I talked to 2 or 3 Indiana State Police, and I asked them, how do you account for Ron Logan inventing an alibi for a crime that had not yet been discovered, and beginning the creation of that alibi at the very time when that crime was being committed, right? He was piecing out over to that fish store by 3 p.m. And all the answers were some variation of, that's one of life's mysteries, that's not something we can explain. So, obviously the party line at that point still is that Richard Allen was solely responsible for this, or partly responsible for this at least. But yeah, the story of Ron Logan, whatever that is, whether it's witness or something more, I think is something that has yet to be told and fully explored.
Well, especially when you look at it in light of the fact that, I mean, the guy was sitting on a DUI conviction. You know what I'm saying?
Multiple.
Like he's putting himself he's putting himself in peril with his own alibi. You know what I mean? It's like that part of it never made any sense to me in terms of.
Well, no, the original alibi was that his cousin drove him.
Oh, is that what it was?
Yes. Yes, that his cousin came and picked him up and drove him, and that was a lie, as well as what time he left.
I believe he called his cousin at 8 p.m. that night and say the evening the girls went missing, the February 13th, and said, "Say I was with you and you picked me up at 3 p.m." It's a very specific request.
It's a very specific request.
And the cousin had said that never before had Ron ever asked him to lie.
Right. It's just the Logan thing is always a weird thing for me,
Yeah.
And it's like, I mean, the fact that the girls are discovered on his land will always have him floating around in my psyche is somehow, being a part of this thing one way or another. I have no idea if you had a hand in it, but it's like to know the lay of the land over there.
And during when we were making the show, I mean, the three of us, we went round and round and round about Ron. On Monday and Tuesday, it was like, wait, there's something fishy here. On Wednesday and Thursday, it was like, I don't know. I think he was just an old guy that just a shitty situation that this happened on his property. And then next Monday we just went round and round and round constantly about it.
And we did try to, especially Barb, like I said, we put together a show, right? And that November of 21, we had received word that perhaps there was going to be some action on the case. And so we were thinking they're about to come arrest Ron Logan, right? So Barb and Andrew actually flew out to Delphi, staked out his house, waiting for the cops to swoop in. Nothing happened.
Yeah.
It turns out that and while that was happening, I was back here in Chicago putting together the show with 3 potential different endings for how this thing could shake out. Getting ready to edit the right one together, and put in the and do some new tracking and do some new writing based on what actually happened. Turns out that entire action was around the Anthony Schatz portion. But yeah, in the entire time of that, we were trying to get the Unified Command to tell us, give us some comments about Ron. And, Barb finally pried something out of him, in early 22 when we were trying to, find a way to air this reporting. Because at that time, again, no one knew who Richard Allen was. He was on no one's radar,
Right.
not even law enforcement's radar at this point, right? So, we had the Kegan Kleins of the world. We had the Ron, these were the names floating out there. And so we were trying to get some kind of response.
Well, and one of the reasons we didn't report a lot about Ron Logan, he's barely mentioned in the podcast, is because CNN, we were all employees of HLN and CNN at the time, and they had a rule, it was a standard that they required of their reporters, that you not talk about people who are not named a suspect as if they are a suspect. And so even though Ron Logan eventually spoke to me voluntarily many, many, many times, and he believed he was a suspect, and we had this probable cause saying that at least in April of 2017, they believed he was the killer of the girls. That wasn't enough for us to be able to focus an episode on him or really to include him much in the podcast.
Yeah, a little behind the scenes action. And law enforcement knows how to play this game, especially with, I consider that, CNN to be, as frustrating as it was to not get that episode out, it's a great editorial establishment. It's conservative on the editorial side. It's there to protect us, the organization, the news gathering,
Right.
the reputation, right? And so the standard is the police must say he is a suspect, use those words, or a person of interest, use those words. If they don't, you can't call the person that. And, that police know that when it comes to CNN, at least.
Right.
But, after pressing, was it Holman, Jerry Holman?
Yes. So I ultimately had a conversation after Ron's passing that started with Superintendent Carter. He said, I'll have you talk to Jerry Holman. And I said, just like, what's the deal with Ron? Like, just say, if he's not the guy, like, just tell me, like, he's not the guy. And he's like, he absolutely is somebody who, I'm forgetting blanking on the words. I just used them earlier.
And continues to be,
or always will be somebody who could have done this.
Yeah, right.
And, after Richard Allen was arrested, Superintendent Carter was asked at that press conference, so does this clear Ron Logan? And he said, no, it not only doesn't clear Ron, doesn't clear anybody else. So what are we to make of all that?
What are we to make of all that? That is just that nagging question that just drives me nuts. I mean, when you've got, look, and it's a double-edged sword. You've got this arrest that they've made. You hope that it's a guy that they actually have some more evidence on, more than what we've seen. But you've also got them talking out of the other side of their mouth with respect that there's more of them, which to me, okay, good. Then that means you're still investigating. I am not getting the sense that they're continuing to investigate. Now, am I privy to their investigation? I'm not. But I know that they're preparing for trial, and that when they have their powwows, I hear about it via tweets or all other kinds of way. They're all the Unified Commands, all in Carroll County. There's 40 cars here, like you hear about it. I'm not getting the sense that there is actually any continued investigation into anybody. That's the sense that I'm getting. And the fear is that if Richard Allen turns out to be not the guy, and the state just can't meet their burden. And look, at this point, we have God knows how many confessions by Allen. The defense is going to challenge those because of the conditions of his incarceration are barbaric. They just are. Like, I get it. He's a pretrial detainee. People are like, good, I don't give a shit. He's a child killer. Why? He's not any of those things until he's convicted.
Right.
That is
Couldn't
the
agree more,
fact.
man. Couldn't agree more.
Absolutely. And, you know, one of the things that we were talking about earlier today with regard to the confessions is this is something we have talked about amongst ourselves for a long time, is that well, I'll let them voice if they agree with this, but I don't believe that that there's really enough physical evidence to convict anybody of this case on its own, and you need a confession. And I think that's something.
Yeah.
I think that's something that they have, you know, they've run into dead ends with other people, and I think that's part of why they can't clear them, is because, well, you know, we don't really have enough here to be able to clear these other people. But that is kind of problematic if you're going to say it's Richard Allen. Okay, well, if it's Richard Allen, how is it not Ron? How is it not Kegan Kline? How is it not, you know, a number of other people who've been named? And certainly the names that the defense has thrown out as being potential third-party suspects.
I used to say in our war room to ad nauseum, I would say the thing that separates this case from all the other cases I covered in 20 years at HLN in the true crime universe is that this case can literally be whatever you want it to be. You can make a formidable argument for whoever your person is, for whoever you think did it. You can make a formidable argument that Richard Allen, Ron Logan, any other name. And, you know, that's one of the really baffling things about this case, is that it's like, choose your own adventure. Whatever you want your case to be, there's an argument to be made for it. It may not be completely strong, but it's also going to be incredibly difficult to disprove too.
I think that goes for
Scares
not
the
just
fuck out of me, by the way.
It should.
Yeah.
If you're,
yeah. And I think another scary part of that is that it's not just us feeling that. It's not just the people watching this feeling that. Law enforcement has their own factions that believe different things and different theories. You saw some of that in the Franks memo. We know that that's also the case, with other suspects as well. And, if the police,
there are still law enforcement officers who worked the early days of this investigation who are convinced it was Ron Logan. There's a camp that believes it's the Odinists. There's a camp that believes that it's somebody else,
There's a camp that believes or wants it to be Richard Allen.
Right. Yeah, there's camps for all of them, and my thing is, when we look at the state of where Allen's at right now, and we look at where the evidence that has been presented to us through pleadings is right now, when confessions become their strongest evidence, which is apparent to me by far their strongest evidence at this point, that scares the hell out of me. Because when you look at it in conjunction with the fact that we have a pretrial detainee who is supposed to be housed in a county jail, who defense counsel came in and said, we can house him in Cass County. We've got the Cass County said, look, we don't want him, but we could take him, and the judge says, you know what? Nah, I'm good. I'm going to keep him in a prison with the worst of the worst.
Hours away from his counsel and family.
And everybody, like, just completely cut off from everybody, like having no real human contact with anybody that would be any kind of semblance of a support system for this person. And, people that just refuse to accept that will absolutely destroy somebody's psyche, on top of the fact that he's 23 hours a day in segregation, is full of shit. Like, and I'll just flat out say it.
Well, and also, Bob, I mean, for the people that think that, I would urge them to think for a second, what if this was your brother, your husband, your son? Like, if he did this, then he, by every stretch of the imagination, he deserves every penalty that's given to him.
100%.
But the man also deserves the rights that he's afforded. And if it was your son, your husband, your brother, whoever, you sure as shit wouldn't think that. And that
Right, and
that stuff gets me worked up. It really does.
Me
man.
too, obviously.
And it's
We're
not
cut from
fair
the same
to,
cloth, Andrew.
it's not fair to Abby and Libby either to convict the wrong person. So, in order for them to get justice, we need to get the right guy behind bars. And maybe that guy is Richard Allen. Maybe he is. And maybe when we get to trial, the prosecution's going to come in and lay some stuff down that we haven't heard or seen. And we're going to be like, oh, wow, okay.
Actually, this is a question I have for you, Bob. And everything that we know about the case against Richard Allen comes from the filings, the improbable cause, and the things we've seen. How much if it's just from a trial strategy, I don't know if how much could they be holding back? Like, do they have to put everything in the PC, or can it be they hold surprises for trial?
No, and you would not believe the epic debates that I had on Twitter regarding probable cause affidavits, where people that have never tried a case in their entire life, I try not to be that prick on Twitter, shut the fuck up talking to me. You haven't tried it. You never walked, into a courtroom the day in your life. Like, how are you questioning me? Like, the reality is that most PCAs in a case like this are written by a prosecutor, not a cop. So I can guarantee you, Nick McClelland wrote that PCA. Now, does that mean that Liggett wasn't in the room? Yeah, well, I mean, the lawyers understand what they need to meet in terms of burdens in order to say, okay, this is what I need for probable cause to get a warrant. They're not going to leave that to a cop in a high-profile case. The lawyers have gone to law school. Believe it or not, cops don't know jack shit about the practice of law. They don't understand that their job is to enforce it. Okay, with the lawyers then go in and try to figure out, okay, well, look, do we have the right guy or do we not have the right guy? We're handling the judicial side of it. So they're going to put their best foot forward, meaning that they're going to put the strongest evidence in there. And there's for two reasons that exists. Number one, everything's getting tendered to the defense anyway in discovery. Yeah. Number two, this is the opportunity for the state to put their theory of the case out to the public at large, for the public to stew on for years. You think they want to roll a turd out there and just let the media run with it for 2 years? They are going to put their strongest, because there's no detriment to them. They're not surprising the defense with anything.
Right. They have to hand it over in discovery anyway. Right. Yeah.
But what if they don't think it's a turd?
Well, I mean, you know what I mean? Like, said it all. He's like, we had a judge sign off on the arrest warrant. That he just kept answering the question like that over and over and over. Well, a judge signed the arrest warrant. Do you think it's a strong evidence? Well, clearly they had enough to get an arrest warrant. The judge and getting into Diener and why he recused himself so mysteriously right after all this takes place is just we'd have to spend hours on trying to dissect that and figure out what happened there. But they're going to put look at our most recent, and they use bail applications in New York, but look at the Huerman shit. Like, does it seem like they're holding anything back in the Huerman bail applications? They are laying that case out against
even Koberger. I mean, the amount of detail that was in Koberger's.
Yeah. Right. And that's coming under heavy attack right now. It's like you look at that at first blush and you're like, well, shit, in comparison to Allen.
Right.
Allen's hot garbage, but now you've got Ann Taylor, who's fighting the hell out of that, who's challenging the IGG stuff and saying, look, so that's yet to be seen, but that is the battle that takes place before trials. And I try to tell everybody that listens to my podcast, the war in every single case, the true wars are fought in the pretrial motions. That is what determines what's going to be inadmissible and admissible at trial. What you're seeing at trial is the end game. That's it. Right. And you're seeing what the judge has decided they are allowing and is proper pursuant to the rules of evidence to be admissible. That could exclude huge pieces of evidence that for whatever reason have been barred from being introduced. So it's like those kind of things you just have to I love the fact, because and Barb, you can attest, when did Court TV finally start airing pretrial motions? This is recent vintage shit.
I'm still new with them, so I can't answer that.
Like, but headline news. So like they just have
Yeah.
never been aired. Like they didn't.
No, and
like, they were
that's
not.
what, one of the attorneys who's an anchor at Court TV, Julia Janae, that was something that she said, is that all of these motions are the most significant part, because this is going to set the rules of the game, what can be said and what can't be. And yeah, you're right. I mean, it is a significant part. I mean, even today, listening to, the jury instructions in the Karen Reed case, like, that's important too. What is the jury told, and what is the language that they are given?
It's everything.
Right.
Jury instructions are literally the guidebook that they hand these 12 people that are going to go back and deliberate when they're sitting and they're like, okay, well, what do we need to figure out? They're literally flipping through the jury instructions.
Absolutely. And I think, I might be one of the rare journalists in my position, but I have been called to jury duty multiple times. I've been picked for 2 juries.
No shit.
The first one was a criminal case. It was a kidnapping and sexual assault. And more recently, I got picked for a case in Gwinnett County that was a medical malpractice case. And I was the foreperson on that one. So, both times just gave me such valuable information about how juries think and how they approach the task. And I know a lot of people bitch and complain about getting called for jury duty, but I mean, I really do believe it's our civic duty. Like, we owe that to people, because you don't want people who are pissed off about coming to jury duty if you're the one on trial, right? And it's such a process.
I feel like wrapping you in a big constitutional blanket.
I was about to say,
it's so true.
I was about to say, if there is one person, if there is one person on this earth who should be the foreperson for a jury, it is Barbara McDonald, without question.
I would have killed to have Barb McDonald like sit as a potential juror on any of my trials. That's all you ever ask. All I want is them to be honest during voir dire. I just need to know, like, if you have a predisposition, that's fine, but tell me about it, you know? And like you said, what I tell people all the time, I'm like, I know that you're dreading the concept of jury, but it doesn't matter what type of case it is. When you get into the minutia of any case, it is fascinating. And every juror, like every jury trial that we ever did, I never walked out of there thinking that the jury didn't like take that civic duty so seriously from start to finish. Like I never felt like the jury let me down, no matter what the verdict was. I felt like they were always attentive. I felt like they applied the law and they took it seriously. And it's like the trappings of the courtroom just kind of overtake you. And you start to feel the weight of it, even in civil matters. Civil, we're dealing with money. Criminal, we're dealing with liberty and freedom and sometimes life. So the gravity's different, but you still feel the weight of it when you're in that room.
I feel like in the cases that I've covered over the years, I also feel like there's sometimes where a jury will get too cute, and it's almost like the jury instructions are overwhelming and they overthink what they need to do. And the case that always comes back to me when I think about that is Casey Anthony. And people say, how did Casey Anthony get off? And I'm like, because the jury got cute. They overthought. That what they did is they moved beyond just common sense and rational thought. And they were swayed by like overthinking things. And it's like, no, it's not that complicated here.
Right.
And so they got cute. And as a result, it ended the way it ended. But
yeah, and it's like funny. I was writing my episode for my Garcia season, and we happened to hire Werner Spitz, who's passed away recently, who was a preeminent forensic pathologist in the world, and happened to be, the defense's forensic pathologist, and he was really instrumental in getting that verdict because of what you're talking about, because his whole testimony about the tape, the duct tape, and the fact that he was claiming that he got on the stand and he said, look, what would have happened had Casey still been alive when that duct tape was applied to her is that there would have been skin when it was ripped off. And that was like a lot of people credit that testimony to being kind of the critical testimony that swayed the jury to thinking that this was all post-death, that everything that happened with Casey and Kaylee was after death.
Right.
Like, I happen to think differently on that case, just because of a lot of shit. But again, that's one of those cases that'll always kind of be out there. And I tell people all the time that the fact of the matter is it's very rare, despite whatever the verdict is, that these cases don't live in the gray. Like cases that are circumstantial, which is a vast majority of cases, are always going to live in the gray because it's just not a black and white situation.
Right.
It's one of those things where, like, I'm always on the fence with shit. Always. Like, I'll be on the fence. Like, I sat through 30 days of Karen Reed. I'm on the fence. I mean, do I see a world still? Like, I've heard all the evidence now. I've heard everything that they put out. And there still exists a world in which I could see that Karen ran into him. They never had me on second-degree murder.
No,
I never thought it was intentional. But do I see a world in which she could have backed into him and maybe like not realized it? Absolutely. Do I see a world in which she could have backed into him and maybe thought that he wasn't really injured? Like, maybe. And do I see a way that he could have gone into that house? Like, maybe. It's like, and it's hard for me to get to like a cover up that's going to involve 8 to 10 people, because that's a shit ton of people to keep quiet for a long time. That's facts.
Right.
Like that is facts. It's like, it's not the task that he had gone in and that something may have happened. That's the easy part. The hard part for me to wrap my mind around is all of them keeping quiet in perpetuity, and to sit there and watch a woman go down potentially for something that she didn't do.
Well, and the keeping quiet is an issue in Delphi too.
Yeah.
If Richard Allen didn't act alone, why not come forward and say, hey, get me out of this place I'm in. I'll fess up about whoever else was there or who planned it with me or who helped me after the fact, whatever the situation is. I mean, there's so many unanswered questions.
And if Richard Allen isn't the person who did it, and there are multiple people out there who did, it's almost a mutual destruction pact, for anybody to say anything. If you say one thing, it's almost like to drop a dime on someone in that case, you're almost incriminating yourself at the same time. So, there's no incentive to do it. No reward's going to do it, because you're going to jail too.
Oh God. And look, like Barbara, especially, I am sure that your DMs look a lot like mine. And my
DMs that
DM,
I just want to close it all up and say, I'm never getting on social media ever again.
Barb, that was a world-class eye roll.
Oh man.
That was 5 stars, no notes.
Well, and what's so I guess frustrating about it is, I want to tell good stories. I want to give some perspective. I want to help people understand what happened here. And I'm not playing games, and I'm not out to support anybody for any reason other than I believe what they're saying or what the documents say. And sometimes that leans towards the prosecution, and sometimes that leans towards the defense, and sometimes it leans somewhere in the middle where I'm not sure, as you said, Bob, if anybody's even there anymore in the middle. But, there's a lot we still need to know about what happened. And maybe when we get to Richard Allen's trial, we're going to get the rest of that story, and we'll come away from that trial going, okay, we know what happened. This is what happened, and this is who did it. And I hope that's the case, because this has just got to be brutal on the families. They're under a gag order. They can't talk. I know that some of them are struggling, and it's and even Richard.
All right, we're back. I think we should be getting back from lunch here any second. So I'm going to switch back to. Hey, what's up?
What's up?
I just heard you breathing. It was like.
You sure that wasn't court? That definitely wasn't me breathing.
I don't know, man. Tell me. You tell me, man. I don't know. All right, so I'm live. We're good there. All right, let's pull that guy off. Oh, wait, did I have it up? Okay. All right. How was your lunch? Good?
Good, you?
Yeah, it was good. It was good. Nice. Ellie whipped me up an egg bowl. It was quite delicious, Jay. It was quite
nice.
Delicious. Used some leftover taco meat, a little fresh avocado, some eggs. Oh, young black economist member for 1 month. Love it. Love it. Love it. You're a great addition to the community, too. We love having you. Kasha, new member. Welcome, welcome, welcome.
Welcome.
Yeah, so I must have misheard because I thought he did say that that was his last witness, but clearly he's got, sounds like about 4 more witnesses.
Yeah, 4 or 5 someone reported, but I thought it was like at least 4, I thought.
Yeah, so that'll line up very nicely for closings tomorrow.
Jury
and,
instructions.
Yeah, jury instructions, a full day of goodness. That's what it sounds like it'll be. And I'll be stuck in the courtroom, Carroll County. Allie will be with you though.
So she is not going with you to Delphi?
I don't think so. Like I'm pretty confident there's not going to be an issue with me getting in, but you know, people just don't understand. Oh yeah, I keep forgetting about the rebuttal too. Yeah.
Oh yeah, that'll be start tomorrow morning probably.
Yeah,
If
it
we
might
get
be
it today.
It might be. Yeah, it should be. Yeah, that was a good interview. It was a good interview. Barb catches a lot of shit from people on the Delphi stuff. I'm like, man, it's like, you know, she's a writer for Court TV. You know, I mean, she's an investigative journalist. It's
Well, it's like you said, it's very similar to the Karen Reed case. Whereas if you're don't say something that's like on one of the sides, they fucking come for you.
Yeah, it's weird. It's weird. People have a lot of extra time on their hands.
I just want to clear something up. I know Kristen Kitty C is in here is having some. So if you have a Patreon, we love our patrons, but it's not going to affect your color on YouTube. That's a complete if you have a membership on YouTube, completely separate. So if you buy it through YouTube, then you'll have, or if you're gifted a membership through YouTube, your color will change. But that is completely a separate thing from our Patreon. Just want to make sure everyone's aware of that. That's we do like exclusive lives and stuff. We post stuff on our patrons, but that is separate from our YouTube memberships. That's through YouTube. So if it's
and like for us, our Patreon,
After lunch,
you know, all of our patrons get early releases of our pod, commercial free.
Is the jury up?
There's benefits there.
All right, jury's being brought up. Anything we need to talk about before the defense calls their next witness?
Of course, Betsy.
Oh,
yes.
I'm so sorry.
Big time, yes.
I was looking right over top.
I mean, if she watches any of my content, she knows I've had an issue how she's run this case from the get. So that's been going on for a year.
By the way, I had my salami, and I have to say, in this country, we have an epidemic with people not being able to cut deli meats correctly. It's too thin, it's too thick. Let's work on that, folks.
I mean, that's a real thing.
It makes
Allison is very, very picky about the the thickness of the American cheese that we get.
Yeah,
from Deli.
not too thick, not too thick.
Like
It shouldn't be like crumbling in my hand.
Right.
And also
It
shouldn't
can't be so thin that you can't peel it apart.
It's an epidemic. We need training.
It really is.
Vote for me, and I will fix this problem that we have.
Wow, dude, you just got my vote. Like that, like, you don't understand. Like I do most of the grocery shopping around here, so like, and I'm like I've been going to the same store forever, but it's always different deli people, and I'm like, and I'm always telling the same story. I'm like, my wife is very picky about the cheese. I'm like, it can't be too thick. It can't be too thick. It's got to be just right. And I feel bad. They're like, oh, do you want me to put the paper between each piece of cheese? I'm like, it seems like a waste of paper and a waste of your time. I'm like, just cut it right, dude. Just don't make it so it's so thin that that they're stuck together. Like,
you can't even like get it. It's like they're 2 pieces. It's terrible.
Yeah.
Sorry for my diatribe. Sorry. The court is back. We're back.
We are back. Let's go. Jury, we're waiting on the jury to come in.
Again. All right, welcome back, everybody. It's after lunch now. We're all back in 2020 CF 3014. Is there anything we need to talk about before the defense calls its next witness?
No.
All right. As soon as the jury comes up, let me know and we'll bring them on in.
Yes, I will fix daylight savings, Drew, because we won't have it. I'm tired of it. Get it out of here. Just
Yeah,
keep
who
it the
does it to
same.
be dark at 5?
Those are like the farmers. They could do their own deal. We're keeping
Right.
it.
That's their problem. It's a farmer problem, not a Bob and Jay problem. We don't want it dark at 5. Trust me.
No.
Jay, so you like that Genoa salami? It's got the peppercorn.
No, I don't want the peppercorn in it.
Son of a bitch.
And
Then don't
Genoa.
be ordering Genoa.
Genoa, Bob. Genoa.
Don't be
Genoa.
ordering what, Genoa?
No, Genoa.
Genoa?
Genoa.
Genoa.
Oh, you're pronouncing it wrong. It's Genoa salami.
Genoa.
And get that peppercorn shit out there. That green shit, I take it out. I don't want that in there.
Then
Don't
you
have that
don't
thing
get
in
the
there.
Genoa salami.
Genoa, Bob. What are you saying? Genoa.
Dude, the whole point of that is that you get peppercorns in there. Otherwise, you just get regular hard salami.
No, I don't want hard. That's different. I don't want hard.
Oh my God. What is happening? What is happening right now?
People are talking about Listeria and Boar's Head. Luckily, I got the Starbucks brand today.
So y'all can sit down. Welcome back, everybody. As we were breaking, I saw some folks got new pad and paper, and everybody's pen is still doing okay. All right, just let us know if not. I hope you had a good lunch. Did anybody discuss the case amongst yourselves? Talk about the case with anybody outside of this group, or do any research on people, places, things, or legal topics, or get any information about the case?
No, sir.
Everybody says no. All right, Mr. Taylor, call your next witness.
Thank you, Judge Whyte. Defense calls Justin Warren.
Oh, I want Jason Alexander though. When is George Costanza coming back?
George likes his chicken spicy.
George is getting
Sir,
upset.
affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
It moved. It moved.
Cool, sir. Thank you. Just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. Just up, down, left, right, however you need. Loud,
Dig
clear
into
voice.
this
You'll
hot
hear
pocket.
everything.
Yes, sir.
Yeah.
Your Honor, with the court's permission,
All witnesses.
permission to treat as adverse.
You can go ahead and approach.
Permission to treat it as adverse. Wow, we're starting off hot. We're starting off hot.
Yeah.
Wow. Who is this dude? But I love that. Look at it. Did you see the judge just put his hands on his head?
He said, "Oy vey." He's like, "Why did you bring this up earlier?" Earlier.
Oh, he was like, "Oh, son of a bitch." Did anyone
Oh,
see
see,
that?
Allie's not here. We could do all the hot pockets we want.
Oh, the judge was like, "Are you shitting me right now?"
He's like, "I told you to bring this shit up to me before we went to lunch." He did too. He's like, instead of us
You're
doing
right.
it- Yeah, I mean, he's like, this seems like it's something they should have addressed prior to. Because all he's thinking about right now is one thing.
And Bob,
Yeah.
if I'm wrong, but what he means is a hostile witness, which allows him on direct to cross. Is that what he's
Correct.
lead? I'm sorry, to lead.
You are correct.
On direct.
No. On direct, he would typically be just not leading. On he wants to be able to lead. So
Right.
He wants to do it as if it's a cross examination.
Right. Exactly. Right.
Yeah, I wonder does he seem like a cop? Maybe cop-ish?
No, I don't think so.
No?
Maybe.
No. I don't know. We'll see. We'll find out.
Bless you.
Detective Warren, good afternoon.
Good afternoon, sir.
You were the
Yeah.
lead on this case, were you
Oh,
not?
you're
Yes,
right,
sir.
Bob. Lead
Can you
detective.
tell ladies and gentlemen of the jury, what does that mean, the lead detective?
The way that our unit works, the Manatee Homicide Investigative Unit, the lead essentially during a homicide investigation is elevated to essentially almost the rank, not a sergeant, but basically has some of the same responsibilities as far as handing out assignments and then collecting the information in the end.
And is amongst the ones with the most knowledge of the case. Would you agree?
We do collect everything at the end, but we do have meetings, so everybody's pretty much aware of what's going on.
All right. Does the lead detective develop the theory of the case?
We work as a group, so like I said, it's pretty much a group effort.
Do you recall being asked the following question on May 16, 2023 at a deposition? Question, okay, so part of your responsibility as the lead detective, you would develop a theory of the case. Would you not? Answer, sure.
The answer is still sure. Yes, sir.
You want your investigation, especially for homicide case, do you not, Detective Warren, to be objective and fair?
Yes, sir.
With conclusions supported by evidence?
Absolutely. Yes, sir.
Yeah. Not speculation.
That's correct.
It's not something, given the nature of what a homicide investigation entails, that you want to jump to conclusions.
That's correct.
Did you submit an arrest affidavit for Ms.
Objection.
Benefield?
Pre-trial rule.
Just asking the question.
Ruled at this point.
Did you submit an arrest affidavit for Ms. Benefield?
Yes, sir.
Did you represent that?
Objection. Pre-trial rule.
Sustained.
Did you describe?
Objection. Pre-trial rule.
Go ahead and ask your question.
Let me ask you this. Was it your position that based on the entry wounds to Douglas Benefield, that it did not appear he was facing Ashely Benefield when he was shot?
Based on what I knew, yes.
And as it related to the chest wound, what did you base that on?
Well, whenever we have a homicide investigation, one of our detectives will go to the medical examiner's office for the examination and obtain a preliminary finding. We don't actually receive the medical examiner's report for several months to maybe even a year in some cases.
You're aware that the medical examiner's finding here was that he was shot from the front.
Hearsay.
Sustained.
As it related to the wound to the leg, Detective Warren, what was the basis for your conclusion?
I'm sorry.
As it related to the wound to Douglas Benefield's leg, what was the basis for your conclusion?
It appeared that he was shot from the right side of his body.
Can we agree that you got both of those wrong?
I wouldn't say so, but I'm not a doctor. I would ask the doctor.
Okay, so it's your position as you sit here today that Mr. Benefield was not shot from the front?
That's not the way that it appeared when we did our preliminary investigation with the medical examiner and then later on.
And it's your position today as you sit here that?
Objection, Judge. Can we approach this?
Pretty interesting.
What they consider to be a hostile witness, and I see a few people asking in the chat, is if it's you're calling a witness who, for example, their interests are aligned with the opposing party. So obviously, in this situation, cops are typically aligned with the state. So you're typically not calling them in your case in chief because they're not going to testify to anything that is helpful to you. So, in the rare occasion, like this case where they didn't call the lead investigator for whatever reason, the defense wanted to get him on. They wanted to be able to treat him as hostile, which means that Taylor has the ability to cross-examine him. If he I don't know what the judge ruled. It seems like kind of a cross. So I'm assuming that he approved it, because you ask permission from the court in order to treat a witness as hostile, even though they're calling him. So it seems kind of contradictory in terms of you're calling the witness. How can they be adverse? But it's what the content of their testimony is that's adverse to your case, or at least in theory it is. So that's what's going on here. Clearly, this cop typically would have been called during the state's case in chief. Instead, they didn't call him, which I'm curious about. I'm curious why they didn't. Hopefully we get into it. There's got to be a reason.
Well, probably
right?
for the reason that I brought up, like the at some point this guy was like, yeah, she shot him in the back, and then it turns out no, she shot him in the chest per the medical examiner.
Right.
So I mean, that seems like what he really wanted to get out here, that they wanted her to be guilty by saying she shot him in the back, when in fact the medical examiner is like, no, he was shot in the chest. I guess that's why they didn't call him. Like, they didn't want to front this. They didn't think that I don't know.
I don't know. I mean, like the ME kind of gave his impression in terms of what he believed went down, right? I mean, it was kind of like it was that whole blade position,
right?
That he was in the blade position, kind of like what kind of like if you're fencing, like that same kind of position.
Well, kind of like what she described when she was trying to say he was in like a fighting. What Ashely described when she was like, he's like in a sidewards fighting position. Kind of what she described when she was on direct examination.
Yeah, I mean, you're definitely trying to make yourself smaller, less area to hit, like if somebody's got a weapon. So yeah, I think we might have a couple bloops.
Close up your notes. Step back in.
Oh my
God, Jay! What did you do?
Don't begin deliberations.
Judge Gaffigan's got to be so mad. He's like, I fucking told you guys, if we're going to have issues, let's deal with it without having to send them out. And what's the first thing he has to do within the first 15 minutes?
He obviously heard your whole thing about the salami and not understanding that Noah has peppercorns in it, and saying that he's upset. He's upset by your whole.
Sorry, Gaffigan.
Right,
I
sir.
don't like pot pockets either, Gaffigan.
We're going to need to address some legal matters about your testimony, so I'm going to ask you to step out into the hallway. The rule of sequestration has been invoked, so you're not to discuss questions asked of you or your testimony with anyone.
Jewel.
You're not to talk with other witnesses about their
always in
testimony,
position
questions
there.
asked of them. You're not supposed to do any research about the case or watch anything.
Yes, sir.
All right, the witness is out. So as I understand it, there's going to be several areas of cross-examination regarding Detective Warren. And the state has objected on the longstanding doctrine that you can't call a witness solely to impeach that witness. So that's where we're at. And the line of question where we stopped was going to involve statements made by the detective in his probable cause affidavit or arrest affidavit. All right, so these issues were addressed, and I seem to recall that I allowed these at the stand your ground hearing, and this may have been the footnote where I said rulings at trial may be different. And there's also been a pretrial motion regarding impeachment of Detective Warren and what is relevant and material and admissible. And I said, I believe my ruling was that it would have to be shown at the time of the cross or the direct and the attempted impeachment to show that those criteria are met. So State, what else did you want to put on the record?
Judge, only that this keeps happening, and we did hours of litigation about these issues so we would not have this problem in the middle of trial. Now, almost every sentence that comes out of Mr. Taylor's mouth, I have to object because he is not following your rules or the rules of evidence. So I would ask that we try to get this ironed out now so we don't have to call the witness back and I have to object 5 more times. He has clearly only called this witness for impeachment purposes. That is the A#1 first objection that I have.
Sure.
All right, I called this witness to establish substantive evidence. I asked him, what does being the lead detective on a case mean? Is that the one who has the most knowledge of the case? Do you develop a theory of the case? He resisted that. I impeached him with a prior acknowledgement. He then also said and confirmed that he would want his investigation to be objective, fair, with conclusions supported by evidence, not speculation, and that it's not something that you would jump to conclusions on. Now, that is my substantive evidence predicate. And based on that alone, if nothing else, I am now allowed to argue to the jury, don't you think it's strange that the lead detective on a homicide case would not be called as a witness on behalf of the state? So that's my substantive position. Along the way, I should be also likewise entitled to impeach him. For example, he has testified that you would not want to jump to conclusions on a murder case. You'd want it to be objective, fair, conclusions supported by evidence, not speculation. All right, fine. Is it not true that within an hour and a half of this shooting, you referred to this as murder? I then want to ask him, do you believe all homicides are murders? If he says yes, good. If he says no, then I plan to impeach him because he made that statement in his deposition. I then want to ask him, and do you believe that all people who kill are murderers? If he says yes, fine. If he denies it, then I plan to impeach him because he made that statement in his deposition. I don't see why that is not a fair game, respectfully. The only other question I had of him was he had authored a supplemental report on November 16th of 20. And in that supplemental report, there is a provision on the report for bias, referring to the subject, Ashely Benefield. And he checked the box, or either checked the box or wrote in no bias. I plan to ask him about that.
What report is that?
That is a report that he authored, a supplemental on November 16th of 2020. And referring to Ashely Benefield as it relates to the victim, Douglas Benefield, he wrote or check the box that says no bias.
What are the other options?
Well, the other options are hate, spite, ill will. And
on that form?
No, the form it's an open form. It's for him to put it in there. Here, I'll show the court the form. It says bias motivation. He types in none, no bias. The next block says bias target. It's blank. And the box after that says bias circumstances. That too is left blank. Would you like me to show you?
First, I don't think he filled that out.
Even if he did, I don't know which
No, I will tell the court in deposition, Detective Warren questioned whether or not he had filled that form out, despite the fact that it's got his name typed on it. That's going to be a question of fact for the jurors. It goes to its credibility, not its admissibility, respectfully.
All right, the line, thank you. The line of questioning that you seem to be starting with was the line of questioning that the stand your ground hearing where a narrative was established. And then I believe it was shared with the state, and then there were some amendments, and then it was shared with the state, and then there were some amendments, I think, to final form.
All I proposed to ask him here was, did you write a witness hit Ms. Benefield with a box? And I want to ask him if he knew who that witness was. And he's going to tell me it was Doug Benefield. And I'm going to ask him why he didn't say that. Give us a reason why you would not have disclosed that rather than put a witness.
Judge, I feel like we litigated all of this. And this was supposed to be shown to the court outside of the presence of the jury so you could make a predetermination before the jury came out. I would like to know the relevance of what is in his arrest affidavit. He cannot call a witness to the stand and say, do you do a thorough and fair investigation just so he can impeach him with this stuff that he's trying to get in. He calls him and says these questions and calls them substantive evidence. It's not substantive evidence. It is setting him up so he can get in all of these items that he thinks are impeachment. We have gone over this before, that what is in this arrest affidavit is irrelevant. What the judge signed the arrest affidavit. You said in your pretrial order that the use of the word murder versus homicide, my motion was granted unless this defendant can establish to the court why this is relevant. And the defense did not say anything different than what they said before when we argued this. Also, any edits of a warrant or search warrant or anything in the warrant, same thing. So I really don't understand why we're back here arguing this again. The arguments are exactly the same. He calls this witness, asks a few questions to set up impeachment. It is disingenuous to say that this witness is called for anything substantive other than attacking his credibility. He was never a witness. Why is he attacking the credibility of a witness that never testified?
So as I understood the court's ruling, until such time as I could demonstrate the relevance of it, it was not admissible. I think the relevance of the lead detective believing that all homicides or murders is overwhelmingly relevant.
Please explain. I understand, and you said that multiple times in multiple hearings. Relevant to prove what?
Bias. This guy executes a search warrant within 45 minutes of the shooting, referring to it not as a homicide, but as a murder. We've already had testimony from at least 2 deputies, and in particular, I'll remind the court of Lieutenant, I believe it was Dickens. Who? Dickerman. Who testified that not all homicides are murders, that the reason you have to take time to investigate a homicide is to determine whether or not there's been criminality. So here's the lead detective who initiates the theory of the case. Within 45 minutes, he's calling it a murder rather than a homicide. And he makes the statement that all homicides are murders and anybody who kills is a murderer. And the court is going to instruct the jurors, if you feel her action was justified, then she's not guilty, because not all homicides are crimes. How could that not be relevant?
This witness never testified.
Any further thoughts?
No.
All right. Yeah, these we've already covered this ground. So it answered a question just a moment ago about what was the purpose for calling this witness, and the law is very clear. And I think both sides know this area of the law. You cannot call a witness solely to impeach that witness. Asking if that person is the lead detective, is it important to be fair and objective? Is it important to rely on facts? Is it important not to engage in speculation or jump to conclusions? Those are not substantive questions regarding the investigation. Those are just general questions to someone about being objective and fair. In this particular situation, and I'm skipping over the part about any argument about the state not calling the lead detective in a case. I'll leave that to whenever it's presented. I think we all know the law on that as well. But the answer I got is, what is the relevance of him referring to, in a search warrant within an hour and a half, a murder? What's the relevance of his opinion? This is an opinion. Are all homicides murders? That's an opinion. It doesn't matter what he thinks. If he thinks that all homicides are murders, or all murders are homicides, or there's some mix of the two of them, that's a jury question that the jury is going to have to answer. I can't think of any witness I would let speculate or testify as to whether this case is a homicide or a justifiable homicide or an excusable homicide. That's the province of the jury.
Judge, can I ask?
I tried to give both sides as much time as they wanted to put information on the record. The question, are all people who kill murderers? Again, what I'm asking is, what's the relevance of that to show his bias? There hasn't been anything established that he was particularly biased in any way, or how that would be relevant to this particular case when it's an opinion whether people are kill or murderers. That's going to be a jury question to decide whether the state has proven beyond a reasonable doubt its allegations of murder in the second degree with a firearm, or if the facts and evidence support a lesser included offense, or if the state has not met its burden and the defendant is not guilty, whether they haven't met their burden or because the jury believes and finds that the defendant has acted in lawful self-defense. The other issue about the statements made in the probable cause affidavit, it's my understanding that's going to be asked is, did you know who that witness is? And again, I'm struggling to understand how that is relevant into any particular issues in this case.
How about this, Your Honor? Does the court
He already
think
said he
if,
gave you time,
as the
dude.
lead homicide detective,
Tell him,
Justin Warren would have said, I'm not going to seek a search warrant because I think Ashely Benefield was abused and I think her actions were justified. That would be his opinion. But if that was his opinion, she might not be sitting there right now. That's why I think it's relevant. He initiated the prosecution. And you were hearing from somebody who initiated the prosecution who is overwhelmingly biased. He acted impetuously. He acted without evidence. He got both of the entry wounds wrong. He completely speculated that Mr. Benefield was not facing her when she was shot. Their own medical examiner said he was facing her.
State, anything else?
No, Judge.
Mr. Taylor, I am certainly giving you as much room as I can to cross and impeach on relevant and material issues. But from what I've heard so far, and I will just say that the impeachment from earlier regarding theory of the case, that was not materially different. But so far, the questions you have asked and the questions that I've heard you represent to me and issues that you intend to represent and question this witness on are all impeachment issues.
All right, I have two questions remaining. Will the court allow me to ask them? One question is, I want to ask him if he spoke with the medical examiner before he submitted the arrest warrant. And the last question is, did you fill out this supplemental report and indicate no bias? That's it. Then the only thing left is I want to show him the DNA report and have him read the section that's applicable. We gave them business records notice.
I have. Well, hold on.
Okay.
The two questions that have been stated at this point, the two questions, just to try and get objections out of the way and get them ruled on so we can get this going, is one, two is this supplemental report, nothing regarding bias. And the first thing again?
And the first one was, did you speak with the medical examiner before you submitted the arrest warrant? I think he's already testified to that.
I think he did.
None of it is relevant, Judge.
All right.
And I will be asking for a curative instruction depending on the court's ruling.
All right. And then you wanted to show him
The DNA
report.
Yeah, he submitted the exemplars and he got the report back.
All right. I don't know if I've seen that.
You may not have. We'll be happy to show it to you if you like.
But what is the relevance of showing a detective a DNA?
Hold on. Yeah. Plus, it's a report. It's not been authenticated.
We gave them the notice of the business record. They did not file an objection to it. And it shows that the court may recall crime scene swab, both of Miss Benefield's hands and wrists and forearms. And the DNA came back as Douglas Benefield was one of 3 potential contributors out of 740 million or whatever the figure is. And the court may recall Ms. Benefield testified on the stand that she attempted to flee the house. Mr. Benefield ran after her, grabbed her, spun her around, and blocked the door so she couldn't get out.
Yeah, but it's okay. Go ahead.
My objections are not to the business record certification, Judge. My objection is the contents of the report there has not been a foundation laid to make that report relevant. There has not been a witness that testified that swabs were taken and then turned over. There's not a witness that said, I'm speaking. There's not a witness who says that those swabs were taken from Ashely Benefield and then those swabs were sent to DNA labs. So anything contained in that report that says there's DNA from Doug Benefield or Ashely Benefield is hearsay. There is not a person at DNA labs that can say where those swabs came from. They all they know is they got them from the sheriff's office and somebody told them where they came from. And I think that the probative value is outweighed by the prejudice because it's going to confuse the jury. It's a packet with bench notes and the report. And the report, there's no witness here to testify to explain a very complicated report. This isn't, even ballistics is somewhat simple. This is DNA. It's extremely complicated. And I think that the danger is that it will confuse the jury and that the proper foundation has not been laid. So my objections are not to the business records, which is why we did not file an objection. It is to the contents being hearsay there's an insufficient foundation to enter this, and that there's a unfair prejudice.
I'm quite comfortable relying on the court's notes, and if the court checks its notes under Megan Dorvac, the court will see that Megan Dorvac testified after being called by the state that she swabbed at the sheriff's office that evening Ashely Benefield's hands, arms, and forearms for DNA evidence. And I even specifically asked her if the purpose of that was to be able to determine who may have touched her on that occasion. She agreed. Now, Warren submitted those DNA samples to the lab. The lab returned those DNA samples to Warren. Now I'm going to ask him what the result was. And I have the DNA report for the court if it would like to see it, along with the business certification records of the custodian.
I've seen plenty of them. All right, anything else?
No, Judge, that's not how any of this works. There's been no swabs. There was no witness that said, these are the swabs I took from Ashely Benefield. There's been no witness that said, these are the same swabs that were sent to DNA labs. There's been no witness that said, those are the swabs I received. There's been no establishment that anything in that report is related to this case based on anything other than hearsay, which, I'm sorry, I already said all those things, but it's just frustrating because they're all the steps to get that reported under certified business records have been skipped. And so although I don't object to that portion of it, it's the contents being hearsay and improper.
As a proponent, I'll give you the final word, and I need to make a ruling.
Well, just say the state never filed any objection. We gave them notice plenty of time.
That's right.
Yeah, this is a really easy call. That lab report is not admissible. You could call the DNA analyst who could come in under 9702 and establish the foundation and the bases to admit DNA evidence. After the chain of custody has been established, there's been no evidence. I haven't heard anything at all about the I heard about swabs. I don't recall seeing the swabs. I heard about swabbing being done, but then the chain of custody, getting them to whatever lab did the testing to ensure the integrity of the evidence. Then at the lab, what are the testing processes, procedures, known error rates, all of the foundations you would need under 90.702 and 703, 704, 705 about how this all happens. And then, of course, we need the analyst to explain what these results are. So that lab report doesn't come in. In addition, it's prepared in anticipation of litigation. I mean, that's the whole reason it's done. So that one, that was an easy one. That is going to be prohibited, crossing Warren on the DNA report. The other two, though, the state objects. I think it's fair to ask Detective Warren if he spoke with the medical examiner before he sought an arrest warrant. And you can ask him, I think, if that's his supplemental report. I think it's close, but I'll let you ask him, here in this box regarding bias, nothing is there. But out of everything I've heard, those are the only two questions that I think are relevant and material and appropriate of everything we've talked about and aren't solely to impeach. So, all right,
And Judge, I would just ask to establish the without bias part without speaking it out loud to the jury first.
I don't understand what that means.
He's leading this witness and speaking what's on the report before the witness even says he wrote it or anything. So
right.
I would
So
prefer that he
establish if it's his report. Establish that down on right here. There's a box that says a bias. What does that mean to you? And he left it blank. And is there anything in particular that why he did that? But that's the extent of what I've heard relevant. So. Let's bring him back in.
Oh my banter.
All right, so I mean, the overarching theme is that you cannot call a witness to the stand for the exclusive purpose of impeaching a statement that they made previously. So you just can't do it. Not just in this case, in any case. So what they were saying, what they were arguing, is he was trying to say, well, I didn't call him to
All right,
impeach him
sir,
on
did
those
you speak
things,
with
or
anybody
he
about your
said one thing
testimony,
here
or
and
did
said
anybody
another
approach
thing
you to
there.
speak with you and talk with other witnesses about their testimony or the questions asked of them?
No, sir.
Any research on the case, watch it at all?
No, sir.
And Taylor was arguing that, okay, well, I asked him substantive questions, and that was about, you try to be unbiased, you try to do a full, thorough investigation. Those are just kind of like, those aren't really substantive questions. And if he were being honest, he'd tell you the same thing. They're not substantive. They're not relative to the evidence in the case. So, I understand, like, I see a lot of people are frustrated. Welcome to my world. That's what it's been like as a defense attorney, like things that we find to be highly relevant. Like, I think that this cop's bias, and kind of like in Reed, where Proctor within 16 hours had Karen Reed murdered him. She ran him over and he was the lead guy, and to kind of be able to reach that part of your mind where you're saying, okay, well, this guy clearly thinks that she just killed him in cold blood. He clearly has her pegged as a murderer. How can that not be bias in terms of how they're going to run the investigation? You know what I mean? It's like, I think it's relevant, but I get turned down by judges all the time on things that I think are relevant, and they just don't see the relevance. And, so it's frustrating, but I mean, it happens all the time. But the bigger picture with respect to, just that the ability to be able to simply impeach him, despite the fact that he hasn't, answered any other questions relative to the case itself, is basically where the judge is kind of like, nah, man, I agree. Spitfire it is. But what I'm saying is what we think is relevant and what judges think is relevant are two completely different things. So I'm saying I've been getting crushed for 20 plus years on things that I think are highly relevant that the judges just do not think are relevant because it doesn't move the ball one way or the other in the case itself, which is what they always are pointing to. And I'm like, but because I would have made the exact same argument Taylor made. I would have said, well, like, we might not even be here if this guy wasn't the lead detective. If somebody else had been here who doesn't think that every single homicide is murder. And I've explained to you guys before, not on this case, but, homicide is just the big umbrella. Homicide is when somebody's been killed where it's not a suicide or natural causes. They all fall under the homicide umbrella. Murder two, manslaughter, involuntarily manslaughter. Those are all homicides. So, for this, but again, and I always say, cops don't understand the law. That sounds weird to say because, they're enforcing it, but they just don't have a clear understanding of how the law works and how it operates and the difference between homicide and murder. They don't know those type of things. I'm sure there are some cops that do, but they're not taught that at the academy. They're not in law school. There's a difference in terms of what the knowledge that cops have and what lawyers know. So, and as far as the DNA, did any DNA come in at all?
No, I don't think so.
Yeah, I don't know. So yeah, we'll have to see what did he rule on that? Did he rule that the DNA out?
I missed that.
Were you spacing out, Jay? Is that what was happening? I mean, I'm not afraid to admit I was.
A little bit. I made a your mom joke in chat and I lost it after that.
Toughest job. Die on that one. Ooh, the U.S. men's gymnastics medal. What did they get? Seems like a bronze. He didn't say gold medal. Tell us in chat, Drew. Tell us in chat.
All right, y'all can have a seat. Welcome back, everybody. Did you begin deliberating amongst yourselves? Talk to anybody outside the jury about the case? Or do any research on people, places, things, or legal topics? No. Everybody says no. You may resume your direct exam.
Thank you. Detective Warren, did you speak with the medical examiner yourself before you submitted your arrest warrant in this case?
Well, like I said earlier, we have a detective that will go to the scene or to the medical examiner's office to get the preliminary findings.
Okay, did you talk to that guy?
Let me repeat my question, Detective. Did you personally speak with the medical examiner before you submitted your arrest warrant in this case?
Not that I can recall.
Did you talk to that guy who spoke with the medical examiner?
All right, let me pass this to you and see if this refreshes your recollection.
Sure. Okay. Yes, sir. Yeah, so I spoke to him on October 29th in reference to stippling.
You documented in your report, did you not?
Yes, sir.
All right, my last question, Detective. Do you recall filling out a supplemental report on November 16th of 2020?
I filled out a lot of reports, sir. May I look at it just to verify?
Sure.
See how he keeps looking over at the states table? Allison and I always used to position ourselves in front of the cop and standing in front of the states table so they couldn't make eye contact.
Okay.
Is that your report?
It appears to be. Yes, sir.
All right, can you tell us the date of the report?
November 16th at 15:10 hours.
November 16th of 2020?
Yes, sir.
All right. Let me ask you if there is a provision in this report for you to note whether or not any bias or motivation is demonstrated by the offender towards the victim.
It's a program that's got a lot of different stuff, so there could be possibly, sure.
All right, let me ask you this. Under bias and motivation,
okay,
did you put in none?
Well, it would have just been not filled out. It auto-populates. Like I said, it's a program, and I'm not a programmer, so I apologize.
So if you had been aware of bias on behalf of Ashely Benefield towards Doug Benefield, such as ill will, spite, evil intent, things of that nature, you would have noted it, would you not?
Honestly, it probably would have been just documented in the report.
No further questions.
Cross.
This section that says bias, isn't
Bob,
this
you're muted.
for hate crimes?
Yes, ma'am.
Yes,
When we fill out
we had a
certain
case on
areas for
Monday.
certain crimes, it's required for statistical reporting and things, and a lot of things that I'm not even aware of. I don't typically pay attention to that box, but
So this box is for those kind of statistics, not for any kind of bias that may be going on in this case.
correct.
Thank you.
Redirect.
Do you think it odd that you're the lead detective in this case and
Objection
you weren't called
beyond
by
the
the
scope.
state?
Sustained.
No further, nothing further.
Can this witness be released?
Yes.
No.
You remain under subpoena, sir. The instructions I gave you about sequestration remain in force.
Do I need to stay in the building or can I leave?
No, sir, you can go, but you need to be available in case somebody calls you.
Yes, sir. They have my email. Thank you.
Call your next witness.
Try to come back to it. We call Dr. We call Michael Hay.
Thanks for being here after lunch, folks. If you haven't hit that like, please hit it. If you missed it earlier, this should be the rest of the defense's case. I think 3 or 4 more witnesses, and then they will be done. So we appreciate you being here. We know you have other options. Thanks for being here. Hit that like.
You solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Thanks, sir. No, sir. Appreciate it. My name is Judge Whyte. I'm presiding. Make yourself comfortable in that chair. Get about 12 to 15 inches from that microphone. You just up, down, left, right. There you go. And just speak in a loud, clear voice. It'll pick up everything.
Thanks, sir.
Good afternoon. Will you tell us your full name, spell your last name?
My name is Michael Haig, H-A-A-G.
What type of work do you do, Mr. Haig?
I'm involved in forensics. Specifically, a typical job title would be forensic scientist.
Let's talk about your educational background. Where'd you go to school?
My formal education is as a chemist. I have a bachelor's of science degree in chemistry from the University of Arizona in Tucson with a math physics minor.
When you speak of forensics, what are we referring to?
Forensics in the broad scope simply means the junction or the joining of science and the law. So it's where somebody who is particularly interested in or has been trained to examine physical evidence brings findings or an interpretation of that physical evidence into the courtroom.
Could you describe your forensic career history for us?
My background and training is fairly unique in that I grew up in this field. My dad, Luke Haig, also does this kind of work. So even in grade school, I'd go out and assist him with both casework and research, and I got the bug. So after I went to college and got my degree, I went and worked for a private consulting firm that he ran for about 2 years or so, followed by an application and employment with the Albuquerque Police Department Crime Laboratory, starting in about 1998. With APD, I worked for about 25 years and got to the retirement point and was able to retire. But during that same time frame, I also ran my own private company, specializing in my sort of primary area of interest in forensics, which is shooting incident reconstruction. The study of the physical evidence relating to shootings, the interpretation of that physical evidence, and the reporting on it, of course. With the Police Department Crime Laboratory, I wore quite a few hats. Primarily, I worked as a firearm and tool mark examiner, which someone in that role particularly focuses on the physical evidence relating to those things. But I also worked in drug chemistry as well as blood and breath alcohol, and was a supervisor of those units for about 12 years as well.
Any additional training and or classes that you have taken in order to be skilled at your job?
The list is fairly long. Honestly, I don't remember everything that I list on my CV. But as far as training and expertise, I've been trained and taking classes from everything from the FBI at Quantico to doing cross trainings with the San Diego Police Department, in-house training with the Albuquerque Police Department. I regularly attend conferences and seminars. I worked for the German Bundeskriminalamt. Do you spell it? Bundeskrim. ALAMT, which is like their FBI. So I interned with them for a while before I came to the Albuquerque Crime Laboratory, and a wide variety of other trainings I received over the almost 30 years now.
Are you a member of any professional organizations having to do with your specialty?
I am. The ones that are particularly relevant to what I do would be the Association of Firearm and Toolmark Examiners, or AFTE, the American Academy of Forensic Sciences. EMFSI is one that I've been a member of for about 2 or 3 years. That's the European Network of Forensic Science Institutes. They actually have some very, very interesting perspectives on forensics, among others, including the Association for Crime Scene Reconstruction. But that's another bug I got from my dad, is being very active in the field, seeing how other units do things, as well as participating in those conferences.
His dad,
Have you
we already
authored
talked
or
about Bob, his
published
dad.
any scientific papers?
Quite a few. Another bug I got from my dad. I publish very regularly in scientifically reviewed, peer-reviewed journals, such as the Journal of Forensic Sciences, the Association of Firearm
Yeah,
and
his dad
Toolmark
was Lucian
Examiners
Hay,
Journal, amongst
the
others.
expert in the Alec Baldwin
Written any
trial.
textbooks?
Luke, my dad and I wrote a textbook, one of the few on shooting incident reconstruction. It's in its 3rd edition now. And I'm also the author of a chapter in the Encyclopedia of Forensic Sciences on shooting incident reconstruction.
And how about, Mr. Haig, any forensic presentations of note?
I very regularly present both at conferences as well as for organizations on this area of work.
Can you tell us what certifications are offered in the area of firearms identification and comparison work?
The primary certifications, which certification applies to an individual and accreditation applies to a laboratory, so those are terms you'll often hear mixed, but certifications available and that are relevant to what I do include 3 from the Association of Firearm and Toolmark Examiners, 1 in gunshot residue and distance determination, 1 in firearm identification, that's the examination of microscopic tool marks, as well as toolmark identification, the examination of microscopic tool marks from other things besides guns, like screwdrivers and hammers and things like that. And then when the International Association for Identification had a certification, they've discontinued it, for crime scene reconstruction as a whole, I applied for and took that. All these tests involve both the knowledge test as well as a practical examination. And the AFTE ones, which are still active, of course, require recurrent training and testing.
Have you been recognized and testified as an expert before in a court of law?
I have.
Approximately how many times?
At last count, I think I'm getting close to 100.
And where have you so testified?
Primarily in the area where I worked for most of my 30 years in New Mexico, in Albuquerque. But in addition to that, all across the country, to include states like California and Texas and Rhode Island. And I'm not sure if I've been to Florida before, but many, many states across the country, and courts ranging from district or regional courts, state courts, to federal courts and military court martials.
Mr. Haig, have you given your opinions in high-profile cases before?
I have.
Give us an example.
The cases that come to mind would be Aaron Hernandez in Boston. That was a high-profile homicide trial. I've been involved in the examination of physical evidence in places like Taiwan, even for presidential assassination attempts, or cases from Iraq, and many other places that I lose track of.
Are you an instructor in any areas of forensics?
I am.
You've written on the subject as well?
I have.
And you provide regular training in shooting reconstruction?
One of the areas that I actually gain a lot of pleasure from is instruction in shooting incident reconstruction. So this is the examination, as I said, an evaluation of any physical evidence when a shooting takes place. That can involve the crime scene itself. It can involve trajectories. It can involve a wide variety of things within that sort of umbrella title. But I've taught a shooting incident reconstruction course for almost the entire last 25, 26 years of my career. They're week-long live fire shooting courses. So this isn't just a thought process. I go out and shoot things so that people that do what I do, crime scene investigators, forensic scientists, even pathologists, can come and see how these shootings take place and understand what they're looking at when they go into a scene. So I do that very regularly, especially now that I'm retired. I'm able to do about 4 to 8 of those a year, it seems like.
Is the assessment of bullet trajectories taught in your SIR courses?
It is.
Can
Wow,
you
I
describe
got
for
what
us
I
what a
asked for.
3D laser
Show us how
scanner
this
is?
happened.
This is a tool that I actually feel
He's the
very
guy.
lucky to have helped brought into the crime scene realm. It's an engineering tool, technically. But if you think of a laser rangefinder, a very simple one that you might aim at something, push the button, it shoots out a bullet of light. Light travels at a very consistent speed. So when that light is reflected back to the sensor, time is measured, and we then can calculate a distance because of that time and the known speed of the light. That's one bullet of light. A 3D laser scanner is an engineering tool that sits on a tripod and has such a thing inside of it, but spins in a 360-degree azimuth, left and right, and also is able to shoot out the laser beam in a vertical path as well. So imagine in this room shooting out millions of bullets of light and collecting individual data points on a very accurate scale and then blending all those individual data points together. You get a representation of reality. You get a computer takeaway of your scene. And then you move that system from one place to the next. So you can move around corners and you can blend all of these data sets together so that you really take the crime scene with you. So I was lucky enough with my police department to help start this theft of this technology into crime scene back in about 2005. And since then, many departments have also seen the value of it, particularly with trajectories, in my opinion. And it's become a very common tool across the country and internationally as well for crime scene investigation and shooting reconstruction.
Mr. Hay, can you define for us what exactly a trajectory is?
When I'm describing a trajectory, I like to think of it or describe it or liken it to a snapshot in time. If you imagine yourself in a dark room, completely dark, and things are moving, and you set off a strobe from a camera, let's say 3 times in that dark room while things are moving around, then you've really frozen things in place for that brief instant while the strobe was going off, or in our case, when a shot is going off, because bullets move to our perception of reality in a very fast manner, of course. And so if a bullet, say, goes through something and then strikes something else, it can help us orient those objects that are struck, and indeed then where the firearm is as well. So snapshot in time is how I tend to think of it, but it's a way of understanding where things were, including potentially the firearm itself, as well as objects that are struck.
All right, so you come upon an investigation, if you will, of a shooting incident and you reconstruct it, correct?
I try to.
All right, now would you tell us the significance, the importance of trajectory as it relates to that reconstruction?
In forensic science, you in very many ways have to throw out what you may have seen with regard to TV. Most of the things that TV puts out are completely false. But the beauty or interesting thing about trajectories with regard to shooting scenes is that fact that it gives us a way of assessing where things were in those moments of time. A person in my role may not be able to say exactly what happened in between them sometimes. Sometimes there's a logical progression of what might have happened given the physical evidence that we do have. But in my job, I basically lay the pieces of the puzzle on the table, meaning what physical evidence I have to look at from a shooting scene. And that could be the projectiles, the cartridge casings, the firearm itself, or trajectories, the room, and then try and see what snapshots in time we may have available to rebuild.
Is there a distinction between what you've been referring to as trajectory and wound path?
Wound path is sort of a subset of trajectory. Wound path refers to, indeed, just that, the path a bullet took or created when it goes through a body part in specific, or a body. But in each case, the accuracy and the meaning of those trajectories can be evaluated, because bullets, for the most part, there are exceptions, tend to travel in more or less straight paths. Like I said, there are absolutely exceptions to that, particularly with, we're not dealing with, in this case, non-expanding rifle bullets. But we look at these paths as relatively linear. Every measurement taken by human beings is an approximation, though. So an understanding of how much accuracy to place on those measurements and that documentation is absolutely, of course, important as well. With trajectories into things like walls, when I have good points to work with, or data from somebody's scan of a trajectory rod in place, for example, typically about plus or minus 5 degrees is what I've found from my work, and what I would call a industry standard in my work around a measured trajectory, around a straight line, if you will, that was created by something like a trajectory rod. With wound paths, it can be a little more difficult, and this is something I've lectured on to not only the pathologists in my area, who I worked closely and well with and helped train when they'd come in as fellows, and that I've lectured on at the Swiss Wound Ballistics Workshop 2 years ago, I think, and was asked to lecture on, is the idea that not only are trajectories in bodies a little bit more inaccurate because the way they're measured and how bodies move, we're not walls, we're not rigid. So we have to indeed look at those as a little bit more of an approximation. But for the most part, with things like we're looking at here, expanding handgun bullets, that category, we can describe them or think of them as relatively straight lines as documented. They give us an idea of where a firearm may have been at the time a shot was fired, based on that path. So wound ballistics is a subset of just trajectory. They're related.
You may have alluded to this. If you did, my apologies. What is the degree of accuracy of trajectory reconstruction?
With regard to common things that I typically deal with in crime scenes, like walls, sheet metal in cars, desks, almost anything you can think of, I shoot in my classes to demonstrate this and basically check ourselves and see how accurate we are, about plus or minus 5 degrees. So I'm motioning with my hands to make sort of an arc. So if my primary line of measurement, we're going right down the center of my wedge here, I'm making a visual representation of approximately plus and minus 5 degrees, a 10-degree cone overall if you rotate that into 3 dimensions. But I think I can show you that later.
What steps did you take in preparation for your testimony here today?
When I do a case review such as this, there are materials that I typically would like to see in order to help inform myself on what evidence, what pieces of that puzzle are on the table to include, particularly documents, things like crime scene images, autopsy reports, lab reports, all the documentation that goes around a typical investigation, as well as 3D laser scan data, if it's available, amongst other things.
And in this case, did you examine all the evidence that was available to you?
I actually forgot to mention that. In addition to that, in this case, I did examine the actual physical evidence, meaning the projectiles, cartridge casings, etc.
And when you say projectiles, we're referring to the bullets?
Correct.
All right. And this information that was provided to you by the county, correct? By the sheriff's office crime scene?
Which information were you talking about?
That you were able to review in preparation for your testimony here today.
I think technically I received it through you, with the exception of the 3D laser scan data, meaning the documentation, the crime scene of photographs and autopsy reports.
Do you recall whether or not you actually came to the sheriff's office to do a review of the evidence?
Absolutely.
All right. Let me ask you, with that preface, to tell us, please, about the projectiles in this case.
The examination of the projectiles helped me understand in a way where they'd been. This is sort of one of my main areas of interest, is the damage to projectiles. Sometimes, depending on their condition, when they finally come to rest, can tell us something about where they've been and what they've hit, especially if we're dealing with particular types of projectiles, such as we're dealing with in this case, which are expanding handgun bullets. This basically means that we're dealing with a construction that is designed to change shape if that projectile strikes something that is liquidy, and we are mostly liquid, so that would include tissue. A hollow point projectile is typically designed such that it has an external jacket made of copper. So my hands here are representing copper, and then that goes around it in 360-degree rotation. So in this demonstration, my finger's pointing up. That's the way the bullet would travel. A hollow point projectile has just indeed that, a hollow point cavity in the nose of the bullet. And it is designed that way such that if it's traveling stably, nose forward, and that hollow point cavity encounters something liquid, could be a gallon of milk sitting on a countertop, doesn't matter, or tissue. The liquid actually goes into that hollow point cavity, and because the bullet is traveling forward, you build up hydraulic pressure, liquid pressure, just like the brake lines in your car, inside that hollow point cavity. And so pressure inside that hollow point pushes the sides of the bullet open, and it comes open like this. So if I take my hands and make the model bigger for you, the jacketing material, the copper jacketing material that's facing forward as the bullet travels when it encounters something liquid and expands. Some people like the term mushroom. I don't prefer that term. But when it expands or encounters soft damage, the pressure builds up, and so that jacketing that was facing forward actually peels backwards, down, and around. But it leaves you with a forward-facing area of the projectile that's greater than the original caliber. In mushrooms, you get greater surface area presented to the way it's going. And when you do that, you increase drag. And when you increase drag, you decelerate or slow that bullet down more quickly. And so these bullets undergo or created through intense engineering by people at the companies such that they go a preferred depth in tissue or tissue simulant. So the main reason for hollow points in handgun in particular, whether that's somebody in law enforcement or somebody interested in protecting themselves, as opposed to going to, say, the range, would be to control penetration depth. So this bullet will stay in one body, and you don't over-penetrate and go through further. When I work cases that have non-expanding bullets, often called full metal jackets, typically you can see over-penetration. You can go clean through one person and on into another. So that's the hollow point cavity mechanism.
Where were the bullets in this case, Mr. Haig, recovered?
From my review, there were 4 fired cartridge casings and 4 projectiles and 1 small lead fragment that were recovered. And we can kind of go through these because this brings into play a term called the limited universe, meaning we limit our options. We take pieces of that puzzle off the table and put them in their place. So for example, 1 bullet was recovered at autopsy. The entrance gunshot wound was listed as over here on the right chest, as I recall, and the bullet was recovered in the back of the decedent. That bullet, in my examination, shows soft damage, expansion, just as I would expect from bullets of this type. That bullet's wound path in the torso is well documented, and so we can kind of take 1 of 4 off the table in that the entrance hole, primarily for me in the shirt, is a nice round hole indicating that it was not unstable, tumbling. Before it got there, this is basically a nice stable bullet entry, and that bullet was recovered there. So that's 1 of 4. Another bullet was recovered after going through one of the walls of the bedroom and through several cabinets into a bathroom area. And under examination, when I looked at that bullet, it initially looked mushroomed, which is why I'm not a fan of that term, because it had the visual appearance of it, but it was just deformed. Instead of the jacketing material unfolding as I described before, how bullets do in tissue, it was just collapsed. So if you see pictures of this bullet, which as I recall, this is bullet number 11 in the crime scene images, I believe. While it looks fairly mushroomed, it does not demonstrate soft damage. And the hole going into the bedroom wall is, again, a nice round hole, indicating that that bullet was stable when it struck the wall, had not struck something else first. So that's 2 of our 4 bullets that are sort of off the table, and we kind of know somewhat what their story is. A third bullet was recovered down a hallway from the bedroom and in a wall. And other crime scene images indicate that it had gone through things like a book, I believe a part of a mattress, and maybe a book holder before it got to the wall where it was recovered. Examination of this bullet was very interesting in that it shows no signs of any sort of soft damage or even mushrooming of the nose. The nose is in its basically initial condition, but it has a very classic and typical characteristic to it that I demonstrate in my recon class when I ricochet bullets off materials at shallow angles. So when I say ricochet, I mean the bullet came in at a shallow angle and continued on along its path. It's a flat spot on the ogive is the part of the bullet we're going to talk about. It's the rounded part from the nose down towards what's called the bearing surface or the cylindrical portion of the bullet. So it's a big flat spot because things like tile, what we describe as unyielding surfaces, meaning they don't give, the bullet takes up the damage, create those flat spots. In addition to that, when you look at the flat spot, you see scratches or stria on it from dynamic interaction with the surface. And those lines go straight from the nose to the base. That tells me this bullet, when it struck tile, is the likely thing in this scenario, the floor, it was stable. It was going nose first to get that flat spot and be scratched directly from the nose to the base. It then continued on down range and was stuck in the wall. That bullet gives us some idea of some trajectory, even though it's stuck in a wall just barely. You can, in the crime scene images, see it stuck in the soft drywall because it's downrange from the bedroom where all of the fired cartridge casings, biological matter on the floor is. But that hallway gives us sort of a path, a trough that the bullet had to have passed through. There were no other documented impact sites in that area. So we have what's called ballistic accessibility. It creates a path into the bedroom area. If we assume that's where the firearm was, which is a logical assumption in my opinion, based on the cartridge casings, the biological material, that doesn't overlap with another trajectory. I'll come back to that in a second. Our fourth bullet is found on the floor in the bedroom, in the middle of the floor. Its position to me does not really mean much because it's laying there just on the floor where it could have been kicked, could have been moved slightly. So we don't know where else it might have struck in that room. But the key thing about this bullet, and this is bullet number 5, as I recall, is that it does show soft damage. It is expanded. In the images, you would see the jacketing material is peeled directly back and is facing rearward. The damage to this bullet tells me it went through tissue, something soft and liquidy, not things like wood and drywall or glass, but rather tissue. In this case, is our limited universe option. So this bullet, number 5, would have had to have gone through the gunshot wound to the leg, which, as I recall, enters on the interior left portion of the leg and exits out to the right side of the leg itself. So those 4 bullets, and each one has a story to tell about what it did or did not strike. When in the hallway of this incident or otherwise, if we take the position that the firearm is generally just in the bedroom and is pointed in the same relative direction as the 2 trajectories that I've described for you, then it would have to be that the decedent was in motion, because we have trajectories in the decedent's body that are almost opposing. We have one that goes from, as described in the autopsy report, and this is how it's commonly described in such things, front to back, right to left, and as I recall, relatively flat. I think it was maybe slightly downward, but I've forgotten the vertical component. But the key factor is that one goes this way, and as I read the autopsy report, the other gunshot wound enters the inside of the right leg and comes out the exterior outside of the right leg. These are basically 2 relatively opposing trajectories on an object that undeniably, in my work, objects, bodies, regularly move in between shots for one reason or another. So given that, to me, those trajectories in the body indicate to me that the body was in motion.
All right, and with respect to the firearm itself, are you able to draw any conclusion whether or not that was in motion as well?
Certainly within the degree I've described before with the 2 trajectories that I can show you, the one that goes in the wall, for those that I can demonstrate by physical evidence, there was some motion. And as I recall from my measurements in the 3D scan data, it's something like 4 or 5 feet, at least, from one position of one trajectory's area over into the area of the other. As an approximation, again, because again, trajectories are approximations. Otherwise, beyond that, no.
So would it be safe to say that your conclusions support the fact that both the deceased as well as Miss Benefield would have been moving from right to left?
I can't tell you that the firearm moved from right to left of those shots. A statement of such would be supported by those 2 trajectories that I mentioned.
All right, would you please demonstrate for us now from the slides that you brought how you reached the conclusions that you did.
Sure, it'll take me just a minute to set up the laptop.
Yes.
Yes, please, Your Honor. Thank you.
Hopefully the nerd got them a longer HDMI cord. By the way, again, this guy's dad testified in the Hannah Gutierrez trial. He was not the jabroni that pointed the gun at the judge. He was the really good witness. Like really had his own gun made. Any blippiting around, Bob? Or are we?
Chuck, we are able to blippity blip. I don't think so. I
No,
think
you're
we're
live.
Damn it, man. Damn it, man.
But this guy is good, man. If he's gonna say something that is,
This guy's good, man. He knows
is
his shit, bro.
Yeah, and he knows how to explain it well.
Yeah. He's a science guy.
Yeah, Lucian Haig. If you
Science
guys
and the
remember, his
law.
dad's
Law.
Please.
What I'm showing you here is the 3D scan data of the scene. So I didn't take this data. This was done by Manatee County investigators. I took the individual scan worlds and then blended them together. This is a process called registration. And I'll move you through it. Hopefully we don't get a jump between my laptop and what we see on the screen. So again, this is not a computer game. These are actually millions of individual data points. You can see in some of these places the individual
God, they
spots.
better
Each
show
one of
this.
those is
I'm
a
gonna
data
lose
point
it.
collected by the scanner.
Show the fucking
And as we
screen.
look down on the scene here, you're looking at
Don't show it.
the
Portrait
sort
J.
of wood
show
looking floor. You can see
gotta be
a
kidding
tape
me.
on the floor. And now I'm going to switch perspective such that we're going to slide down to the side to allow you to get a feeling for what we're looking at. So as I move through this, you're now looking towards the doorway, exiting the bedroom over the top of the room.
Mr. Haig, I'm sorry to interrupt.
Please.
This is the room where
Oh,
the
there we
shooting
go.
took place.
There we go.
That's my understanding. There are
Hey.
certainly fired cartridge casings, 4 of them in the room, as well as a bullet hole going into the wall here.
Okay, and that would be the mattress on the right-hand side that was leaning against the wall.
That's correct. Where I'm moving my hand cursor right here in the data is a mattress.
Okay. And are you able to, from that perspective, yet see the entrance to the room?
Yes, I can swing us around so that we look into the room even, if you wish. So as I come down in the data, I can put us in the doorway.
Okay.
So that's a view into the room, and we can then even come into the room in that manner and pan around and see the room. Within the room, as I mentioned, we have a perforation into the wall, a nice round hole. As I recall, this is impact site 11, maybe. But if I swing around here, I can actually show you where that is. So the shadows you're seeing on the wall here are from the tools the investigators use. These are very common tools in our industry, trajectory rods. For this type of scanner, they often put a sphere over that rod. So that's why you see a round shape there as well. But the main point here is that there is an impact site in the wall right here. That's where a bullet hole exists. From that, I took two different approaches to create this trajectory for visualization for you. One, I simply took the scanned data, basically their trajectory rod in place, and looked at the many, many data points on that and extrapolated a line from it. If we use that method, the trajectory for that looks like this. So this is the blue line that comes out of that. And I'll swing you directly above it so you can get what's called the azimuth viewpoint first. I'm going to click us back into what's called an orthogonal view.
God, this guy's
so looking at this trajectory, you see how as viewed, it has a slight left to right aspect to it, and it's traveling from the bottom of the screen as you're seeing it into the wall at the top of the screen. Now, the county investigators did a nice thing. They did two different ways with this trajectory, not only the trajectory rod itself, but they took the rod and then put a laser on one end and shined it across the room. So the bottom wall, as you're looking at it here, and measured where that dot was on the wall. So I simply took their data and connected the dots also. So between the perforation in the wall to their laser dot, and that line looks like that. So green and blue. In the trajectory world with walls, this is decent agreement between these two methods as far as the accuracy that we come to. And in fact, if I put plus or minus 5 degree cones, I talked about the error earlier, on both of these, we can see that those two cones look like that. That's actually a 10 degree cone for each of them, the green and the blue. And so from the data that I have for this case, for this one shot, I would include any area within that cone, but either one of those cones, as the area where the firearm would have been at the time that shot was fired. I can also show you this from the side view to give you an idea of the vertical component. So I'm going to remove the left wall of the bedroom as you're looking at it here, and I'm going to swing you down. And from this vantage point, you can see how there is a downward component to these shots as well, going into that, I believe, again, number 11 hole within the bedroom.
Would that be consistent with Miss Benefield firing the weapon while she's standing in the upright position?
There are certainly multiple places along these cones where a shooter could be standing. So basically any hypothesis or any scenario that puts the gun in those cones, including that one, would be on the table. So we've seen the up and the down, the vertical component here. We've looked at the azimuth, the left and the right from above. What I'll demonstrate for you now with the data is I'm going to take you to the right.
If I may, Mr.
Please,
Hagan,
yeah.
As to that bullet, for the trajectory that you've just shown us, there was no indications that it had struck tissue. Is that correct?
That's correct. And I'll show you that picture of that bullet eventually. But this bullet, based on the damage that the bullet shows, as well as the nice round hole going into the wall, this is a miss of the decedent. This did not strike the decedent. If I take you to the side of the cone here, the far right side of the rightmost cone, our most right option, from that position directly over it, if you look down the hallway area, you actually, fill in, you actually cannot see where that bullet struck the wall. This area right here is to the right of the bullet's impact site. We actually have to move, as I will now, over into this area. And I'll get us right at the edge of the wall. We have to come all the way over here in order to get to the impact site, which from my examination of the images is more in this area. So somewhere on the tile in here is a bullet impact site, a ricochet off the floor. That bullet goes on and then barely perforates the drywall or penetrates the drywall up in this area. So,
and that's another bullet, is that correct?
Correct. Sorry, I'm on to bullet 19, as I recall, was its designator for those two.
Let me recap for just a minute. So one goes in the wall, and then one goes down the hallway.
That's correct.
And again, you can't say which shot was first or second.
I don't have physical evidence that would allow me to establish that, correct? But that bullet in the wall down there also expresses no soft damage. It is also one that did not strike the decedent.
A miss.
A miss.
All right.
So from the 3D laser scan data, and I don't have a good trajectory or a good impact site to look at here. I was unable to go in and examine the floor. If I'd been able to find that impact site, I might have been able to refine that trajectory into the wall a little bit better and give us a more defined trajectory. But other than the ballistic accessibility aspect of going down that hallway, I can't do that here. Just they're two separate trajectories that have some slight divergence in the lateral aspect.
Did I ask you what the degree of accuracy is for trajectory reconstruction?
Yes, you did.
I think we covered that turf, just that plus or minus 5 degrees is an industry standard. And based on having shot a lot of stuff, including walls, for a trajectory like that, assuming the trajectory rod was placed properly, about plus or minus 5 degrees is appropriate.
Did you have an opportunity, Mr. Haig, in preparation for your responsibilities in this case to interview Ms. Benefield?
I wouldn't describe it as an interview by me. I was certainly present while she described the incident.
And with respect to her description of the incident, is there anything at all in your conclusions that was inconsistent with Ms. Benefield's description?
I can't think of anything that would necessarily be inconsistent. The key points that come to mind, where I remember her saying she stepped from her right to her left during the course of fire, that the decedent was moving rapidly in all sorts of patterns or manners, which would fit with the gunshot wounds entering the body in different angles. So from that perspective, no.
Give me just a moment, Your Honor, please.
Yes, sir.
That's all, Your Honor. Thank you, Mr. Haig.
Cross?
I just have a couple of quick questions. So you were able to give opinions about where the trajectory would be for the two shots into the walls, correct?
That's correct.
But as for the injuries into the human, you cannot opine about that.
That's correct. I don't have any other sort of anchors to bring the decedent's body into play with the scene because of the lack of perforation.
Okay. And with reference to the chest wound, I saw you kind of turning it several times. So, and we've had terms used such as front and side. So if you could just show the jury, where was this entrance wound?
To the best of my recollection, and of course, I could refresh my memory with images if it's helpful, but to the best of my recollection, it's in this general area on the side of the chest, and then it goes in, is recovered just under the skin in the back. So if you're sort of the firearm location, it would place the upper body in a vague general orientation like this.
So if you turned your body straight.
Oh, this way?
Right. Can you keep turning until you get to the point where, okay. So that's approximately the positioning of the gun to the body.
The blade.
For the upper body, yes. I'd have no way of, yeah.
Thank
Correct.
you.
Blade.
Thank you. No further questions.
Redirect.
All right.
No, sir.
See ya.
Can this witness be released?
Who's
Yes.
next?
Yes.
Sir, you're releasing your subpoena. You're free to go.
Thanks, sir.
Thank you. It's going to take you a minute to put that away, and it's about 10 minutes after 3, so I want to give you your afternoon break. Give you 10 minutes, go on back, stretch, get something to drink, maybe a little snack if you want it, and we'll get you back out here as soon as we can. So no deliberations, don't talk with anybody about the case, and don't do any research. All right? Figured that'd be better than having you
Hustle. Thanks, sir. Appreciate it.
All right, we'll stay in recess for 10 minutes.
Thank you.
Did anyone hear how many witnesses he said? I thought 3 to 4, but I saw someone else tweeting out that there might be 5 witnesses left. I mean, we got 2 down, possibly 2 to 3 more to go. And if you missed it, the 4, 5. Chad is conflicted. The defense did say they're going to rest today, folks. So tomorrow will be rebuttal and instructions, I guess. Oh, crap. My lights just changed. I think we just lost power. Am I still on here?
You're still there.
All right. We have some weather, but my lights just, that must have been like a real quick. No, this is, I'm looking like the fucking sun. Ah, jeez. No. The big yellow one is the sun. All right. That's better. Thank you, Dawn. If you haven't hit that like already, please hit the like. Some people are thinking that went bad for the state. Interesting. Bad for the defense.
Really? I thought it went pretty well.
Do you guys think that was that extra was good for the defense or good for the state? I must there was a miss. I really I missed the cross or at least all of it. So what did they get across? You guys think that made that for the folks who think that was good for the state? Let us know. Yeah, it was like a vampire in stepping into the sun, Taryn. My lights I have on like the lowest. I don't even think this one's on the wrong setting now. Cold. Oh my god. 20%. No, these fucking things, man. There we go. Much better. If it was a fighting stance, he wasn't facing her?
But she didn't say. She said that he was like in the blade stance was always the thing. Right?
She said, yeah, for me, it was a wash. Jessica tuned him out. DG says 1,000% good for the. What is going on?
All right, hold on. I'll be back.
All right. I don't know why my lights keep switching, but thanks everyone for being here. We are on break until I think 3:20 Eastern, which is 8 more minutes. I am in the Twilight Zone, Scott. What is going on? Why do my lights keep turning on? Oh boy, it's haunted. Oh no. Oh no. Don't this is not if this is a ghost. Terrible. Does anyone know who the other 2 witnesses are? I forget what he said. Gremlins, son of a bitch. By the way, we will be on my channel tomorrow and Bob will be at Delphi tomorrow, folks, if you missed it. But Delphi is not live streaming, so Bob will be taking notes. 3-day hearing. So make sure you look out for those lives, which I assume will be in the evening, as they don't let you take in any electronics in the courtroom. Not even a watch, if I remember correctly from the last time Bob went. So he will be taking notes and then reporting back. Isn't it the worst, Rex? Rex says, I would vampire 24/7. However, I have a wife that likes natural light. I know, right? Like, why do we need the windows open? The ghost want. I'll tweet the Olympics. I wish I could live stream the Olympics, but that would be a disaster. First of all, on Peacock, I probably wouldn't even show up. And second of all, there would just be a bunch of copyright claims. I'd probably get kicked from YouTube. So can't take that. No, I didn't change the settings. They're just changing without me even hitting them. We're having weather here, so I just assume it's some power flickering. The 3-day hearing starts tomorrow. Thanks, Missing. That ping pong is amazing. Have you guys, has anyone watched the ping pong? They hold it in this way when they serve. It's wild. They hold it and they almost talk to it, and then sometimes they throw it really high, and they do their they're putting so much fucking spin on that ping pong ball, man. Ping pong is the shit, and I gotta wait till fucking Wednesday for the next USA match. My man, what's his name? No, I'm forgetting his name. Ja is his last name. I want him to win it all. Women's rugby is insane. I love that one USA lady. I don't know her name, but she is like a fucking full-on running NFL running back. She's awesome. She does social media. I'm sure someone in the chat knows her name, but she is a badass. She is a badass. Whoever that USA rugby lady is. Surfing. I haven't seen. Oh,
I'm not sure which one that was on. I think it was on
the
young Mr. Galvano.
Yes.
Hopefully, Bobby
Somebody might
Digital
use him as a
will be back here in a second.
give it.
Bob, are you there? I don't think they're back officially yet, but it's okay. Virtual ping pong.
I'm here.
Oh, there he is. I just heard. I don't think they're back, but I hear audio. I watched field hockey this morning. Oh.
This is Dr. Emma Lou, Your Honor.
Dr. Emma Lou is next.
Don't bring her in yet. I was just asking.
I couldn't believe how big the field was in field hockey. It was wild. Iona Mayer, thanks, Joni. Thanks, Ariel.
While we're
Is it
on the
Iona or
subject, how long do you think she's going to be? More than an hour?
Probably not. I would say maybe 45 minutes, my best guess.
No problem. I just versus 4 hours.
Correct.
All right.
No problem.
State, have you already deposed her?
Yes.
All right. So you know she's going to say,
Yes.
presumably what your question is going to be.
Yes.
I only ask because that will take us, assuming we start in the next, 5 or 10 minutes, 5 minutes, to 4:20. And I guess at that point, probably let the jury go for the evening. Well, you can announce you rest. We can let the jury go for the evening. You guys can say if you're going to call any rebuttal or not, but then maybe one pass through the jury instructions. I'd appreciate that.
So would I.
Okay.
Judge, the last thing the state wants to
Is he
bring up
inferring
is
this
that
is the last witness?
we didn't bring it up during the question, but I think that Your Honor had clearly told Mr. Taylor at the bench what he was allowed to ask Detective Warren. And that did not include, don't you find it odd that the state did not call you as a witness? And I think we had litigated close to that issue, if not directly on point, and then you directed him not to. And I know we're down to a few witnesses left, but it's been an ongoing attempt to subvert justice by Mr. Taylor to continue to do things like that, speaking when we've objected and continuing to speak. And As to the, don't you think it's odd, it was actually Mr. O'Keefe who told Mr. Taylor, hey, you need to object to this. So that's a whole different objection I have, that Mr. O'Keefe continues to practice law in this courtroom. But I just
Wow.
think that
Wow.
at this point, the state is
Spicy.
asking for you to sanction Mr. Taylor in some capacity about disregarding your continued rulings. And I understand that that may not be something we address right now, but it seems to be an ongoing issue in the state. That last one with Detective Warren was the most outrageous.
Wow.
Okay. I'm not going to take that matter up right now.
Yes.
We got witnesses and other matters to deal with, so.
I just wanted to get it on the record before we move too far away from the witness. Thank you for letting me be heard.
Absolutely. All right, looks like we've got everybody back. Is Dr. Lou ready?
Yes.
Staten, you ready?
Yes, Judge. Thank you.
We'll do that right.
All right. What do you bring in? Do you need the?
I don't think so, Judge.
What? I don't think so.
I don't think he hurt the defense. We agree. Oh, I agree. Kimmy's blessed. I thought that effort was awesome.
Thank you, Kimmy.
Oh, Dawn Burke. I didn't even see this. If you have PTSD, the first thing they teach you is to close your eyes and breathe. No question. Breathing. So important. Thank
I just got a $10 Venmo from Mary S. Thank you. Just thanks for all you do, Jay. Thank you so much, Mary S.
All right, you all can have a seat. Welcome back, everybody. Any deliberations, contact outside the jury about the case or research? Everybody says no. All right, Mr. Taylor, call your next witness.
Thank you, Your Honor. The defense calls Dr. Emma Wu.
You solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Good afternoon, Doctor. My name is Judge Whyte. I'm presiding over the case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. Just speak in a loud, clear voice. It does adjust up, down, left, right if you need it.
Yes, thank you, Your Honor.
Good afternoon.
Good afternoon.
Would you tell us your full name and spell your last name, please?
Yes, my name is Emma Lew, L-E-W.
And do you hold any professional degrees?
Yes, I am a licensed physician in the state of Florida, so I have an MD degree.
All right, Dr. Liu. Let's take a moment. Let me just run you through your undergraduate education. Where did you receive that?
I graduated from the University of Saskatchewan College of Medicine in Saskatoon, Saskatchewan, Canada.
And following your college degree, you attended professional school?
I did a one-year rotating internship in Vancouver, British Columbia, and started my pathology training in Vancouver. I completed my pathology training in Saskatoon, Saskatchewan, worked for 3 years as a staff pathologist at the Royal University Hospital, then came down to Miami in July of 1991.
And with respect to your work experience, what brought you to Miami-Dade County, Dr. Liu?
I wanted to train in the best facility
that there was for forensic pathology, and everyone in Canada and in the States said, go to Joe Davis in Miami. So I did.
And did you eventually rise to the position of the medical examiner for Miami-Dade County?
Yes, when I was in training, I was an associate medical examiner. Then Dr. Davis offered me a permanent staff position, and I was an associate for 10 years.
I want to ask you if you can tell us, if you can approximate the number of autopsies that you've performed.
In Miami-Dade County, it should be at least 5,000.
As part of your duties as a medical examiner in Miami-Dade County, Dr. Liu, did you also respond to crime scenes?
Yes, we responded to scenes of violent and suspicious deaths.
Would you tell us why? Well, first, let me ask, is it typical for the pathologist to respond to crime scenes? And depending on that issue, why you chose to do so?
Yes, in Miami-Dade County, when law enforcement needed a medical opinion, whoever was on call as the medical examiner would respond. And the purpose is twofold. Number one, so that we can provide an opinion about the circumstances of death or the types of injuries on the body, and also for our benefit, so that I can see, or we can see, the body in the context of its surroundings and be able to better interpret our findings at the time of autopsy.
Do you teach any courses?
Yes, I used to teach in the medical examiner death investigation course, and I still teach for the Carnival Cruise Line's security conference, and I will be lecturing in the Miami-Dade Police Homicide Investigations course.
And how about gunshot wounds? Have you taught courses in gunshot wounds?
Not entire courses, but I have taught the section about gunshot wounds in death investigation courses.
Let's not take anything for granted. If you'd be kind enough, would you explain to us, Dr. Liu, what is an autopsy?
An autopsy is the examination of a dead body. It consists of two parts. One we call the external examination, and that's when we look at the outside of the body and describe such things as height, weight, color of hair, eyes, scars, tattoos, any evidence of medical intervention, that is, any evidence that paramedics or doctors and nurses may have treated the decedent, and then any evidence of injury. After looking at the outside of the body, both front and back, and in the orifices, then we do the internal examination. And that's when we open up the body cavities to examine all of the organs and tissues inside the body cavities, from the brain inside the head down to the pelvic organs. That is an autopsy.
Dr. Liu, were you asked to assist in this case?
I believe I was, yes.
Would you tell us how?
I believe you contacted me.
And what did you do in preparation for your testimony here today?
I reviewed the autopsy report. I reviewed some of the autopsy photographs, and then other circumstantial evidence, as well as having spoken also with Mrs. Benefield.
Okay, I need you to try to keep your voice up. Did that include being present for Miss Benefield explaining what had happened?
Yes, I had made a previous trip to Bradenton and had met with Mrs. Benefield.
I'd like to ask you, Dr. Liu, about the gunshot wounds in this case.
Yes.
Will you tell us how many there were?
There were 3 separate gunshot wounds.
And would you please explain them?
Yes. One was a superficial gunshot wound on the right upper arm. And that we call a grazed gunshot wound. That was one of the gunshot wounds. Shall I explain the direction?
Please.
Now, you probably heard about pathways of gunshot wounds from Dr. Vega. But as a quick refresher, if, for example, a gunshot wound was from front to back and right to left, that is relative to the person shot, not to you, not to Mr. Taylor, but relative to the person shot. So if it's from front to back and right to left, it is coming in from the victim's front towards the back and from his right side towards his left side.
And was there another gunshot wound?
Yes, there was another gunshot wound on the right side of the chest, just outside of the right nipple.
Please do.
And yes, the pathway of that gunshot wound happened to be from front to back and right to left. And I'm sure Dr. Vega told you it just nicked the bottom of the right fifth rib, went through the right lower lobe of lung, then through the part of the spine, the bone of the spine, then the left lower lobe of lung, and then nicked the back of the left 10th rib.
And lastly, was there a third gunshot wound?
Yes, there was a gunshot wound. This time it was a through and through gunshot wound, or what we call a perforating gunshot wound that entered the inside back of the right thigh, went through both right lower leg bones, and came out the outside of the right lower leg just below the knee. And that pathway was from back to front, left to right, and upward through the right lower leg.
Let me, if I may, using the easel, show you a picture. And have you explain to the ladies and gentlemen of the jury, you mentioned that the abrasion wound to the arm, did you tell us what the trajectory was for that?
In my opinion, the pathway of that bullet was from front to back, upward, and slightly left to right.
Okay. So how, Dr. Liu, are you able to reach a decision like that on something like an abrasion wound?
Through experience and training, having had hundreds of gunshot wound cases and seen thousands of gunshot wounds and supervised hundreds more cases.
Okay, let me show you these two demonstrative aids and ask, with court's permission, if Dr. Liu could step down. I wonder if we could have the easel so I could set these up. Dr. Liu, here is a pointer that will help you.
State, feel free to reposition as you need so you can see what's going on.
Thank you, Judge. With court's permission,
Yes, ma'am,
I
you can
ask
step
Dr.
down.
Liu to
Thank
step
you.
down.
State, have you already seen these?
Yes. Not until now, but I just saw them.
Okay.
You have a preference of which one you'd like to start with? Okay, this one. All right, would you tell us what that represents, Dr. Liu?
This is the grazed or superficial gunshot wound on the outside of the right upper arm. I know there's
Yes, a rod. We have three.
Now, the reason I know that this is a grazed gunshot wound is, from training and experience. Now, the direction of this projectile, you see this edge is a little bit more rounded, and because it's a deeper red, I know it's a deeper part of the wound than here, for example. Now, as the projectile skips across the skin, because it's so superficial, it raises skin, it causes skin tears and raises skin tags. Now, there's some skin tags here, but the best one is this one right here. See this V-shaped tag? And for simplicity, how I remember pathways of graze wounds is that the skin tags point toward the gun. So, if it's pointing in this direction, the gun is somewhere along this line here. So the bullet, therefore, is coming in this direction, going from front to back. This is the front, this is the back. Going from front to back and upward. And because it's on this part of the line, you can see it's slightly to my left, to my right. So this is from front to back, upward, and slightly left to right.
If I may.
This is the gunshot wound that we just spoke about. You can see how it's going front to back and upward. This is the right nipple. This is the second gunshot wound. But it's been a bit changed or altered because the back portion that's straight was an incision made by the doctors in the hospital. So the gunshot wound itself is this round part. Now this is the one that goes from front to back and right to left. The bullet was found by Dr. Vega on the left side of the back. Now, there's something special about this gunshot wound that Dr. Vega may have told you already. After going through the nicking the right hip rib and the right lower lobe of the lung, it then hits the spine. Now, the skull closely surrounds the brain and protects the delicate brain. The spinal cord is an extension of the brain, and the spinal cord is protected by the spine, which is made up of multiple blocks of bone. When a projectile cuts across the bone of the spine, even though it doesn't touch the spinal cord, the energy that is expended by the bullet impacting the bone is transmitted to the delicate spinal cord. And what this wound will do, because the bullet went across the bone of the T10 vertebrae, it causes a spinal cord shock. And the result is paralysis of the legs. I know because I've had cases like this where a bullet not even going through the bone of the spine, just passed by the side of the spine, caused the man to fall on his back, and he was heard to say, "I can't feel my legs." So that's something that's significant and important about this gunshot.
All right. I think you can probably return to your seat if you like. Does it have some water in it?
It does. It's too complex for me.
Let me see if I can help.
Not too much. It's me. Probably the white brown tissue.
Dr. Lou, did you have an opportunity prior to your testifying here today to meet and observe and listen to Miss Benefield explain the events that took place on that day?
Yes, I did. It may have been last year that I did that.
Is there anything at all with respect to your findings that is inconsistent with the explanation Miss Benefield gave?
I believe that Mrs. Benefield's account is consistent with the evidence on the body, and I can demonstrate that.
At the time that you observed Miss Benefield explain these events, did she know what the actual physical evidence was, the actual
Objection.
forensic
Here's the
evidence?
If she can answer without speculating.
I do not know. However, usually the person doing the shooting does not know about the autopsy results. And even if they got the autopsy report, they would need someone to translate the autopsy report for them. So I doubt it, but I am speculating.
Were you struck by the explanation you received in light of that?
Objection relevance.
I'll sustain.
One last question, Dr. Lou, if I may. How many times, if you can approximate, have you appeared as an expert pathologist and testified in court?
During my career, at least 500 times, and then maybe 20 some times more after I retired.
And the vast majority of those occasions, did you testify for the defense or for the state?
Most of those times I testified for our state attorney.
I have nothing further, Dr. Lou. Give me just a moment, Your Honor. Yeah. Dr. Lou, would it be helpful if I were to volunteer my law clerk to come up and allow you to show with the trajectory rods the wounds that were sustained by the deceased?
I believe it would add a new dimension to my testimony. Yes.
Okay. Judge, with your permission, may I?
Yes.
Come on up, Will.
May I step down, Your Honor?
Yes, ma'am. Please do.
May Dr. Lou step down?
Now, I believe that the Gray's gunshot wound was the first gunshot wound because Ms. Benefield indicated that Mr. Benefield was coming towards her.
Objection, Judge.
I'm going to sustain.
Go ahead, Dr. Lou. You just can't say what Ms. Benefield told you,
Okay.
just based upon your conclusion.
I believe the first gunshot wound.
And I would object to that opinion, Judge.
I'm going to need you to approach, please.
What I miss? Is she done or just an objection? You're muted, Bob.
Yeah, she's still on the stand. That
Oh,
was an
okay.
objection. she was starting to give her opinion as to what shot she believed may have happened first.
Okay. Hey, Lauren, what's up?
Oh, Lauren's in the house. Girl. I muted so my
Without
ears and
regard
squeak.
to anything that Ms. Benefield may have said that you heard, based upon your expertise and your own conclusions that you reached, do you have an opinion as to which one of these shots may have been fired first?
I believe that the right upper arm raised gunshot wound was the first shot.
Are you able to say why, what independent evidence exists that leads you to that conclusion?
I have based my opinions on the circumstances provided to me.
Okay. And would that be consistent, the upper right arm wound, would it be consistent with the bullet that went down the hall, for example, and lodged in a book?
Yes, it would be, because it didn't go into the body, it just went across the skin. So the bullet would be free to continue on into another room.
Okay, and because it was just a graze, it would not have any tissue effect or mushrooming, as they say, correct?
Objection.
If she can testify to that from her knowledge and experience.
Because it only grazed the skin, nothing went into the hollow point nose of the projectile to cause deformity or mushrooming of the projectile. So it would be more or less pristine.
All right. Now you've told us, Dr. Liu, about the shock to the spinal cord from the shot that entered the chest.
Yes, going from front to back and right to left.
Would that have, in your opinion, affected Mr. Benefield's ability to stand?
Yes, as I explained earlier, it would cause a spinal cord shock, causing paralysis of the legs and causing Mr. Benefield to fall.
And in falling, would it be consistent that his legs would go up in the air almost as if he slipped on a banana peel?
Yes, that would be consistent, and I can demonstrate.
Slipped on a banana peel.
With your right side facing the judge.
Judge, with the court's permission, could the jurors perhaps stand so that they could see this demonstration?
Judge, I'm confused as to what we're demonstrating.
Get a banana peel in there right now.
Oh, the shot to the leg.
Yes, sir.
Okay, folks, if you need to stand to reposition yourself.
And I want that noise, like the Flintstones.
Was on the right side of the entrance was on the right side of the back of the cab, and the exit was here. Now, you can see that the gun would be somewhere along here. So you can see how consistent this pathway would be from getting shot while it's on the ground, with the gun being in this position. So it's going in here and coming out here.
Okay, so this would be, in effect, a snapshot in time.
Yes, it happens very quickly.
All right. And would it be consistent, Dr. Liu, with the shot to the chest, paralysis, Mr. Benefield falling backwards, his legs going up in the air, and another shot going through the leg?
Yes.
All right.
The evidence on the body, which consists of those gunshot wounds, is consistent with that.
All right. Thank you very much. Thank you, Will. I have one last question for you, Dr. Lou. You can take the witness stand. Do you recall whether there was any other injury to Mr. Benefield that would be consistent with his legs going up in the air and him falling backwards so that his head would hit a tile floor?
Yes, Dr. Vega found an abraded contusion on the back of the head. A contusion is a bruise. An abraded contusion means that there's a little bit of scraping of the skin or a crushing of the skin in the center of that bruise. That is entirely consistent with Mr. Benefield's back of the head striking either the wall or the floor as he fell on his back.
Thank you very much, Dr. Lou. I have no further questions, Your Honor.
I just want to ask you about the leg wound.
Yes.
For a moment. You're not saying that that is the only position that he could have been in, are you?
No, I am not saying that.
Okay. So there are other positions that maybe could have produced that wound path.
Yes.
Okay. The one that you are describing is just one that is consistent with it.
That is correct.
And when you said his spinal cord would be, I don't know what you said, shocked, maybe?
Yes.
Concussed? I don't know what you said. And his legs would go paralyzed.
Yes.
Does that normally mean that they stiffen, they straighten? Does it mean they crumble? What does it mean?
Different people react differently depending on the position that they're in. And paralysis usually means just not being able to move.
Okay. So depending on maybe what movement they're doing at the time, that's what they're going to continue to do.
Possibly,
So,
yes.
possibly. So if he is walking towards someone, we fall backwards with paralyzed legs?
Well, we weren't there, so I don't know exactly his body positioning and movements.
Okay. And you spoke about the abraded contusion on the head, and that can be consistent with falling.
Yes.
From a gunshot. Can it also be consistent with being drug out of the house by EMTs?
Not unless that part of the head would be struck on something, because the contusion is a bruise, which requires blunt force.
Right. So if, for instance, he was being drug out and hit the door jamb or something, bounced his head.
We're blaming the EMTs
that
for
kind of abraded
knocking him
contusion
into
on
the
head?
door?
Well, done with enough force.
That's right, Kay.
That is
What do you have to say
possible.
about it?
Okay. Thank you. No further questions.
Call the EMTs to the stand right now. I want them on the stand.
Dr.
Wow.
Lou, would the abrasion wound to the right arm of Mr. Benefield be consistent with him lunging towards Miss Benefield?
Remember, the pathway is from front to back and upward. So if he was lunging and you were the shooter, you can see how that would be consistent.
That's all. Thank you.
Do you have any questions on that?
No.
All right, can this witness be released? Can the witness be released?
Yes, sir.
State? Ma'am, you're released from your subpoena. You're free to go.
Thank you, Your Honor.
Thank you very much.
Rest. Defense rest. Come on. Oh.
Hey, I need you to take a look at this sticky note. I wrote a note on it.
Mr. Taylor?
Read it.
We have this one issue left.
Okay.
What one issue?
Does that mean no
All
more?
right, jury, there's a legal argument I need to take up. If you could step out for about 10 minutes for me, we'll do that, then we'll bring you right back. No deliberations, no communicating with anybody about what we've talked about the case, and don't do any research on any of the issues. We'll get you right back in a second. you all can have a seat. The jury's out. And was this the issue, the Richardson?
No, this is the DNA issue.
Oh, yes.
And I have the following case for the court. Ladies.
Thank you.
Yeah.
Yes, sir.
Well, I think the judge had some Hot Pocket on his robe there. See that Hot Pocket? Drip some cheese. I had this little blanket on my lap from earlier. I had a different shirt on, and it's like a blanket on the dude's bed over here, which he's possessed our chaise lounge, which we have in our bedroom. And I put this little green blanket on me, and I had like a full coat of hair on my shirt. It was unbelievable. I just brushed this dude too. He's a very hairy guy. Oh, thanks, Spitfire. Yeah, the ads. I mean, how long do you have to watch it before you can skip? Like 2 seconds? I don't even know.
Are they going to actually argue anything? What's going on?
They're shuffling paper, Jay. It's important.
Lot of people are shuffling today.
Just let them.
I'll be right
shuffle.
back. I gotta go
All right,
feed
don't
the friends.
fall in. Don't fall in.
I gotta feed the friends. They are up right over. I'll be right back.
Just a couple of guys, a couple gals, just waiting around, trying to get fed. Yeah, I don't even know how much they pay us on those ads, to be honest with you. I don't know. Are they taking a quiz, a pop quiz, on their favorite Hot Pocket flavors? No, we don't love Hot Pockets, but this judge looked exactly like Jim Gaffigan, who has an amazing Hot Pocket bit. Actually, he's done a few bits on Hot Pockets. It's kind of his go-to.
Hot Pocket. Hot
That's him.
Exciting news for me, Bob. Someone bought a sound machine. First sale from one of my ads on TikTok. I made $1. Big day for me. Big day.
Yeah. Yeah. Jay, what are you going to retire now?
I'm retiring. Sorry, Bob.
Are you going to tape that dollar on the wall?
It's you by yourself now.
God damn it, Jay.
But I did get
any warning.
I did get a message from someone. Allegedly, he's going to send me a free sample for some mushroom coffee. So we'll see how that works.
Oh, you should really hate that.
Fancy pants. Usually when they message me, that means they'll actually send me the sample, but we'll see. They ain't getting shit from me unless they send me a free sample, though.
It's like Kaylin is lurking and working.
We love our lurkers.
We do indeed. We do indeed. Our girl Lainey had to put her best boy or love bug, Bubba, the puppy down.
I saw that. So sad.
Dang.
Thanks, Cabo.
So sorry, Lainey. Catch this. So sad. Ugh. I always start worrying about when my guy might go. It's terrible.
See, I'm not worried about it because I don't know if you know this, Bob, but both my dogs are immortal, so I'm not even worried about it. I'm not going to think about it. I'm not going to worry about it. They're immortal, and
I want an immortal dog, Jay. Where do I get one?
It's in a land that I live in called the Nile. You can get one.
Is there a river there? Hey. Oh yeah, Panny. I've heard of that mud water. It's a little earthy. I imagine it's pretty earthy. It's got a little peaty. It's got a little peaty aftertaste. It's peaty.
Here's the question about the mushroom coffee. I need to know the caffeine. That's what I care about. I could put some stuff in it to make. Let's see.
I just want to know if you trip balls. Is there a lot of balls?
That would be fun.
Do I trip balls when I drink the mushroom coffee?
That'll be a stream.
Ooh-wee. Yeah, we'll both drink the shroom coffee. Trip balls.
All right. Go ahead, sir. I've had a
Watch
chance
something
to
hilarious.
review shorter.
Okay, so this was a DNA report, precisely what the circumstances are here. The state initially wanted to introduce it, then changed their mind because it didn't have any inculpatory conclusions for purposes of the defendant. At that point, the defense moved to introduce it because it was exculpatory. The court allowed the admissibility as a business record, distinguishing it from Crawford because since it was the defense that was seeking to admit it, the confrontation issue was not essential. And on appeal, The appellate court sustained that admission under the business record exception, which is precisely what the circumstances are here, Your Honor. So I can't imagine that the state is going to, and I would further say to the court, the chain of custody is irrelevant. We're not objecting to the chain of custody. I can't imagine that the state would object to their own chain of custody. So we think that the Shorter case clearly establishes that the court can admit that DNA profile, the results, as a business record.
I thought I made it abundantly clear. I'm not objecting to it being a business record certification. That's what I said 6 times. My objection is that there has been no foundation laid to then make that report relevant. That is hearsay in the report. The fact that those swabs are identified to Ashely Benefield or Doug Benefield is hearsay to DNA labs. That means some crime scene tech who did not testify before this jury went and collected his DNA stain card. A different crime scene tech who testified she swabbed her but was not shown swabs to make sure those are the correct swabs, then swabbed her and put those in property evidence. That's all. We don't have any evidence that the same swabs that she was collected then went to DNA labs. And that's what you have to lay the proper foundation. And this is the case I was referring to when I didn't refer to it by name, but this is what I read when I made my objections, because my objections are what I've already stated, but also 403, with just that lab report in evidence. This is very confusing. It's DNA, and it's overly prejudicial to this jury for what I think what it says is this state didn't argue, and I am arguing, how the forensic casework would be unfairly prejudicial or confusing in regards to the work of the jury. This is DNA. I don't know, they sent us the bench notes and the report, but there's no explanation of the statistics, how they came upon those statistics, where those swabs came from, all those things, and I think that will be very confusing to the jury without somebody here. So I'm not making a certified business records objection. I'm making an objection to the contents, and that there hasn't been an adequate foundation, and that they're confusing.
I'm making an objection to your stank attitude, my lantern. Every time.
Warren sent the swabs to the lab. Megan Dorbeck testified that she swabbed Miss Benefield. I asked her why. She said because it would show who had touched her. The court should recall, consult your notes, Your Honor. Miss Benefield testified that Douglas Benefield grabbed her by the hand and spun her around as she tried to leave the house. This report corroborates that to the extent of, I think, 720,000 times more likely. We think it's an essential component of our defense. Now, we don't have any. Chain of custody is irrelevant. Even though they've just basically undermined their own chain of custody, it's not an issue. It's the result that for our purposes and our defense is essential, Your Honor. This case allowed it to be admitted as a business record. The assistant has made eminently clear that that is not why she's challenging it as a business record. I don't seek to introduce the entire report. I will be quite happy reading these 2 sentences, if I may.
Thank you, because I haven't seen this. Thank you. Final thoughts? Is that everything?
Yes, sir.
This is what I've been handed is not marked as an exhibit. It's a 5-page document from DNA Labs International. It's a letter or a report to Detective Justin Warren and a sergeant at the Manatee County Sheriff's Office. And it is signed by Jerome Rem, R-E-M-M, forensic DNA analyst. It lists a number of items. $14 different items that were apparently sent to DNA labs for DNA testing. And the particular section the defense says they want to admit is agency item number MRD5, which would correspond to DNA Labs International item 20-10880, swab from suspect's right hand. And it says that the testing was done. Mixture of 2 individuals, at least 1 male contributor. And it says Doug Benefield and John Sant could not be ruled out as possible contributors to this foreign DNA profile. And it gives, based on its testing, 2 different propositions that were considered to explain the results. One is the DNA profile obtained from the swabs is 720,000 times more probable if the sample originated from Ashely Benefield, Doug Benefield, and 2 unknown persons than if it originated from Ashely Benefield and 3 unknown persons. So there's strong support that Ashely Benefield, Doug Benefield, and 2 unknown persons contributed to the profile rather than Ashely Benefield and 3 unknown persons.
Judge, I would ask you to read that next sentence.
I am. I'm reading it as I go.
Okay, thanks, sir.
If applicable to the case, it is recommended that reference standards from any first-degree relatives of Doug Benefield be submitted for additional comparisons. And I think this is the second proposition that DNA Labs is considering. The DNA lab profile obtained from the swabs is approximately 75 million times more probable if the sample originated from Ashely Benefield and 3 unknown persons than if it originated from Ashely Benefield, John Sant, and 2 unknown persons. Therefore, there is extremely strong support that Ashely Benefield and 3 unknown persons contributed to this DNA profile rather than Ashely Benefield, John Sant, and 2 unknown persons. The DNA profiles of additional contributors to the mixture were not determined. However, there's results that are suitable for comparison. All right, so obviously those of us who have done a number of these cases understand what those statistics mean when you're looking at known standards versus unknown DNA samples or swabs and the comparisons. I am not sure, and I do not have the belief that the interpretation of DNA results as outlined in this DNA Labs report is within the common knowledge of a lay juror, a regular juror. That's why the standard we usually see is one of the parties, whoever it is, whoever the proponent of the evidence is, calling the DNA analyst, generally after showing and evincing whoever took the sample, packaged it, where it was stored. It was then sent from the property and evidence room to the DNA lab. Then the DNA lab analyst will say how they went and got it. And I'm just going to disagree that chain of custody is not important. That's why we have it, and that's why we have certain predicates to establish evidence from a crime scene to court and who touched it and how it changed and what was done to it. So I disagree that that's not important.
Isn't that when the defense contests?
In the problem, well, I gave everybody the chance to argue. So I got a chance to read the shorter case, and the shorter case supports what the court is saying. It says that they leave the issue for another day, whether it could qualify as a business record. However, there remains, and this is at 692 of the decision. However, there remains a very significant section 90.403 concern about the admissibility of a DNA forensic report if the expert preparing the report does not testify. And the reason the fourth DCA, it says so in the very next paragraph, the reason the fourth DCA upheld the admission was for that very reason, that the state did not argue 403. And here they are. Here the state has argued the 403 for a jury to understand what these mean, what these findings mean. I don't find that the probative value is, I do find the probative value is substantially outweighed by the danger of the confusion of the issues, the misleading of the jury to try and understand what this report says and be subject to cross-examination from, well, this time it'd be the state, but it's usually the defense, to explain, where do you get this? How do you get 720,000 times? How many loci were matched? How did you conduct these evaluations? And then what does it mean, the very strong support?
That is.
And then it's also, you've got, the other problem is, Mr. Taylor, you're telling me you only want to read this, you said two sentences. Yeah, these two sentences that are highlighted.
Correct.
But that's only one of the two sets of propositions that could potentially explain this. And the first proposition you want to use doesn't even mention Mr. Sant. And if I'm reading this correctly, there's also a recommendation that there should be some additional testing. There's also additional DNA profiles that are in these mixtures from Ms. Benefield's right hand that are suitable for comparison and have not been compared. So, I mean, I have significant concerns about the misleading of the jury by putting this in. It would, if it would,
Thank you, Helen Steiner, who just got me another thing of UCC, got delivered today. Helen, you're the best. Thank you, Helen.
So, no, sir. Based upon the request that's before me, which is only to put in and read into evidence these two sentences regarding one of the propositions that was considered by DNA labs and interpreting their test results, certainly that would be even more misleading because it doesn't get into the other proposition and the other testing that needs to be done. So based upon that, do you want to have this marked and put into evidence?
Yes.
As a proffer?
I'd like to proffer for the record, Your Honor.
Do you want to put a number on it? What's your next number?
It's 29, but this is the whole record.
Well, hold on. You're handing me a stack of paper that's about, what, 1.5 inches tall?
Yes.
And the only thing you said you were going to enter was this 5-page.
Well, no, I said the only thing I wanted to enter was to read those two sentences. This is the full report.
All right. So it would be your intention to admit into evidence Defendant's Exhibit 29. What is this in here? Or does this go in here?
Yeah, no, that I believe is in there.
No, it goes.
This comes back. Oh, I'm sorry, Ron, I stand corrected. This goes in with the report.
I'll let you put it where you want it.
All right, can I make a proffer for the record?
Yes, absolutely.
All right, thank you.
So beyond, I thought you already did. This is the proffer.
Well, I'd like to make a verbal proffer as to precisely why I think it should be admissible.
Yes, sir.
Okay, so unlike a DNA report that's inculpatory, which requires a chain of custody so that justice is established in the admission of inculpatory evidence. In this instance, Judge, we believe this DNA report is exculpatory. And we believe it's exculpatory because it confirms Ms. Benefield's testimony that Doug grabbed her by the hand and spun her around as she tried to flee. It's independent evidence that not only corroborates Ms. Benefield's testimony, but also corroborates our defense. And because it is exculpatory, chain of custody is irrelevant. We are making no objections to chain of custody. The case law that I submitted to the court, the shorter case, clearly would allow it. And it would be my intention, which I don't think is confusing at all to the jury, to tell them the DNA, reading from the report, the DNA profile obtained from the swabs is approximately 720,000 times more probable if the sample originated from Ashely Benefield, Douglas Benefield, and 2 unknown persons than if it originated from Ashely Benefield and 3 unknown persons. Now, maybe I misunderstand this, Your Honor, but to me what that says is there's 720,000 times more probable that Doug Benefield touched Ashely Benefield's hand. That's what I believe this says, and that's what I think we should be entitled to get to the jury.
Thank you. Do you want that right after the first page?
You can put it right on top.
It'll cover up the exhibit number then.
Oh, okay. Yeah,
so I'm just putting it right behind it. And as I said in my ruling, I think that those questions and what that means and how it's interpreted and how the jury can use that to be relevant to its deliberations and its findings. I'm not saying it's not relevant. I'm saying the problem is 403, as the fourth DCA recognized, not having that analyst causes significant 403 problems with confusion and misleading. So that's the basis of my ruling.
What if I told the court that the actual DNA lab expert is available, but not until after 2 tomorrow? And it would have to be by Zoom.
There's motions that Florida Rule of Criminal Procedure 3.116 defines how and when that can happen. So we need to bring the jury back in, and I just need to know if your intention is to call more witnesses or if you're resting.
Well, I make a formal request that the court abate the proceedings so that we could call the analysis. If the court denies that, then we will rest.
All right. Well, there's Florida Rule of Criminal Procedure 3.116 is very specific. It just came into effect. It was just substantially, I'll say substantially, amended effective July 1st of this year regarding the use of remote technology. If you want some time to look at that, I can certainly give you that.
I'm familiar with it.
Mm-hmm. So do you have
We'll rest.
Okay.
There we go. Finally. Jeez.
Fence rest.
We can do that. Then I can let them go for the evening. I'll tell them to be back tomorrow morning at 8:45, just like we've been doing with a 9 o'clock start.
Yes, sir.
All right, then. So it's lining up for rebuttal, closing, deliberation.
Just so you know, also, we had submitted, the court may recall, you requested copies of the proposed homicide charge, and we had submitted our version to you that we thought would be appropriate, and I did not save a copy of it, so I don't know if the court has it.
I will have to look. Did you send it by email?
No, I believe we handed it to Your Honor.
All right. Welcome back, everybody. Y'all can have a seat. All right, did anybody have any deliberations, talk with anybody outside the jury, or do any research? All right, everybody says no. Mr. Taylor?
Yes, Your Honor, Ms. Benefield has no further witnesses, and we rest on her behalf.
All right, sir. Folks, at this point, it's 4:30. The attorneys and I have some work to do before we can get things going again in your realm of the case. So what I'm going to do is let you go for the evening. If you could please be back tomorrow morning at the jury assembly room around 8:45, just like today. There were probably people down there today. I don't think, was there any civil juries or do you know? There might be a smaller group tomorrow. There might be some judges in civil court picking some juries. So find your area and kind of hang out, and we'll have the deputies come down and get you as soon as we're ready and bring you up and get started.
Yes, sir.
All right, remember the rules for tonight? Don't talk amongst yourselves. Don't talk about the case with anybody else, and no research about people, places, things, or legal topics.
Thank you.
Thank you. Have a good evening.
Fortunately, SSDGM Indy, we typically don't drag our sound clips from one trial into the next because we come up with new ones every single trial. Like we haven't used our Bukakis, any of our classics from the Reed trial.
It'll be retired, sent into the rafters.
Yeah, they're only good when they make sense, you know.
So, but don't worry, we'll have another annoying one for the next trial.
Exactly. And just remember this, SSDGM. All right, I got the poll up before we bounce. I want everybody getting in.
I'm going to have to give you
75 votes.
Let me give you guys a 5-minute break.
Votes. Let's go.
I'm going to go upstairs, and I don't have it in the pile I have with me, but I have a whole other pile. So let me run upstairs and see if I can find
clip.
Yeah, it was. Yes.
And I have the state's proposed jury instructions and the standard for self-defense because it changed in May, and I just wanted to include it. In case
So you got the new one.
Yes.
All right.
But I brought the standard because the instructions are very different than they used to be, so I just brought an extra copy so we could go through
And you have an extra copy for.
Yes.
So 5 minutes. I'll be right back down as soon as I check.
Thank you.
Folks, Helen Steiner just sent me $60 via Venmo for UCC coffee.
Helen's the
Baby.
best.
That is
Helen,
amazing.
you
She's
are the best. Thank you, Helen.
She is a love bug of the nth power. Can I get pods? You get pods with those?
Nah, dude, they're canned. It's canned coffee.
Like I crack it open and enjoy the can?
Yeah, that's exactly what it is.
Oh,
Don't
my
have to refrigerate it.
What? Is it delicious? Is it cold brew?
I mean, didn't you say you got rid of sugar though? I mean, they're filled with sugar.
Oh, they are. Oh, so they're delicious.
Oh, delicious. It's
yeah.
I mean, there's
man.
there's about 6 days of your daily need for sugar in one.
Oh my! Wait, Jay. There is no daily need for sugar. That is
right.
It's
You're
not
right,
a
whatever.
vitamin, man.
The recommended dose, whatever they say on those cans.
There's no recommended dose of sugar. We
Yeah.
suggest you have at least 4 grams of sugar per day.
There's
Otherwise, you'll go insane.
6,000 grams of sugar in those.
Oh my God. All right, man. So I got the poll up. We got 106 votes in. It's pretty heavy. 86% not guilty, 14% guilty. Now, that being said, we still do have the rebuttal from the state, and we also have closing arguments. Maybe the state's going to be able to wrap this thing up in a real nice tight bow for us during closings. I don't think so, but who knows? But yeah, early on, it's looking pretty. And I never put hung in there because that's not something the jury can decide. They can only decide guilty or not guilty. They can't decide to be hung. They can agree to disagree, which results in hung. But second degree murder, Donna, second degree murder is what she has been charged with. I think that's the main charge, or maybe another one, but the big guy. And then I think lesser includeds are probably available as well. So voluntary manslaughter, maybe. But second degree murder is the big one. So where are you at, Jay? What are you thinking? If you I had to put your feet to the fire,
What I would vote or what the jury?
yes, sir, what would you vote?
I would be a not guilty because I just don't think the state has proven their case. I think, like I said before, I think what the state, the defense brought up was valid abuse, and I know people are like, well, it doesn't mean you can murder someone, but to me, they can't prove that he didn't do something that made her scared for her life. I personally would be a not guilty if I was on this jury.
Me too. I mean, aside from like what happened during the defense's case in chief, putting aside her testimony and that brutal cross, state just didn't prove the case. And like I said, going in, this is like a really, really hard case to prove, because you're not going to have anybody witness to what was going on in that house other than Ashely herself. And then you've got basically to just be able to demonstrate that she was plotting this somehow. This is something that this was an ambush, that, she got him over there with the expectation that he'd pop off at some time and that, she could goad him into doing it. And she did. And then she had her gun all set up, all neat, like in her little bin there at the top, not buried under a bunch of I mean, you can make an argument for it. I mean, her gun was certainly one of her many guns, was certainly conveniently packed, in terms of getting to it quickly. But I just feel that she was abused by this guy. And I don't care what type of gap there is, because from my own experience in terms of handling divorce cases and custody cases, along with, the criminal practice, it's like, it doesn't matter. People don't act, a fool when they know that they're, in litigation. They hone their shit down. They're not popping off. They're not threatening. They're not doing all the things that they were doing, which led up to the divorce, because they're trying to prevail in court, whatever the case may be, whether it's getting custody of the kids, whether it's, I don't want to pay alimony or whatever the case may be. People just don't, they're on their best behavior when they're in litigation for the most part, unless you have people that just can't control themselves, and there are definitely people out there like that. But in my estimation, this guy, like just the main things that you and I have kind of pounded the table about, like both here and on Twitter, Jay. And, dude fired a weapon like in the room with her into the ceiling. That's fucking psychotic. Like anybody who's like saying, that's not that big of a deal. Yeah, really? It's a huge deal. If I was in a party and like one of my friends is in an argument with his wife and he pulled a gun out and shot it in the ceiling, I'd think he was out of his fucking mind. I'd be like, what? And now subtract everyone else out of that situation. You've got a dude like firing a weapon into his, it's no self-control.
Or
that's anger off the charts. It's scary, man. Like there's, and obviously punching the dog in the face.
Right. Or another witness who was not this defendant, saying that we got out in text messages, he put a gun to his head and also struck that witness, I feel like kicked her on their honeymoon or whatever. Like someone like came at me on Twitter like, oh, he drops character. I'm like, what do you mean he drops character? Have you not seen all this evidence? To me,
right.
Like, that's just like, you see all this stuff and you're saying with all that stuff that's been entered into evidence that the jury has heard, that you could say beyond a reasonable doubt there was no chance he sort of like attacked her like she said, or it's hard for me, but I know people are entitled to their opinions. But
yeah, no, people are entitled, like, and so are we. In my opinion, is that this guy was abusing the hell out of her psychologically, and that he was a really scary guy. From like even the cruise texts are just weird. It's like,
yeah,
talking about
yeah,
fueled murderous rage, and he's a jealous dude. You can sense it immediately. Super jealous. She's way younger. She's attractive. He's in his 50s. Like when you start getting older as a man, your confidence wanes a bit. He's a fit dude. He looked like he was roided out. Like, to me, frankly, the one picture I've seen with him with his shirt off, dude, looked like a roid monster. But, to me, to expect anybody that has lived with that and knows what he's capable of and is probably thought about what beyond what he's capable of in terms of when he loses control completely, I just don't think I think it was reasonable. I think it was reasonable to think that this time, like when things were really coming to a head, that night when it seemed to have to do with how he packed the truck, because she was really upset that he had like not kept their shit separated, because her intent was, I'm going to unpack all my stuff at my place. You're going to unpack your shit at your place. And then when he commingled it all, that's when this conversation came up, and that's when he started getting progressively more and more angry, and I don't know how you're supposed to be able to decide, when this guy is going to lose his mind and kill you. The dude shot a gun into a ceiling in her presence. I'm just telling you, you do that shit here in Illinois, you're going to jail. Like, they're going to absolutely consider that to be a crime. They're certainly going to consider it to be like they would enter in a no contact order in 2 seconds in that situation. Oh yeah, he pulled out a gun and fired it into the ceiling. Yeah, order granted. No judge is going to sit on a hearing like that and err on the side of stupidity by denying that, and then this guy turns around and kills her. Granted, an order is only a piece of paper. You know, I mean, if somebody's hell bent on killing somebody, a piece of paper that exists in this world is not going to stop that person either way, you know. But the reality is that this situation for me, there's no way that they've convinced me. And I see, like, I've seen people on Twitter, I've seen people in here talking about their stuff that they haven't let in. Well, if they didn't let it into court, that means that it's inadmissible for a reason, and it doesn't matter. All I can do is judge upon what the evidence presented was, and that's what I base my decision on. And so, like, I could really care less what else existed beyond what was in evidence. You know, I mean, I know that there were things that they wanted to get in, the defense wanted to get in as well, that was not admissible. So, I mean, that goes both ways. But yeah, I don't know, man. NG for me. I don't think there's going to be anything they're going to be able to do on rebuttal that's going to convince me otherwise. But so yeah, tomorrow, y'all, we're back over at Jay's house. Jay's throwing the party. He will have plenty of snacks. He'll have lots of UCC coffee. The dogs will be there to snuggle with you if you're feeling a little out of sorts. Allie, I'm sure, will be hanging for a majority of the day. I will be knee deep in Delphi. I assume that I'll be doing a live tomorrow night to give you guys updates. And remember, there's no phone usage in the courtroom. So, and they're crazy about it there. So there's no live tweeting. I can't do any of that stuff in that courtroom. It's like lunch break will be the first that you'll hear from me at all. Unless, of course, she doesn't let me in the courtroom. So, but I just can't see that happening. That would be insane. So
let me ask you this, Bob. So people just have a time. Would you assume 5 Central would be about when you think court will be done for that? Like, just so people have an idea when you may.
I think so it's set for 3 days. So I think she'll probably end court around 4:30
Central
each day, you know, depending on how much they're getting done. I think there's like 10 pending motions they're going through over these 3 days. It's like that Karen Reed day where they had all those motions, but some of these are heavy duty, you know, litigation motions where there's going to be witnesses coming in to testify. So I've been looking forward to this day for a long time in terms of the defense kind of being able to get their say and get some of this in front of the judge to see how she rules on certain things. But should be a big few days. Obviously, I'll be popping in on you all, and I'll definitely be checking my phone at lunch. But you know,
yeah, and I can obviously, as if court is still going, I'll obviously let you guys know. Bob will let me know if he, you know. So we'll keep you updated. Just make sure you're subscribed. Obviously, have your notifications on, so you know.
Yep. All right, y'all. Mods, thank you once again for being the best in the business. We adore you. We adore you. Thank you for everybody that was so generous to both Jay and I during the course of the day. We always really, really appreciate that. It's how we pay our bills. So you guys are the heroes of the story always. And thanks once again for being the best chat in the land. There's no doubt about that. Put you guys up against any chat out there. And we're going to come out on top every single time. So, Jay, I love you, man.
Love you, dude. Good luck tomorrow.
Appreciate that. And you guys, we love you. And we'll see you tomorrow. All right.
Bye, everybody.
Ciao.
Nation, please give all of yourselves an ovation. No, it won't be real long until next time. OJ Bo Nation, there's no place we'd rather be. J-Bo J-Bo Nation is the place to be. J-Bo Nation is the place to be. J-Bo Nation is the place to be.